Good morning and welcome to the continued special meeting of the San Francisco Ethics Commission relating to the official misconduct charges against Sheriff Mirkarimi. We have a lot to do today, and so I wanted to start by going over my proposed schedule for how we'll proceed. We'd first like to hear the closing arguments from the attorneys. From the mayor's side, have you decided whether you want, how much you want to use up front and how much you want to use, if any, in rebuttal?
We'll have 40 minutes up front, 5 minutes for rebuttal.
Okay. During the course of these arguments, I suspect that the commissioners will have questions for you, and so expect to be interrupted. This is obviously for us, and so that we can get a good handle on what your positions are and any final questions we may have. Our questions come out of your time, so don't expect more than 45 minutes just because we're spending some of it asking you questions. After that, we'd like to take public comment on this agenda item. Public comment will be strictly limited to 2 minutes per person. I know there are a lot of people who would like to give public comment, and we look forward to those comments. Because of the volume, though, we are going to have to limit it to 2 minutes, and I'm going to instruct the staff to turn off the microphones after 2 minutes. I'll explain this again right before we do public comment, but you will get a warning beep when you have, I believe, 30 seconds, which will allow you to wrap up your comments. After that, I intend to take a lunch break, following which we will deliberate. The Commission will address the factual and legal issues that have been put before us, and hopefully we will come out with a recommendation for the board at the conclusion of today. In addition to the oral findings, we should discuss whether we want to have some written findings. I think one idea is for the attorney for the commission, Mr. Embledge, to write a summary opinion of what our findings are at the end of today, and then for us to either adopt that as a summary in advance or to meet again to officially adopt the written summary of our oral findings today. But I would expect any write-up would merely be a summary of what we've already found, not any sort of new bases for our findings. So those are the things I hope to address. And before we start with attorney argument, let me take the roll. Commissioner Studley?
Here.
Commissioner Liu?
Here. Commissioner
Hayon? Here. Commissioner Rennie?
Here.
All commissioners are here. And so let's begin with the mayor.
Good morning, commissioners. I have prepared a closing argument in anticipation of not being interrupted, but I understand that things change and we have a compressed amount of time, so I will do my best to cover all the main points and answer your questions as well. So let me proceed. On March 19th, 2012, the City and County of San Francisco and the Sheriff's Department faced an intolerable situation. Sheriff Mirkarimi had just been convicted of a crime. He'd just been sentenced to 3 years of probation out of his 4-year term of office. And the nature of his crime was troubling. He was convicted of a crime of false imprisonment, while at the same time having the responsibility to lawfully imprison the prisoners in county jail. Moreover, it was a crime of domestic violence. It was a crime involving the violation of trust in the marital relationship, and any crime involving a violation of trust raises serious questions about whether an individual can carry out the trust that comes with public office. Faced with these facts, the mayor acted. The mayor asked the sheriff to resign. He did not. The mayor therefore filed these charges And that ultimately brought us to today. Now, under the law, before the Commission, the official misconduct provision in our charter, and the case law of the California Supreme Court that interprets similar provisions under other state laws, under the evidence that's been presented to this Commission, under the common sense and wisdom of the commissioners, and for what is right for the Sheriff's Department and for our city, we ask you to recommend sustaining these charges to the Board of Supervisors. Now, the Commission has received a great deal of evidence in this case. Most of it has come from the mayor, and most of it has been unchallenged. The mayor presented 9 witnesses through written testimony and exhibits. The sheriff exercised his right to cross-examine only 2 of them. Most of the evidence in this case concerns what the sheriff of the city and county of San Francisco is expected to do and what Ross Mirkarimi did instead. The facts are not very difficult to understand in this case, and I'm going to go over them in a moment. But first, I want to address the law that the Commission is going to have to apply and address the specific questions that the Commission asked the parties to address in the briefing about interpreting our official misconduct provision in the Charter. Now, the legal basis for removal is met here. The sheriff seems to argue that even if I acted wrongfully and terribly under the law, a technicality permits me to continue in office. That is not the case. Now, I've prepared for the Commission something akin to the jury instructions you might have in a civil trial. And if I could ask my counsel to provide this to the other side, I'll pass up a copy to the Commission.
You may want to zoom in on that a little bit if you can, Mr. Keith. Thank you.
Now, what this document is, it's the first sentence of our charter official misconduct provision. And Commissioner Hurd presented option 1 and option 2 at the last hearing, and this is very close to option 2. And the big question, I guess, that this way of setting out our definition of official misconduct answers is, does the official misconduct have to have a relation to the duties of office? It does. But the dispute here isn't about that. It's about what is that relationship, and that's really what the sheriff's legal arguments seem to hinge on, is what that relationship has to be. The sheriff claims it's not there, but it is.
Counsel, isn't your reading of option 2 really too restrictive of what, it may make no difference in this case, but as I read it, it is talking in the disjunctive. First talks about misconduct relating to the office itself. The second is a much more broadly worded. This is conduct that falls below the standard of decency, good faith, and right action impliedly required of all public officers. There's nothing in that section, that clause, that says the misconduct has to relate to the office. For example, you would agree, would you not, that if, say, a member of the Board of Supervisors became aware that another member was engaged in child molestation, which clearly has no relationship to his office, but chose not to disclose it and to cover it up, that would constitute a violation of the Official Misconduct Act?
You know, that is an issue that I'm glad is not before us today, because that presents a very troubling question. We have serious misconduct that certainly reflects on the moral and ethical judgment of an officer, and then whether another officer then has a duty to report that to the city. I think that there's arguably a duty implied under law based on the trust that that individual holds toward the city to maintain the standards of conduct of the body. So I think the reason why that seems like such a difficult hypothetical to us is because it's hard to say, well, a supervisor has this as a job, but if you look at the trust that a supervisor has to hold, that's part of what a supervisor is supposed to do. So I think that even these situations like that, they do nevertheless relate to the duties of office. And in this particular case, it would seem to relate to the trust that that supervisor holds for office. I mean, I think, in this case, we have a nexus certainly between the fact that the misconduct is a crime, and of course the sheriff is in law enforcement. The misconduct has consequences that are related to law enforcement. So it's not a tough question whether the relationship test is met here, whether the official misconduct provision would capture all of the sort of reprehensible conduct that we think that our officials shouldn't be engaged in. That's a question perhaps for amendment.
But isn't it a fair reading of that the drafters were focusing on two things? One is performance in office and doing some misconduct relating to that. And the other is some overarching ethical code that any public official ought to abide by. Isn't that what they were concerned about?
Well, I think that the greater includes the lesser. The duties of office includes that ethical code. And part of the duties of office and the relation to the duties of office is maintaining that ethical standard. And I think that that's something that a person could look at the main clause and say, well, what's wrongful behavior by a public officer? It's not upholding what we expect of a particular officer. And then the use of the word including tells us that that definition includes things like conduct that falls below the decency standard. It's not limited to that, nor is it limited to a failure to take action to perform a mandatory duty. It's any wrongful behavior in relation to the duties of office, including these things.
And you may be going to get to this a little further on, but do you agree that it's sort of a two-step process that we have to deal with? One is, was it official misconduct? And two, did the mayor act reasonably in exercising his discretion?
I think the question, well, I think that really goes to the question of, is there a minimum level of wrongful behavior that we have to have? For example, jaywalking. That's wrongful, but does that mean an elected official should be removed? That's a tough question about if it's doubtful that the people who wrote the charter intended that. And fundamentally, we have a decision that the Board of Supervisors has to make about essentially knowing the consequence of sustaining the finding is that the sheriff will be removed. Is that a consequence that they think is appropriate for this? So I think there is a determination of, are the consequences appropriate for the wrongful conduct? And the conduct here, in this case, is so wrongful that there's no question that that consequence is appropriate.
But you agree that it's a two-step analysis. One is, if we were to find that there was no official misconduct, that would be sort of the end of our hearing and our recommendation to the board saying we find that it wasn't official misconduct. Or we may say, yes, it was official misconduct, but we think removal from office was a unreasonable exercise of discretion. Isn't that a two-step analysis?
I don't think we're really looking at the mayor's exercise of discretion. I think we're thinking, does the conduct here in fact warrant removal? And in fact, that's one of the things under a separate section of the official misconduct provision that deals with felony crimes involving moral turpitude. What's mandatory when that happens, when an official commits a felony crime of moral turpitude, is the mayor must remove. The mayor has no discretion. But nevertheless, it goes to this body to then decide, does that offense warrant removal? So there is a judgment being made, I think, about the severity of the conduct and whether that's considered to be part of the initial misconduct analysis or a separate analysis. One could discuss, but certainly the severity, I think, does matter. But here, I don't think the Commission needs to grapple with the question because the conduct is so severe.
Mr. Keith, but you would agree that we can decide that it's official misconduct, but make whatever recommendation of the board we think is correct. If we think removal is too significant of a penalty for the act, do you agree it's within our discretion to make a recommendation to the board that he not be removed from office?
I think that this body's recommendation to the board does embody a judgment about whether or not the sheriff should be removed. So yes, I think that this commission could theoretically find that there is some level of misconduct that meets the definition, but nevertheless doesn't warrant removal. I think that treating that as I don't know how sensible it is to treat that as a two-part analysis, but I think that, because I think that the idea of what is wrongful conduct in relation to the duties of office, I think that suggests that we're measuring the severity of the conduct. So I think it's difficult. I think that we're complicating the task too much to say that, well, we have to figure out whether the basic legal elements are met and then make a separate determination about the severity.
And I do want to go back briefly to the point that Commissioner Rennie was raising. I think what he was suggesting in the interpretation of the charter, it was more akin to option one. And I understand your view of option one is that it would be unconstitutionally vague.
Well, it's not that it would be unconstitutional, but I think, yes, that interpretation probably would not give sufficient notice of the conduct that's prohibited. On the other hand, the interpretation that saves it is, well, you measure that conduct by reference to the standards of that particular office. And the rule is that interpretation always saves the statute. So that's how these general good conduct provisions are interpreted.
But as far as your position is that what you've helpfully labeled the conduct clause must relate to the duties of office, that you don't think we should interpret the charter provision, the conduct clause of the charter provision to not have to be in relation to the duties of office, right? You believe there must be some connection.
Right, of course, but with the proviso that test is not difficult to meet and it is very broad.
Sure, I understand that you have differences in how strict you think it has to be, but
yes.
Okay.
So now the sheriff basically says that this relationship test that we've just been discussing is, well, the charter must have a provision that says the sheriff cannot commit a crime. It's there. He says there's the 5 duties in the charter. It's not here. Therefore, it's not official misconduct. Well, that argument doesn't make any sense. I don't think that anybody would think that the charter meant to allow someone, an official, to do anything on the job, no matter how wrongful, that if it wasn't spelled out as a particular duty in a statute that you couldn't violate, wouldn't give rise to official misconduct. That doesn't make any sense. When we talk about wrongful behavior, and again, we look at the cases and what they talk about with regard to this relationship test. The California Supreme Court said in the Cranston case, dealing with a police officer who engaged in reckless driving while off duty, it upheld the termination of that officer, and it said, the public has a right to expect police officers to obey the laws, whether they are on duty or off duty. When police officers violate the laws which they were hired to enforce, they do so at their own peril. The relationship existed there, and that's the same relationship here. So this test, though it does apply to the conduct clause, is fully satisfied here. And I think that it's conceivable that there are situations where there could be terrible conduct, where it could be a much harder question. This is not one of them.
Let me ask you about Cranston. I mean, Cranston talks about that the specificity may be provided by the common knowledge and understanding of a particular vocation or profession. And so you're using that to suggest that the particular vocation we should have in mind are sheriffs or law enforcement officials. Do I have that right?
Yes.
But when I'm looking at the actual charter provision, I mean, the language to me is pretty clear. Falls below the standard. If the people intended multiple standards, I think they would have understood to use the plural, standards. So I think it's one standard of decency, good faith, and right action impliedly required of all public officers, so that I think the vocation that we need to evaluate are not sheriffs or law enforcement, but public officers. Now, we haven't heard a lot of testimony or expert testimony about what the standard is for public officers, but presuming that there is one, that seems to be the standard we need to apply, not the standard that applies to police officers.
Well, I mean, let me respond to that in two ways. First of all, it's a question of what all means. Does it mean each, or does it mean every? Does it mean that every official is subject to the standard that they should be meeting, or does it mean that they're all subject to the same standard? It's not clear.
But isn't
under
it
the
more about
statute.
whether it's standard or standards? I mean, if they intended multiple standards, why wouldn't they use the plural?
In similar provisions, say provisions that govern the conduct of all state employees, that similar language is used regardless of the fact that you can have state employees who are corrections officers or lawyers or park rangers or maintenance folks. The same standard is used and it applies to all of them. And similar language like this is used in those statutes. And nevertheless, the courts interpret it to mean it's what applies to that particular office because that's what makes sense. And then the other issue here is that the lowest standard of decency is one of the standards that the Commission will apply, and that's why the use of the word including in this provision is so important. Including means here are some examples. It doesn't mean that it is limited to this. So when we talk about wrongful behavior by a public officer in relation to the duties of his or her office, that encompasses the professional standard. So we still have a professional standard that applies to the person in the office, and we also have, we want to make clear that there is also a baseline standard of decency that applies. Courts have said that baseline standard in any case has to be interpreted in relation to the office, but it's a separate provision. This is a larger general definition that includes these things as examples. I think when the voters enacted this, they envisioned that, gee, there probably is a standard of decency that has to be met by everybody who's in public office. So we want to make sure that's in there. But as a practical matter, meeting that professional standard, that's one of the basic duties. If you didn't have the word including here and all the text that follows it, we would then this idea of meeting the professional standard would still be embodied in the general definition. These are just illustrations, so these are really two different standards that could apply, though as a practical matter and as a constitutional matter, we apply the standard of the profession from that second clause.
Okay, so you think that everything after the first including are mere examples of what could constitute wrongful behavior by a public officer in relation to their duties.
I don't want to say mere, I'd say non-exhaustive. Here are some things that we want to make clear to the extent that there's any potential for ambiguity as to what this general definition could mean under these particular circumstances that we could foresee coming. You know, we want to make that clear. So I think these are illustrative examples. And I think there's also, I mean, our brief explains this in greater detail about why we think this makes sense. I want to talk about one of the other legal arguments that the sheriff makes, and this relates to the timing of the misconduct. And I think that we can look again at the definition of official misconduct and break it down into elements. So let me pass along to the Commission another sort of jury instruction type of document, which breaks down official misconduct into its elements.
Thank you.
All right. So what we're doing here is taking the general definition of official misconduct that's at the beginning of the first sentence of our definition of official misconduct in the Charter, and we break it down into the four elements of official misconduct. Now, the sheriff has made an argument that because he committed his misconduct a week before, or initiated his misconduct a week before his inauguration, that doesn't count. Well, our response to that is simple. It may have been a week before the inauguration, but it was 2 months after the election, and that's what is significant. And the definition of official misconduct answers the sheriff's claim. It says official misconduct means any wrongful behavior, and then the second element, by a public officer. Now, there's no statement in the Charter about what this definition of a public officer means, but there's no reason to restrict who a public officer is and say, well, it's somebody, it includes elected officials, but only after they're sworn in. And the reason for this is the very purpose of the official misconduct provision. The official misconduct provision is meant to deal with wrongdoing that comes up after The voters have voted or after an official is appointed to their position. When the voters went to the polls in November 2011 and they marked their ballots, they did not say, I am casting a vote for a sheriff who has committed domestic violence and will be on probation for 3 of the 4 years in office. These are facts that were unknown to the voters. They came to light after the election, and it's the very situation that official misconduct provisions, both in our city and elsewhere, are meant to deal with.
Well, counsel, it may well be that the second portion of it deals with that question. But the first portion, I don't know how you can read it other than it says, official misconduct means any wrongful behavior by a public officer in relation to the duties of his or her office. So that the first paragraph clearly says whatever that wrongful misconduct was, it has to be in relation to his duties to which he was elected. So that if he hasn't taken office, he may have been elected, but if he hasn't taken office, how can he be guilty of violating that first section?
Well, let's think about the type of misconduct that could be captured here in relation to the duties of office. A person can be about to take office, and they could abuse the power of the office they're about to take by making a threat about what they will use that power for after they take the office. A person can engage in wrongful behavior shortly before taking an office that casts disrepute and discredit on that office as the consequences of that wrongful behavior unfold. And an official that's between election and inauguration can be busy preparing to take that office. And that's why government ethics laws that do define who a public official is define a public official to include, and this is from the California Political Reform Act, this is cited in our brief, Gov Code 82020, defines an elected officer as, quote, any person who holds an elective office or has been elected to an elective office but has not yet taken office, end quote. And this provision is cited in our brief.
How can an act of domestic violence be transferred into saying that is a misconduct in relation to his office? It may well be a violation of the second clause, but how can it be an act that's in relation to the duties of the office to which he's elected?
Because his own conviction impairs the ability of his department.
Convicted at that point.
Well, there is a special rule, and there are some jurisdictions that say you can't take misconduct from a prior term, meaning actually you can't take misconduct that occurred before an election and then charge it afterwards. But even those jurisdictions have a principle that when someone is convicted of a crime, it's the date of the conviction that matters, and we look at that conduct. And again, the reason for that principle, well, there's two of them. One of them is the goal here is to protect the office and protect the public. And so having a rule that when you actually have something as serious as a conviction of a crime that occurs where the conviction occurs during the term protects that office. The second reason is because the actual conviction is conclusive evidence that the conduct occurred. Things can be up in the air, things can be unknown, things can be hidden. But this conviction makes it conclusive evidence, and that's exactly what we saw here. The mayor let the criminal process take its course, and when the conviction happened and the sentence happened, he acted because he had conclusive evidence that this misconduct had occurred. And so in the specific situation of crimes, even the jurisdictions that have a rule that say you can't do that, they say there is an exception for a crime. And I'm not aware of any case in which someone said that when you're convicted of a crime during a term, but it happened before the term, you're off the hook. And it's the similar rule in probation violations because, again, the rule is, did the threat to the public, come to light during the term that the person is being subject to scrutiny? And in this case, it did.
Commissioner Sedley?
As we're drilling down on the words, the phrase that's used here is in relation to the duties. When it might have said instead during the conduct of or in carrying out the duties, which would have made our job clearer to know about the timing. Do you think that the fact that it says in relation to as opposed to a more specific wrongful behavior in carrying out the duties of the office would have set a higher and different kind of standard.
Well, I think it does, and there are official misconduct provisions that do. The statewide government code provision that outlines the type of official misconduct that's prosecuted through a grand jury is narrower, and there's a case that we cited called People v. Mullen involving a sheriff in which an incident of child molestation came to light for the sheriff, and he didn't pursue an investigation, and moreover, he didn't refer it to any other agency. And the court said, well, the job of the sheriff is to detect wrongdoing, and he didn't do anything. And this was something that met that more closely related test under the government code. I think when the voters did this, I mean, they also said we're looking at wrongful behavior, not unlawful behavior. So they meant this to be broader, and I think including provisions like the decency clause showed that the voters wanted this to be a broad provision so that we could hold our elected officials to a higher standard, including being able to deal with situations like this where you have conduct that relates to the duties of office and clearly bears on the effectiveness of that office and how well that office is going to function, where you have consequences that are going forward. They wanted to be able to capture that, and I think that this language does. Now, I think that our brief discusses the difference between wrongful behavior and unlawful behavior closely enough and what that signified, so I'm not going to dwell further on these elements. What I want to do is turn to the relationship test and talk about how that relationship test is satisfied here.
Mr. Keith, may I interrupt you? Going back to the definition, your handout on the broad definition where you broke it down into inaction, conduct, and conflicts clause. So are you reading the charter to say, when you look at the conduct clause, conduct that falls below the standard of decency, good faith, and right action impliedly required of all public officers in relation to the duties of his or her office? Would that be the way you're interpreting it, if that's the standard that we're supposed to apply today?
I think it has to be. I mean, I think that the use of the word including, followed by illustrative examples, tells us that that what comes before is the general definition that has the elements that need to be met in every case. And again, I think the dispute here is on what exactly that relationship has to be.
Okay, thank you.
And you're only alleging a violation of the conduct clause?
No, we're alleging a violation of the general definition here. I mean, I think some of the conduct here, all of the conduct that's alleged violates the general definition. Some of it also violates some of the other illustrative clauses here. But what we've been focusing on is that general definition.
Okay, but you're not making an allegation that he violated the inaction clause, right?
I think some of the conduct related to the investigation could fall under that category, but doesn't necessarily, and that really depends on the facts as this commission sees it. Basically, if this commission concludes, based on the evidence, that the sheriff initiated the contact between his campaign manager and his wife, and he took that action as part of his course of conduct to keep his wife from going to the police, then he's responsible for all the consequences that came to that, all the consequences that came from him bringing in his campaign manager to clean up this mess, in which case he's responsible for the actions that she took later that afternoon, with regard to the conversations with Ivory Madison, with regard to the ongoing efforts, working with Ms. Lopez to try and stop this police investigation if he initiated it. If, on the other hand, the commission were to find that the sheriff didn't initiate that contact, but nevertheless found out about these efforts to dissuade Ms. Madison and Mr. Mertens that were going on that day, then I think the inaction clause would come into play. Because and I think under the principles of that case, People v. Mullen. But other than that, I don't think the inaction clause comes into play, because I think we have affirmative acts taken by the sheriff which are wrongful, which is a different type of thing than just simply not acting when something comes to light.
And you're not making an allegation under the conflicts clause, right?
Well, I think that with regard to the sheriff's threat to use his power, that does certainly violate specific conflict of interest laws by the city, but there's also no question that that's wrongful behavior in relation to the duties of office, so I don't think we need to dwell too much.
Have you identified to us a conflicts of interest law that he violated?
Yes, it's identified in our brief. He violated 3.218A of the Campaign and Governmental Conduct Code. that provision says you can't violate any provision of a statement of incompatible activities, and the sheriff's statement of incompatible activities, like every statement of incompatible activities in the city, states, and as every statement of incompatible activities is required to state, he used the prestige or power of his office for a private end. That's the violation there. But again, these clauses are illustrative. I don't think we need this clause to know that that kind of conduct constitutes wrongful conduct in relation to the duties of office. But in this case, that clause is also met.
Would it be your position, if it wasn't the position of sheriff, if the public official who had been suspended by the mayor was, say, a supervisor, and he or she performed the same acts that you allege were performed by the sheriff or the sheriff's people to try and close off the investigation, that wouldn't be a violation because the supervisor doesn't have any responsibility insofar as criminal investigations?
I think that if we had a situation where where say the person wasn't initiating the contact, but say it came to light to them after the fact that these people were working on his behalf to cover up his crime, I think there's an argument that under that circumstance, the person, as much as we would want them to take action, may not be under an obligation to.
That's the way you read the statute?
I think that with regard to specifically the inaction clause, we read it that way. It's another question whether that conduct might be reached by the decency clause and just the general baseline level of conduct that we would expect.
Mr. Keith, sometime today, can you show me, and I may have just missed it, where in your amended charges you rely on the conflicts clause as a basis for sustaining official misconduct?
We don't separately state it. We simply state that it's wrongful behavior in relation to the duties of office. We think it also happens to meet that illustration, but again, our concern is that it meets the definition to begin with, and we think it falls within there. It's not separately alleged. We do certainly allege that using the power of your office in a custody dispute is wrongful behavior in relation to the duties of office. We don't parse the statute down to that example, down to that illustrative clause.
Okay.
Now,
Mr. Keith,
yeah.
when you discuss the evidence, can you discuss the evidence you think supports the general clause and then the evidence that you think supports the conduct clause under your interpretation?
I think that what it really is, it's applying two different legal principles to the same sets of facts. So I think actually at the very end of our brief, we do address the idea of what baseline standards that this conduct might violate. And I think that the argument is, well, committing domestic violence is certainly not something we're willing to tolerate from a sheriff. And there is certainly an absolutely crystal clear relationship with the duties of office with regard to law enforcement when it comes to domestic violence. On the other hand, from a supervisor alone, I don't think that the voters of San Francisco contemplated that that standard of decency would permit domestic violence by any official in the city and county of San Francisco. So I think that that would be an example of where it meets both clauses. And I think we get into more difficult territory when we're talking about that baseline standard, but we don't have to go there to complete the task that we have, because with regard to the duties of sheriff, it's clear and the evidence supports it, and I don't think anybody could dispute that there's a relationship there.
Okay, thank you.
Now, I'll do my best to do some highlights of the evidence here. Now, we have the heart of these charges has always been the sheriff's crime and his conviction and his sentence for those charges and the consequences of that for his office. We also have a course of conduct that followed that included acts of witness dissuasion, threats, and I should say not just followed, but conduct that was wrapped up in that, threats to use his official power in a custody dispute, witness dissuasion, and then various actions that during the criminal process that were either deceitful or abused his trust or didn't comport with his responsibilities for law enforcement. But the heart of the charges has always been the domestic violence.
Can I make a suggestion when you talk about the evidence? I at least don't need to hear your evidence for the physical abuse. It would be helpful for me if you would point me specifically to the non-hearsay evidence of witness dissuasion in particular, and also the evidence, the specific non-hearsay evidence of using his official powers to try to obtain custody of his child. So those are, and then I guess thirdly, the evidence that his statements to the police were willfully, what was the term you used? Willfully misleading. I mean, I want to know what the evidence is that shows that, I for one, credit Inspector Daniele that the sheriff said that to him. I want to know what evidence you have that that was an affirmative lie, that he knew he had the gun, but that he didn't turn it over. So those are sort of, for me, the three areas that would be helpful to be pointed to specific non-hearsay evidence.
I neglected to start my stopwatch, so I don't know how much time I have left, but I will do my best to
I
cover
have
those
you
things.
at 32 minutes.
We're 32 minutes in.
Yeah.
Then I better move quickly. All right. With regard to the non-hearsay evidence of the threat, we have the video, of course, which is in. And then we have the contemporaneous statements to Ivory Madison, which are also in. We have the statement of Callie Williams, which, when it came in, was a statement of Ms. Lopez's, I guess we'll say when it came in it was hearsay, but Ms. Lopez has since testified. So now it's not hearsay anymore, it's a prior inconsistent statement. So all three of Ms. Lopez's contemporaneous statements are not hearsay. So to the extent that we're concerned about a hearsay problem.
Where in the record does Ms. Lopez say, the sheriff told me that he can take away my son because he is the sheriff and he's got that authority, or something to that effect?
Ms. Lopez never testified to that. She testified to the opposite, which is what made those other statements admissible. Callie Williams reports that threat that Ms. Lopez made about using the power of office, and likewise Ms. Madison reports it. It's in their written declarations, and and as well as it's in the video, that he said he's very powerful and he can do it, immediately after saying that she's doing this because he said he can take away Theo, and he said he's very powerful and he can do it.
So it's your position is that by saying he's powerful, that implies his power is because he's an elected official, and therefore we should decide that he used that power to use the power of his office to try to take custody of his child, or exert force over his. I'm sorry. Or exert force over his wife.
That's what Ms. Lopez said she understood it as. She sent that.
Okay, where's that testimony?
Well, there's two things. One is a text message she sent on January 4th that said, use your power. She was asked during the hearing, what does that mean? She says it's your power because you've just become sheriff and you're a supervisor. That's in her testimony. So she understood his power to mean that. And of course, that's circumstantial evidence of what she probably meant when she was saying, he said he's very powerful in the video, and to Ms. Williams and to Ms. Madison. And those sections are cited in our support for the proposed findings of fact.
Yeah, you cited a lot, though, and I looked at a lot of it, but I'm okay.
And I'm happy, to give specific page line references after I have a chance to sit down and look at the testimony.
Okay, thank you.
Now, I know that there was another question about why we should believe that Sheriff Mirkarimi was being deceitful with regard to the weapons. Now, recall what the sheriff said. The sheriff was confronted with an EPO that required him to turn over his weapons. The police officers have said, or I should say Inspector Daniele has said, the agreement that we made was that his attorney would call us, meaning me and my partner, Inspector Becker, the next day to turn over the weapons. Now, they went to Sheriff Mirkarimi. They said, we see you have 3 weapons. Sheriff Mirkarimi said, oh, you know what? I have 2 of those 3 weapons, but that 3rd weapon, I sold it in 1996 to a recruit at the police academy. And what was Sheriff Mirkarimi's explanation for that? He said he was thinking out loud. He didn't know where the weapon was, and he wanted to be helpful. Well, if a person doesn't know where his weapon is and he's confronted with an order that says, give me your weapon, give me all your weapons, this is required, he's going to say, I don't know where it is. He's not going to say, I disposed of it on this date and in this way to this person in this transaction, to give details about how this transaction supposedly happened. It's not credible. Now,
But but the guns get turned over all at the same time.
they do, but the process for how the guns get turned over also show us that Sheriff Mirkarimi's account of what that agreement was not credible.
Okay, but even if it wasn't, even if he said the words that Inspector Daniele says that he said, what's the motive there to lie about selling the guns 15 years ago if they end up all being in the same place and they all get turned over together? I mean, what was he trying? I mean, are you trying to make some allegation that he was trying to keep the gun, that one gun from the police so that he could have it for himself? I mean, what's the there?
I think Sheriff Mirkarimi was confronted with this order, didn't like the idea of having to turn over his firearms. I mean, I don't think anybody likes the idea of having to turn over what they have. And he made a stupid decision that he shouldn't have made. And he decided that well, I've been confronted with this. I don't want to give these to the San Francisco Police Department. I'm suspicious of them. They have, I don't have a great relationship with them. I want to keep the weapons under my control. I'm not saying the decision was rational, but it's understandable that somebody who doesn't want to turn over his weapons and is suspicious of the agency that he's turning them over to could make that decision. So that would be the motive, is that he simply doesn't want these weapons to be in the hands of the police department. And to me or to you, that may not seem like a very good motive or a very good choice to make, but I don't think it was a very good motive or a very good choice for him to make, but he nevertheless did it. There's no explanation for why somebody would essentially make up stories about selling a weapon when they could simply say, I just don't know where it is.
How about, do you make anything of giving the guns to the sheriff's department instead of the police department, and then let's not forget the witness dissuasion? Right.
Well, the giving of the weapons to the sheriff's department rather than the police department. So, again, I think we're looking at the same motive here. I don't want to give, I definitely don't want to give up my guns. And okay, well, maybe I'm going to have to give them up because I don't want to out and out violate a court order, but I still don't want to give these weapons to the San Francisco Police Department. I want to keep them in my agency. And again, this doesn't seem like a very sensible thing to do, but there are a lot of things that Sheriff Mirkarimi did in this course that isn't a very sensible thing to do. And I think if you look at what his testimony was at the hearing to explain this, you're going to find that that testimony was not credible, and it's rebutted by the actions that the people took following the agreement that Sheriff Mirkarimi described. Sheriff Mirkarimi said, said that the agreement was, well, the agreement was my lawyer was going to give the weapons to the sheriff's department, and the sheriff's department was going to give them to the police department. That was his testimony before this commission about what the agreement was. Well, what happened next? We know from Inspector Daniele's declaration that the next day, when he spoke on the phone with Captain Gorwood from the sheriff's department, she didn't have any idea that was a plan. He offered to come over and get the weapons. She said, no, we'll take care of it. So this is a plan that Sheriff Mirkarimi has supposedly made, but he sends over a member of his staff and doesn't inform her of that plan, because certainly if she'd known that were the plan, she would have given the weapons to her counterparts at the police department. But then the next thing that happened conclusively disproves Sheriff Mirkarimi's testimony at the hearing, and that is this. There was a court date the following week where Sheriff Mirkarimi's attorney, of course, was present, the same attorney who was present when Sheriff Mirkarimi was served with the order and when this agreement was allegedly made. The district attorney asked the judge to issue an order to the sheriff's department telling the sheriff's department to turn over the weapons to the police department. Now, if the plan was as Sheriff Mirkarimi described, his attorney would have said, okay, that's the plan. But his attorney didn't do that. His attorney objected. He tried to stop that order from getting issued. So the explanation that Sheriff Mirkarimi gave of that agreement to this commission is not credible. It's disproven by the actions of the staff who are supposedly part of this agreement and by his own attorney who was present when this discussion was had. So I think the commission can conclude from that Sheriff Mirkarimi's testimony in relation to this gun issue is simply not credible. and that lack of credibility with regard to the guns is related to the same poor judgment and poor decision-making that led him to take these deceitful actions in the first place with regard to his guns. And then the last thing I would want the Commission to see about why this all matters. We submitted, and it's in evidence, a transcript of this particular hearing where the judge explained that in a domestic violence case, especially one involving the sheriff, things need to be done by the book, and those weapons have to be with the police department. They should not be with the sheriff's department. Its Superior Court judge recognized that it's not enough for the sheriff himself to turn the weapons over to his own agency, and she issued that order. So that's also evidence that the Commission can look at about why this matters. It's the sheriff not doing things by the book. It's the sheriff thinking that the rules don't apply to him, and it's the sheriff using his own staff to try and keep his guns out of the rightful hands where they should be. For whatever motive that he had, it was an improper motive, but he did it. Now, I want to talk about the witness dissuasion. If Commissioner Herb, you could remind me of what your questions were on that point so I can cover that.
So first, who did he dissuade? I mean, your brief mentions Ms. Lopez. It also references a lot of other testimony and evidence that we heard. But are we just talking about the efforts to dissuade Ms. Lopez, or are you alleging official misconduct based on dissuasion by the sheriff of any other individual?
Yes, we are with regard to Ms. Madison, and this is how they're different. The sheriff worked directly on Ms. Lopez. He coupled his pleas to her to not go to the police with the threat about the consequences that would follow regarding custody, and he got his campaign manager involved. This is all in the effort to try and get Ms. Lopez to not go to the police. So that's Ms. Lopez. And then the sheriff became aware of what Ms. Peralta-Haynes and what Ms. Lopez were doing on his behalf with regard to Ms. Madison and Mr. Mertens later in the day. Of course, the sheriff did not directly speak with them, but he found out about it. And we spent so much time looking at those records of what happened on January 4th, how close together, how frequent those calls were, how they were interspersed with Ms. Lopez's communications with Ms. Madison and Mr. Mertens. It's inconceivable that the sheriff didn't know what was going on and didn't act in response to what he had initiated.
So the argument is that he found out about it, told Ms. Lopez to tell Ms. Madison that she should not go to the police, that something bad's going to happen to her if she does, or that he's going to use the power of his office somehow to prevent her from going to the police or cooperating with them? I mean, with
regard to Ms. Lopez or with regard to Ms. Lopez's efforts?
Well, I'm just trying to find out. I mean, you conceded that the sheriff didn't talk to Ms. Madison.
Of course.
And the two people who apparently did are Ms. Lopez and Ms. Haynes. So for Ms. Lopez, are you alleging that the sheriff told Ms. Lopez that she should tell Ms. Madison to not talk to the police because the sheriff would use his power against Ms. Madison if Ms. Madison did so? I mean,
no, there's no allegation that the sheriff threatened to use his power against Ms. Madison. No, the basis of this sort of the latter efforts that happened on January 4th, where Ms. Lopez was essentially turned and started to work on these other witnesses, was that the sheriff knew about it and didn't do anything.
Okay,
and
so this
he
is
may very well have encouraged it, but we certainly know he knew about it
inaction.
and did nothing.
This is the inaction point, that he should have encouraged Ms. Madison to go to the police, but did nothing? Is that?
No, he should have responded to the efforts that his wife and Ms. Peralta-Haynes were making with regard to Ms. Madison, because it was interfering with an ongoing law enforcement investigation at that point.
I guess I'm just not clear what. Okay, so you're saying he should have done something that he didn't do.
Yes.
With respect to Ms. Madison. And what exactly should he have done with respect to Ms. Madison?
Number one, he should have at least tried to persuade his wife not to continue calling Ms. Madison and trying to interfere with it. He actually did the opposite.
Okay, so stop there. So he should have tried to convince his wife to stop dissuading Ms. Madison.
I'm
right.
giving an example of an effort that he should have taken. We know he did nothing.
And the fact that he didn't do that, and I think my view is that the evidence doesn't show he did that he didn't try to dissuade his wife. But you think we should find that he committed official misconduct because he didn't try to convince his wife to stop telling Ms. Madison not to call the police. That's one of the things.
Okay. But there was a text message that he sent to his wife where he told her, you have to reject Ivory's actions, we both do. So there he's even encouraging his wife to do it. So that is actually taking action. I mean, I think that his duty, I think he still had a duty to do something, but we do have an action of him encouraging his wife to do that. We also have his knowledge that it's happening. Another thing he could have done is simply called up Ms. Madison and say, you know, I understand there's a police investigation. My wife may have said some things to you about not talking to them. You should cooperate with the investigation. I have nothing to hide. That probably would have, I mean, that would be, I think, the ideal thing to do, you know, because that is, after all, was the object of those witness dissuasion efforts.
So other than Lopez and Madison, is there anyone else that you're alleging he dissuaded from going to the police or cooperating with the police?
Well, I think Mr. Mertens is wrapped up with Ms. Madison, but no, yeah.
Did you think he had an affirmative duty to tell his wife or that you ought to cooperate with the investigation?
What he, you know, oh, to tell her to cooperate with the investigation? No, I think his duty was about having her not go and try and interfere with the investigation with regard to other witnesses. She can do whatever it is that she wants, though after. Oh, I'm sorry. You know what? I think I misunderstood the question, because early on, he did make those efforts to.
I'm sorry to interrupt you, Mr. Keith. I appreciate that the public is invested in this, but it's very important that you not have outbursts, not have any comments or noises. And I'm instructing the sheriff's office right now to please, without me interrupting, if you see someone making noise, please just remove them from the room. Thank you.
I think with regard to his wife, he had an affirmative duty to not pressure her to not go to the police and to not make threats and to not enlist his campaign manager in efforts to dissuade her. I think he had those duties. Whether or not, you know, I don't think he had a duty to tell his wife, well, I committed a crime, go to the police. He didn't have a duty to do that. But I think, but that's not what happened here, so we don't have to deal with that. He actually took acts to try and prevent his wife from going to the police.
Thank you, Mr. Keith. Unless there are other questions from the commissioners, your time is up. Thank you. That's helpful.
Good morning, Commissioners. I want to begin by thanking you for your service to the City and County of San Francisco for this very unusual proceeding. This has taken an extensive amount of time on everyone's part, and I just want to thank you on behalf of myself, the Sheriff, my co-counsel, Ms. Canny, Ms. Lopez, for your careful consideration of the evidence and the law in this case. This morning, for our closing argument, I'm going to spend a few minutes talking to you about discretion and vagueness, and then I'm going to turn it over to Mr. Kopp, who is going to address official misconduct and the facts as relates to official misconduct.
Before you start, Mr. Wagner, can I make a comment as somebody who's tried cases for a lot of years and appeared before a lot of judges? You didn't do your client any favor by starting off your brief by saying, at the end of an unnecessary, protracted dog and pony show. Is that what you consider these proceedings to be?
Respectfully, Commissioner, no, absolutely not. I certainly do not consider that your
You understand we're
consideration.
mandated, once the mayor took action, we had no choice whether or not to have such a hearing, and counsel for the sheriff and counsel for the city, for the mayor, got together and said how they wanted it to be conducted.
With all due respect, Commissioner, I apologize for the use of that phrase. It certainly was not meant to describe your consideration. What this commission has been doing under its obligation under the city charter, that was solely meant to describe the mayor's presentation of evidence and the mayor's bringing of this case, which we have felt from the outset was not called for in any stretch, either under official misconduct or was a reasonable exercise of the mayor's discretion. The test for vagueness is whether or not the statute at issue, in this case 15.105, has sufficient definiteness that ordinary people could understand what conduct is prohibited. That's number one. That's the first prong of the test for vagueness. The second prong is does the manner or the language of the statute encourage arbitrary and discriminatory enforcement? And under both of those prongs, can we understand what conduct is prohibited, and does it lend itself to arbitrary and discriminatory enforcement? Under both of those, we would say that the 15.105 is unconstitutionally vague, whether we're talking about option 1 or option 2. Now, how do we tell if the application of a statute is arbitrary or discriminatory in its enforcement? Well, we look at the context, the consistency. How are other examples of alleged wrongdoing dealt with by the mayor, by the city, by other enforcement bodies? Was the mayor's suspension in this case, was it arbitrary? Was it discriminatory? Was it consistent with how this mayor has treated other cases of alleged wrongdoing by city officials? Was it consistent with how other mayors have handled similar cases? I respectfully submit to you that no, it was not consistent with how this mayor has dealt with other cases of alleged wrongdoing, and it was not consistent with how this city, how other mayors have dealt with cases of alleged wrongdoing by elected officials. This was only the third time in the history of San Francisco that a sitting mayor has suspended an elected official for alleged official misconduct. The first time was in 1932. Mayor Frank Rossi suspended the public defender, Frank Egan, for murder. Mr. Egan went on to spend 25 years in federal prison. The second time was in 2007. Mayor Gavin Newsom suspended Supervisor Ed Jew for perjury and extortion. Again, both felonies. Mr. Jew is in prison today. The third time is in the present case. Mayor Lee suspended Sheriff Mirkarimi for, according to his original press release, his plea, the sheriff's plea, to a misdemeanor violation of Penal Code Section 236, misdemeanor false imprisonment. The sheriff spent no time in jail. He was cited and released. So you have 3 very serious felonies involving very serious prison time, and then, in this case, a low-level misdemeanor and no jail time or prison time. The facts could not be more different. It's obviously extremely, very, very inconsistent to how other mayors have dealt with alleged official misconduct.
Mr. Wagner, in those other 2 cases that you're referring to, did they involve the office of the sheriff? Did they involve the sheriff himself or herself?
No. In the first case, it was a public defender. In the second case, it was a supervisor.
Thank you.
And counsel, do you agree with me that our job here is a 2-step job, and that is first to determine whether or not there was misconduct that reaches a level of official misconduct under the definition. And if we say yes, there was, we still have the question of, did the mayor exercise his discretion in a reasonable manner?
Yes, Commissioner, I absolutely agree with that 2-step process. And as to whether or not the mayor's decision to suspend was a reasonable exercise of his discretion, you've heard from opposing counsel, and it's absolutely true, in 15.105, there are instances where the mayor must suspend. It's not discretionary. If a person is convicted of a felony crime involving moral turpitude, and if this commission then determines that that's a crime that warrants removal, then that the mayor must remove from office. So that tells us right away that there may be felony crimes involving moral turpitude that would not warrant removal from office. So, however, I agree with the mayor that it is a discretionary decision. And when the mayor came before you and testified before you, he was asked very directly, well, Mr. Mayor, are there other crimes that might warrant suspension? For example, a DUI. Would that warrant suspension? And the mayor said, well, I don't know because I haven't thought about it. Well, if the mayor doesn't know what other crimes, misdemeanors, would warrant removal from office because they would constitute alleged official misconduct, then how can any official be on notice? If the mayor doesn't even know what other misdemeanors would constitute, that would warrant removal, that would warrant suspension, how can anyone be on notice? So,
Counsel, in determining whether or not the mayor exercised his discretion in a reasonable manner, can the mayor and or this commission take into account what the elected official did, what the public official did between the time that the alleged misconduct occurred and the time when he is removed from office or suspended from office?
You mean can the commission take into account the suspending authority's conduct or the removed officials?
The conduct after, in other words, that let's assume in a case that a public official commits an act which would constitute official misconduct, and between the time that he commits the act or she commits the act and when the mayor exercises his discretion, can he take into account what happened in between in regard to that public official's conduct relating to investigation, for example?
Well, I believe, yes, that the mayor can take into account. He can he or she can exercise discretion. The question is the discretion reasonable? Was it a reasonable exercise of discretion? The mayor can take into account any kind of conduct, but the question is, was it reasonable? Is it reasonable to suspend an elected official for that alleged conduct, whether it was the conduct that occurred at one point in time or how the accused official dealt with that afterwards?
Mr. Wagner, I'd appreciate your explaining in the course of your discussion of vagueness what you think our role and what the Ethics Committee's responsibility is with regard to vagueness. Some of what I'm hearing sounds to me like this belongs in a court if certain circumstances took place, and that our job is quite explicitly to assemble a record and make a recommendation. So I wonder where the vagueness argument fits in.
Thank you, Commissioner. I agree that question is a very, very important one. And in fact, you probably know that we went to Superior Court prior to this commission process getting started and made that very argument that 15.105 is unconstitutionally vague. The judge at the time said, well, let this process play out. If you don't like the result, then come back and see me, basically. And said, you know, the Ethics Commission, let the Ethics Commission make that determination, whether if they can decide whether or not it's vague or the merits of the case. So as to your recommendation and your responsibility under the Charter, I would respectfully submit that if you do find that 15.105 is unconstitutionally vague, then you cannot make a recommendation for removal. I don't see how you could do that if you find that the law itself is unconstitutional.
While this will be subject to our discussion, I don't think determining constitutionality is part of what I signed on for as a commissioner. And I don't think we have that authority. I think we have a responsibility to do something, and whether we can or cannot may go to whether it is vague. But we have to see that as we deal with the charge and the facts before us. So I'd really like to know what you think we do today that is related to this vagueness consideration, or whether you're alerting us to an argument you made pre and might make post.
Well, the Charter requires the Commission to make compile a record and make a recommendation. It doesn't say which questions of law that you may consider when in making that substantiates or that is the basis of your recommendation. So I would respectfully suggest that the Commission can take into account its own interpretation of what the law is and the facts are to make its recommendation to the Board. And if that doesn't involve a finding or a conclusion of law as to 15.105, that is certainly within the Commission's purview. I believe that if the Commission wanted to make such a finding or a conclusion of law as to 15.105, that would also be in your purview. I'd like to move on and wind up here and then turn it over to Mr. Kopp. A few other facts that we know of that I already talked about the inconsistency of the suspension in terms of San Francisco history. I would like to talk for a moment about the inconsistency of how this mayor has dealt with other alleged wrongdoing. The current Department of Public Works head was found to have committed by the city attorney's office, the current city attorney, to have committed many acts of wrongdoing. And the mayor did not suspend, did not remove from office, but rather promoted that individual against the strenuous objections, I might add, of City Attorney Dennis Herrera.
Mr. Wagner, is this anything we have in the evidence here?
Yes, it is. I've submitted it with a brief. There was a memo. I don't have the date in front of me, but it was a memo from the City Attorney's office, from Dennis Herrera's office regarding Mohammed Nuru. Beyond that, last year, this very commission recommended...
Are you standing?
I'm sorry to interrupt. That document is not in evidence. It was submitted as an attachment to an early brief. It has not been admitted before the commission.
You know, in my view, the relevance of what you're talking about is tangential at best. My recollection is similar, that it's not in evidence. This is argument. It's mostly legal, I think. So I would be permitted to allow Mr. Wagner to proceed. If there are objections from my fellow commissioners, perhaps we should discuss.
I can withdraw the comment. I think the point holds, which is that this mayor has treated this case differently than he's treated other cases. I think the public record shows that, and this evidence shows that. Beyond that, what other facts show that the mayor abused his discretion? His charges kept changing. In the original press release, he said he was suspending the mayor for a plea to misdemeanor 236. Then the charging document said it was the plea plus domestic violence plus maybe witness dissuasion. He wasn't clear on that originally in the charging document. It was maybe there might have been witness dissuasion. And then finally, the mayor's amended charges threw in the gun allegations as well. The mayor testified that he talked to Ivory Madison, but he never bothered to talk to Eliana Lopez, even after being encouraged to do so by both the sheriff and former mayor Art Agnos. The mayor admitted he suspended first and asked questions later. The mayor submitted a declaration from Ms. Madison that, in the words of Commissioner Rennie, was designed to poison the well. Finally, at the very last hearing, we requested subpoenas regarding whether the mayor's testimony was truthful. All of those facts, the charges changed, who the mayor talked to, when he talked to them, the fact that he never talked to Ms. Lopez, the questions about his credibility and truthfulness, all of that goes to whether or not he reasonably exercised his discretion. I respectfully submit to you that he did not. And if you find that he did not, then you must recommend to the board that the sheriff be reinstated. And at that, I would like to turn it over to Mr. Kopp to address the definition of official misconduct in the facts. Thank you.
Thank you, Mr. Wagner.
Good morning, Commissioners. I want to start off by addressing the point that you raised, Commissioner Rennie, about our comment about this dog and pony show. That was not intended to reflect on anything that you or any of the other commissioners have done. In fact, we appreciate the effort that you have made. That was a comment on what we view as a completely unnecessary and superfluous presentation by the mayor. So if it offended anyone, we apologize for that, but that is our view, and it is a strongly held view. We have objected throughout these proceedings to much of the evidence that they have wanted to put before you because we don't think it bears any relation to what your task is here. So that's the explanation for that line.
Well, Mr. Kopp, I will say, though, that remark struck me as being akin to the statement that was made by your client that this is a private matter.
Well,
Shows a certain amount of arrogance about the requirement to follow the law.
well, then I want to correct the record and make it clear that we understand and appreciate that the commission must carry out its duty under the charter, and we know that you've all tried to do that in a conscientious manner. Now, I do want to discuss what we think the meaning is of official misconduct, and that inevitably leads me to discuss the Mazzola case at length. One of the things that I want to say about Mazzola is that at that time in 1976, there's no doubt in my mind that Mayor Moscone and the then members of the Board of Supervisors were intelligent, conscientious public servants, and they took their jobs seriously. And I don't think anybody involved in that case or that proceeding took it lightly. And yet, they got it wrong. And now, that didn't help Mr. Mazzola. He was able to clear his name several years after the fact when the Court of Appeal reversed the removal finding, but he was already out as a commissioner. His term had expired. And I think that points out the perils of you making a recommendation for removal and later the board voting to remove, because this is a rarely brought proceeding, and it's a proceeding that can have the effect of contravening the will of the electorate. And we see this type of a proceeding and the law that governs it as completely different from many of the cases that have been cited to you by the mayor and his attorneys, some of which are from other jurisdictions, some of which are from other procedural settings. There is a major difference between cases that discuss termination of hired employees and the situation here, which is the attempted removal of an elected official. Now,
So is it your view that an elected official should not be subject to the same standards that an employee should be subject to who's in a similar position? I mean, the sheriffs, the people who work under the sheriff would be subject to the employment standards that some of these cases discuss. Why should the sheriff not be subject to those?
I'm not saying that he should not be subject to the same standards. I just don't think that you can import principles of law from other cases that deal with administrative discipline of employees. I don't see this as an administrative hearing.
But what's the legal or logical reason why we should not borrow from those cases?
Well, I think that you can look to them, you could consult them, but I don't think that they should be the primary authority here. Our contention has always been that the primary authority here is the Mazzola case because it is the only higher court decision that deals with official misconduct under the San Francisco Charter. Now, we recognize that at least one commissioner has expressed the view that maybe Mazzola doesn't apply because the charter definition changed since the Mazzola case was decided. But, as I tried to point out in the brief that we submitted, the current definition of official misconduct under the charter draws almost entirely from the language used in the Mazzola opinion. And what is the 2 points that are most critical about that opinion from our perspective are, number one, that the official misconduct has to occur while the official is in office. And much of what the mayor has alleged here occurred before the sheriff was sworn in. Now, they have presented you with a parade of horribles about why this cannot be the correct interpretation. They have said if an elected official is elected and then robs banks during that period between the election and the time he's sworn in, well, we can't have that situation. That can't be the definition of the charter. There has to be a way to address pre-swearing in testimony. Well, the fact of the matter sorry, not pre-swearing-in testimony, pre-swearing-in conduct. The fact of the matter is the charter is an imperfect document. And I would like to make the point here that if there is no removal provision for the mayor. If the mayor is elected and before he is sworn in decides to go out and rob some banks, there's nothing in the charter that will allow him to be removed for official misconduct. Okay? So this is not, I mean, the charter can be amended perhaps to plug holes in. They want to imply this pre-office holding authority to suspend, but it's not there. And the Mazzola case specifically says official misconduct is misconduct that occurs while you're in office. And that's one of the reasons why that case
Well,
is so.
Mr. Kopp, the Mazzola case, as you pointed out, this definition that we have before us now was not before the court in Mazzola. Presumably, it was written and drafted after the Mazzola decision. And you're right, the first part of it does track the Mazzola opinion. But the second part, the or, would seem to be filling in a gap that Mazzola left out, and that is, or conduct that falls below the standards of decency, good faith, and right action impliedly required of all public officers. So that one could say, reading Mazzola, what the charter drafters were concerned about is that if we limit it just to what Mazzola says, we don't get the broader coverage that we want. Is we don't want our public officials to have conduct which falls below some standard. Now, you're arguing that that standard is so vague that it can't be enforced. But isn't that the logical reading and why Mazzola doesn't control us? Because we've got language that didn't exist in Mazzola.
Well, my answer to that, there are a few ways to respond, and I'll try to best address those points. I agree that there is at least one word in the current definition that was not even mentioned in Mazzola, and that's decency. But it is our view, and I believe that the mayor has conceded that it's option 2, as proposed by the chair, that makes the most sense and that has to be applied. Now, of course, you can come to a different determination. Even if the parties agree, you can decide differently. But the parties do agree that you have to couple the decency clause with the wrongful behavior in relation to the duties. So I hope that addresses that question. But we go one step further than the mayor, because we believe that for there to be official misconduct, it has to be while an official is either performing his specified duties or failing to perform those duties, and that there is not a standalone morals clause that can apply to whatever a public official does in his or her private life. And there is another point that I wanted to make on this subject. We do think that Mazzola remains good law on these two critical issues. One, that you have to be engaged in the performance of your duties to be guilty of official misconduct, and two, that misconduct, whatever it is, or conduct, has to occur while you're in office, not during the time period when you've been elected, but not sworn in. And the reason why...
Can I interrupt you on the
Yes.
while in office?
Yeah.
In Mazzola, was the while in office meaning performing the duties of office, or was it because he wasn't in the official position yet? My understanding was that he was a commissioner at the time. So Mazzola, when Mazzola says while in office, I don't think they're talking about the situation where you're swearing in. They're talking about the position, the situation where you are not performing the duties of your office when you're leading a strike.
No, I agree with you. That's correct.
So Mazzola doesn't address your timing issue.
Well, it does in the sense of in surveying the various legal authorities that the Court of Appeal decision surveyed, including Black's Law Dictionary, Amjur, as well as some other state cases, and they're cited there, the Hale case, the Harvey case, the Wachter case. it kind of gathered together all these legal authorities, all of which, I mean, if you look at those cases, they all deal with public officials who are in office at the time there is some misconduct that is alleged. Now,
but wasn't Mazzola really addressing the question of the relationship of his job as a commissioner versus his job as a business agent for the union? I mean, that's a relationship question, not a timings while somebody's physically in office question.
Well, in our view, there were two main issues that were addressed and decided in Mazzola. And the primary issue is certainly whether or not, as an airports commissioner, there was any relationship between that and Mr. Mazzola's actions advising his union to go on strike. That is correct. However, before they could even reach that point, they had to address the void for vagueness challenge. And the way that they rejected that void for vagueness challenge was by referring to these long-standing definitions of official misconduct. And so when the court looked at the three cases that I just mentioned, as well as the other legal authorities, they decided, no, this isn't vague because there is an understood notion of what official misconduct is. And what it is conduct that occurs while you're in office. Now, to address the Chair's question about did they make any determination as far as a pre-swearing-in time period or a post-swearing-in time period, no, they did not. But I don't think, as the Mayor has argued, that this definition of official misconduct is dictum. It forms the basis of the opinion.
But, and then the language of the charter was changed by initiative. And how do we know that the change was in order to reinforce, as you would say, an in-office requirement, that the conduct must be in office, or to make clear that that wasn't what the voters intended?
Well,
the fact that there is a change after something happens doesn't tell you in which direction they intended it to be, and the words "in relation to the duties" are quite. There were other words available if the initiative had wanted to say while you are holding that office or while conducting that office.
Well,
how do we know which direction we meant?
Well, I mean, if it's difficult to tell, then I think you have to adopt the interpretation that favors the accused in this situation. But I think if there's an easier way to answer that, you know, any statute, when you're construing a statute, it has to be harmonized with other laws if possible, if it won't do violence to the interpretation of the statute. And I think that you have to look at the current charter definition of official misconduct that was enacted after Mazzola, clearly draws from the Mazzola opinion, and say that the drafters, whoever they may have been, were well aware of what Mazzola had to say about this issue. And so it has to be interpreted in a way that is consistent with the Mazzola decision. There is one other point that I would like to make, and I'm certainly willing to entertain.
Can I stop you then while we're on this point? As a policy matter, is there any justification for why this should not apply to an elected official who's not yet sworn in? I mean, to say that the charter is imperfect and the people didn't vote in a provision that was perfect is not very compelling to me. I mean, I want to know why, in your view, we should take a restrictive view of public official that would absolve him of or immunize him from being suspended for official misconduct prior to his actual swearing in.
And there's a very simple answer to that, and that is the primacy of the will of the electorate. There is a provision in place, it's called the recall, that can be used to remove a public official that the voters want to get rid of. And that's the democratic way to do it. Now, admittedly, it can take some time because you have to wait 6 months until after the official is sworn in to start gathering the signatures. So it can take close to a year to remove the public official. But that's the democratic way to do it. Bringing these proceedings, it's far too susceptible to the vagaries of politics.
But the voters knew all that, in theory. The way we have to read this is that the voters understood that there was a recall option available, and they said, we need this. It's not as though we or the supervisors or the state said, you need to do something different and override the recall provision. Why doesn't this harmonize perfectly with the voters saying, we want an additional tool and process, and we, the voters, will design and put it into place because, in our view, the recall process is not sufficient. Whatever the reasons for why they wanted this to do, it's the voters who said we want another tool, not some third party or our determination that adds this to the armamentarium.
Well, to be fair, I don't think the voters created this new tool out of whole cloth. It's existed in the charter for almost 100 years. The power to remove for official misconduct has been in the charter. It's just they tweaked the procedure a bit, creating the Ethics Commission.
Right. They refined and reviewed it repeatedly is another way to describe the same thing.
Exactly. So, but to answer your question, I think you have to assume that the voters were aware of the state of the law. And the state of the law has not been in California, so far as I can tell, and the mayor has not cited any case to this effect that allows a person who has been elected but not yet sworn into office to be removed for any act that occurred before they're sworn into office. There's just no such case that exists. And that's why they've had to go to other jurisdictions to try to persuade you that this is the right interpretation. And again, at the risk of beating a dead horse, I'd have
We don't know whether those cases don't exist because nobody tried to discipline situations that arose, or whether there are no such factual situations. That's just
of course,
in it.
Of course. And I don't want to move away from this if there's anything left unanswered. But one other point that I want to make about this. The mayor has argued that law enforcement a law enforcement officer should never run afoul of the law, should never commit anything that can be charged as a crime, and a law enforcement officer should never be convicted. As a matter of fact, their expert witness said, you get convicted, you should be fired immediately. That's not the case here in San Francisco. There are many, many law enforcement officers who have been convicted of misdemeanors and remain on duty and serve honorably. And this goes to the point that I think Commissioner Rennie raised. There's a two-part process here. You determine whether or not there's official misconduct, and then you decide whether or not this was a correct use of the mayor's discretion. I would maybe add something to that, as suggested in our brief. I think if you did find that there was some level of official misconduct, you could make the recommendation that it doesn't warrant removal. And the mayor has argued law enforcement has a special duty because they're required to investigate, they're required to do certain things. I mean, you can look at what happens with judges who can be fairly said to be bound to uphold the law and apply it fairly. And I personally know several judges who have been convicted of misdemeanors and are not removed from office. I mean, the fact of the matter is, it has to be recognized that people sometimes make mistakes and they sometimes run afoul of the law. It doesn't necessarily warrant removal. And clearly the facts of this case, in our view, do not warrant removal. Unless the Commission has further questions, I would submit.
I want to talk to you about a couple of facts.
Sure.
In my view, I'm going to credit Inspector Daniele's testimony because he submitted a declaration and he was not cross-examined on it. So in my mind, it's credible that the sheriff told Inspector Daniele that he sold his gun in 1996 to some cadet. In your view, I assume you don't think that's official misconduct, but what's the justification for making this untrue statement to Inspector Daniele?
I think that the question assumes something that's not necessarily, okay, it may be an untrue statement, but as you yourself, I think, focused in on when you were asking Mr. Keith some questions. How do you know that it was made with any wrongful intent or intentionally? Perhaps the sheriff just didn't remember what happened with the gun. You know, I can't really give you a proper answer on that. I can't give you a proper explanation. But I can reiterate what the mayor said, which is that by itself isn't anything that would warrant removal. If it's not, then the question is, why are we even discussing it? Is it to make weight because the rest of the allegations aren't sufficient? So in my view, whether or not the sheriff made a truthful or untruthful statement regarding the guns really doesn't have much relevance. I mean, the point of an EPO is to get guns out of the hand of the person who's accused and into law enforcement's hands. That's the point, and that's what was done here. And whether it went to the sheriff's department first and was then turned over to the police department is really immaterial. I mean, who knows why his lawyer objected to that transfer? I don't.
Staying to the facts a little bit, and I've been troubled by the question, and I asked Mr. Wagner that, as to whether or not, in determining whether or not the mayor acted reasonably in exercising his discretion, he could take into account the events or the acts that occurred between the time December 31st and the March 19th date when he acted. And one of the troubling things is Ms. Lopez's assertion of the attorney-client privilege. Based upon her testimony, it was absolutely clear to me, and it was clear to the court that ruled against her on that point, that she wasn't talking to her as a lawyer. She had talked to her over a period of a year about problems with her marriage and said she talked to her as a friend. And when she talked to Ms. Haynes and told her about her discussions with Ms. Lopez, she didn't say, I went to Ms. Madison as my lawyer. It was clear she was saying, I went to Ms. Madison, and I didn't think she would disclose it. I thought it would be confidential. But there's not a scintilla of evidence in the record that supports a claim of attorney-client privilege. And that troubles me, that in an investigation, it would have been one thing if Sheriff Mirkarimi had said on January 4th when this thing first rose, you know, I did a terrible thing, it was a mistake, I'm sorry about it, and you know. But that isn't the course of conduct that they took for the next 3 months, which was, or 2 months, was essentially stonewall.
Well,
can the mayor take that into account?
Well, in my view, no, and primarily for the fact that Ms. Lopez had a different attorney than the attorney who represented Sheriff Mirkarimi. If there was one lawyer representing the two of them, it might be a different situation. But whatever actions were taken by Ms. Lopez in asserting the attorney-client relationship between herself and Ms. Madison can't be attributed to the sheriff. There's no evidence that
It could be attributed to the sheriff to the extent that he could have said, hey, I don't want that raised. I want to just get this over with. I want to lay the facts out, not let the newspapers tell what the facts are. I'm going to tell you what the facts are, as he told us here.
Well,
if he'd have done that on January 5th, I don't think any of us would be here.
Well, but that assumes then that Ms. Lopez, again, that assumes she's going to do what he tells her to do. That assumes that Ms. Canny will do what he tells her to do. It assumes a lot of things that may not be provably true. So I do agree with you that the mayor can take into account events that happened after he was sworn in up until the time of the plea. I also think that you should take into account what the sheriff was able to do during the time period that he did serve. And it's clear from his testimony that he was in the midst of accomplishing significant progress in the sheriff's department.
I want to ask you about the Ms. Lopez video. In there, she refers to the sheriff as having said he's a powerful man. Now, the mayor is arguing that that demonstrates a concerted use of his power as sheriff to dissuade Ms. Lopez or get advantage in a custody dispute. Why isn't that the most logical reading of that testimony? I mean, what else could he have meant?
Well, here's what I see as the problem with this whole powerful man argument. There isn't any specific, there's no specific language. I mean, saying you're a powerful man can mean any number of things. Yes, it is, one reasonable interpretation could be that he's an elected official. He has or believes himself to have more power than the average person. I mean, I think there's a real question about the truth of that statement. You know, I don't know that if you go into court in a custody dispute, you're going to be treated any differently by a bench officer just by virtue of the fact that you hold a public office. But getting back to your question, I think that is a reasonable interpretation, but I think that having heard the explanations from both the sheriff and Ms. Lopez, it is clear and it's equally reasonable that he was talking about child custody laws and how they may favor the person who has citizenship here, and certainly that they are going to, you know, I mean, we've come a long way from the days when the custody of a child was pretty much automatically awarded to the mother. The father has significant rights that are recognized in family court.
Thank you, Mr. Kopp.
Thank you.
Thanks, Commissioners. I'll see how much I can cover in 5 minutes. And what I'm going to do is I'm going to talk about the facts, because I think some of the facts here make these legal questions that we're facing easier. Because we're making a decision here by reference to facts that we actually have in a real record before the Commission. And I think one thing that's crucial here is that a course of conduct is pled. It's a course of conduct that began on December 31st, 2011, and continued until the day that the sheriff was suspended. It includes his missteps and his misbehavior in the investigation, his public statements, and most significantly, the discredit and the dysfunction that he would bring to the sheriff's department were he to continue as a convict in that office after March 19th, 2011. I think when we look at this as a course of conduct, the timing issues go away. I think that the Commission was spot on the significance of Mazzola on this point, which is that it didn't speak to the timing issues. And all of the policy reasons favor a timing issue that doesn't create this period of immunity for an elected official. But you know what? We don't have to go there, because we have a course of conduct where many of the consequences that spun out of his conduct were preventable, but Sheriff Mirkarimi, by his actions and his errors and his conduct, invited those consequences.
Let me ask you about Mazzola, because I kind of find both of you a little bit off on what Mazzola means, because I'm looking at page 149 of the opinion. And the court goes into this assertion that official misconduct under attack is virtually the same as misconduct in office. It then refers to the Black's Law Dictionary and the Amjur. And in both, in the Black's Law Dictionary, it does have this language by a public officer in relation to the duties of his office. And then the court, using that, finds that that means that it has to be misconduct that occurs, that has a direct relationship of the alleged wrongdoing to the office held. And it also says the violation or omission must be committed while in office. Now, and I understand that you are now saying that this Mazzola dealt with unlawful conduct and we're dealing with wrongful conduct, and I appreciate that distinction. But the charter uses that same in relation to the duties of office that we use in our charter. So why should we not follow how Mazzola interpreted in relation to the office the way and apply it to our charter, since it's the same language, the same words, And Mazzola requires a much more direct relationship than you're suggesting is required.
Okay, that's a good question, and there's an easy answer and a hard one. And the easy answer, I don't mean to be flip, was that Mazzola dealt with a charter provision regarding official misconduct that forbade official misconduct. No definition whatsoever. They had to come up with a definition.
Okay, but you understand we're in a situation where we have very little case law, so we're...
Then in 95, the voters came up with the definition, and they took part of it from blacks, they took changing it, they took part of it from Amjur, changing it, and they've changed it since. Now, I have here, and I'm sorry I don't have multiple copies of this for the commission. What I have here is the Black's Law definition that was quoted in Mazzola, and then at the beginning of the charter definition. We don't go on to add the decency language, but it continues to add the decency language. So the thing about the Black's language is it didn't get into the decency issues. It didn't get into the professional standards issues, like in the same way the Amjur definition did. So the Amjur definition has that. We get those decency issues, and the relationship test for a decency test is the standard required of an official who holds that office.
That's a fair point, but you've conceded that the decency clause is limited by the relation to the duties clause. So I can't see any reason why you'd read clause, how did you label it, the inaction clause to have a certain type of relation to the duties, but the conduct clause to have a different one. I think they've got to be the same. I mean, if it's going to relate to the duties, any one of the subclauses has to relate to the duties in the same way.
They don't. They don't have to relate to the duties in the same way, and the reason why is this. We look at the professional licensure cases, real estate agents, lawyers, you name it. You can commit a wrongful act that shows that you don't have the qualities to be in that profession, and that alone satisfies the nexus requirement. It satisfies that relationship test. So the relationship test does mean very different things when you're talking about sort of the strictly construed legal duties of office, which again is what Blacks was focused on, but then the charter, widened that definition to include all wrongful behavior, and wrongful behavior encompasses violation of that office-specific standard. So I don't think the relationship test means the same things, particularly when we think how much Mazzola was focused on unlawful behavior. There was no violation of a statutory duty here. But we have a new definition now. So I think we need to look at Mazzola's discussion of the relationship test and the need for something tied closely to statutory duties as something that was also tied to its definition of unlawful behavior. So the issue is different. The relationship test is different. I mean, that's why it's okay, for example, for a real estate agent to have a conviction for possession of drugs, but it's not okay for a peace officer to have a conviction for possession of drugs. They're both indecent conduct, but one of them has a relationship with the duties of office, the other one, the duties of the position, the other one doesn't, and we interpret these kind of morals clauses, let's call them, in relation to what are the qualities, the ethics, the morals that we expect a person in this particular position to hold based on the kind of trust that's at issue.
And you've advocated a common sense test for this relationship test, right?
That's what the law says, and that's what we've advocated.
And so explain to me why I, as a commissioner on the Ethics Commission, should be comfortable applying a common sense test, and whose common sense should I be applying?
Well, the common sense test is, what do people in this position do? And of course, as commissioners, we don't know that. So we have witnesses come in and say, here's what a chief law enforcement officer is expected to do. We have declarations from the sheriff, from the acting sheriff, outlining all the different responsibilities of the sheriff, whether policy responsibilities, operational responsibilities. We have exhibits, we have documents from the sheriff's department outlining these responsibilities, the rules and regulations that govern everybody in the department. So it's a common sense test, but it's one that it's a fact-based test fundamentally about what people in this office do. And one of the functions of the commission has been to collect that evidence, and that's the evidence that supplies what is in relation to the duties of office. So it's a common sense relationship in that sense.
I have one other question, and I apologize for monopolizing your time.
I think we should give him 2 minutes to finish.
At page 9 of your brief, you appear to agree that there's a difference between personal misconduct and official misconduct. Do I have that correctly?
In that there are some things you could do that are completely personal that wouldn't be a proper basis for removal. That's
Okay.
right.
Okay. I just wanted to make sure I understood
Yes,
that.
yes. Now, Commissioners, again, I think, again, the facts help us. Much as they help us with this issue of what the relationship test is, they help us in understanding, does this warrant removal? Because the Sheriff's fundamental argument is, I mean, it begins with the premise that this was just a nonviolent misdemeanor, a fact that we know not to be true based on the testimony that came in at this hearing. That's their initial premise. But then they say, well, even if it was, you know, it's still not enough. There needs to be more. And I think the evidence that came in on the conduct showed it was more. But beyond that, the consequences that have followed from that conduct for this department, for law enforcement in this city, and for domestic violence law enforcement in particular. The sheriff has made statements that alienated victims, that discourage, and he's engaged in conduct that would discourage any witness from coming forward and reporting a crime that's committed by a high official. These are things that a sheriff just cannot do. He did them, and he did these things as a consequence of what happened, but he made choices along the way. These choices as well were wrongful conduct. They may have begun with a terrible, terrible incident, but the sheriff consistently took actions that caused further negative consequences for his department and for this city. There's no question that this type of conduct warrants removal. He committed a violent crime against his wife. He violated that trust. He is not suited to fulfill the trust of this office.
They're way over time.
Mr. Wagner, overruled.
Okay. I've concluded. I thank
you.
the Commission for its time and attention.
I want to say a couple things. First, I want to thank the parties for their argument and for their cooperation throughout these proceedings. As you and the public know, this was somewhat of a novel endeavor that we engaged in, and your cooperation was very helpful in getting us through it. I also wanted to thank Mr. Embledge, who has donated his and his firm's time pro bono to help us negotiate some of these issues, and of course the Commission staff for their help, as well as the public. Your interest has been significant, and we certainly appreciate the role you play in the Commission doing its work. So here's the plan. Let's take a short break, and then after the break, we will begin with public comment. Again, public comment will be limited to 2 minutes. Is there a procedure that you would like us to follow as far as people lining up, or how should we do this? Okay.
We can have people, because we have people in the north line court.
Okay.
We can start filming it through the right here. Actually, we go around and then straight out. Would that be convenient for you?
So your idea would be to start with the people outside and then have people inside do public comment at the end? What are you saying?
They stood in line here first. The people that are here right now.
Should do public comment first?
Yeah, they stood in line. They got here first.
Right, okay. And then you want them to file out after they've given their comment? And then have to come back in?
They could actually, if the people that are here, if they stood in line, I would suggest, it's up to you, but if they could just go regain their seat.
Regain their seat, okay.
And then after that, we can start forming. We already have the line set up outside, sir.
Okay, okay.
And then we can start.
Do you have any estimate of how many people are lined up outside?
1 second, please.
There's only about, there's actually maybe 2 people.
Okay, given those numbers, and I want to ask my fellow commissioners, should we take a 10-minute break, go through public comment, and then take a lunch break, even if that means lunch occurs, around 1 o'clock or later? Or would you prefer to try some other means of proceeding?
Take a break. Take a break. Yeah.
Take a short break now, go through public comment, and then take a lunch break? Okay, let's do that. So let's take 10 minutes. So let's come back at 11:10, and then we'll begin with public comment.
I think you have to see. I think they have no idea whether they'll like.
SF Gov TV, San Francisco Government Television.
Okay, we are back in session, and we will now take public comment. Before we begin with the citizens in the room, Mr. Emblich has a brief announcement.
Okay. Just as part of the public comment, I just want to say that 2 commissioners received an email with comment about an argument about the issues before the commission. That email from Mr. Paul Melbestead has been forwarded to the council for both parties, and the email will be entered into the record as part of the public comment.
Thank you. We welcome the public. Please, ma'am.
I've handed out what I want to say. Good morning, commissioners.
Please speak into the microphone.
Okay. Good morning, commissioners. I'm Nancy Coleman Ventrone, and I'm Ross Mirkarimi's mother. I'm here, of course, to support my son, but I have an additional unique perspective. I sit on the Human Rights Commission for the state of Rhode Island, appointed by the governor. Like you, we have to make difficult decisions that affect people's lives. We must sort through a lot of conflicting information to reach a fair and just result. Facts do matter, not innuendo, rumor, or gossip. There was a rush to judgment before the new sheriff was even sworn in. Sometimes it's difficult to peel back the layers. I follow and view everything in this case every day. The most salient fact here is that Ileana Lopez is not an abused spouse. I know her as a strong, independent woman who speaks her own mind. She travels regularly to Venezuela for extended stays. She attended acting classes in L.A. She has a weekly San Francisco radio show. She taught movement classes for babies. I also personally know that since March 2011, she has wanted to return to her family and career in Venezuela with Theo. She has stated repeatedly that the video was made for a potential custody fight, not because she fears her husband. Theo means the world to his parents. How many of us have argued with our spouse over the care of our children? How many of us have said and done things in the heat of an emotional argument that we deeply regret as wrong and for which we are deeply sorry? The mayor's charges are built on the erroneous assumption that Ileana is a victim.
Thank you, ma'am. Next, please.
Thank you very much. Good morning. My name is Espanola Jackson. I've been a community activist for 50 years or better. I was very surprised to learn that you only been in, not just you, but this commission for 18 years. And you have a hard job in front of you of making your decision. And I'm hoping that being an advocate, you all being attorneys, that you do the right thing. Because as the previous speaker said, the family knows best. And number one, the innuendos about brutality. She was bruised because a lot of us are easy to bruise, and we all know that. So I want you to take what the facts are and not what people and the press have gave up some time ago about what has occurred. Please do the right thing so you can sleep at night and people can look up at you in your years coming, because some of you are very young and you're going to be running for office, and I'm quite sure you will want people to do the right thing by you. Amen.
Good afternoon. My name is Barbara Tangeri. Ms. Ileana Mirkarimi, I am Garifano/Latina from Honduras, Central America. I supported your husband, Ross Mirkarimi's Ethic Commission hearing since day one. When he was supervisor, I volunteered in another office. I respected and saw the human side of him. For example, he allowed a puppy belonging to the receptionist to work every day. If it was okay with him, it was okay with us. When Sheriff Mirkarimi was suspended with no pay, I immediately aired my own domestic issues before the Board of Supervisors and sent a strong message to Mayor Edwin Lee that no one is free of domestic issues. Mayor Lee, have you looked at your own dirty linen? It is my sincere hope your marriage heals, Mirkarimi elected job back as sheriff, back pay, and benefits restored. May the peace of the Lord be with you both, and of course, especially Theo. Thank you to everyone.
Commissioners, my name is Francisco da Costa. And in all the deliberations, what I'm going to say right now, some of those deliberations you have not heard. You have read about them, but you have not heard. We have a Sunshine Task Force that after deliberation sends hundreds of cases before this Ethics Commission. You have to ask yourselves, how many of those cases have you thrown into the waste paper basket? You have to ask yourself that we the people, when we formed this Ethics Commission, whether we wanted an Ethics Commission like this that adjudicates in the manner in which you have thrown out so many cases sent to you by the Sunshine Task Force. Now, you commissioners, let me bring it to your attention. We have 4 supervisors who have been charged official misconduct by you, commissioners. Yet, in this process that one of you commissioners alluded to, maybe a dog and pony show, in this process, you are going to make some adjudication and send the same process before the Board of Supervisors, of which 4 supervisors, commissioners, have been charged for official misconduct. We the people are puzzled. We the people are bewildered. We the people are confounded. I feel personally, in this case, we should not have taken this route. Waste of millions of dollars and waste of the people's time. Thank you very much.
Good morning, Commissioners. My name is Julie Sue, and I'm President of the San Francisco Commission on the Status of Women. However, I speak as an individual today. The city has made a commitment to combat domestic violence. We've reduced the homicides related to domestic violence by over 80%, and that is a concerted effort by the policies of the city, working with the Family Violence Council and every individual in law enforcement, representatives of our social services, as well as the court. So I hope that we don't unwind the efforts. That also includes work by the Sheriff's Department. And when you have a link that you cannot work with, that undermines the policies for the city. I also am a public attorney working for the state of California as a regulatory enforcement attorney for the California Department of Insurance. That also includes licensees. And every government employee has a particular code of conduct. Specific conflicts of interest may be specific to departments. But in terms of licensees, we do remove for DUIs, for domestic violence. The Department of Real Estate made specific regulations for direct conduct related to the job. The Department of Insurance and other agencies don't have that specificity. And we all know what the common sense definition of decency is. We hold the public trust. And so your decisions will impinge on whether or not an elected official has special treatment and doesn't have to conduct himself or herself with the charges, if that person is above what the rank and file must follow. Thank you.
Hello, good afternoon, all of you. I've been here, I'm Maureen Daggett. I'm friends with Ross's family through my son and his wife, who are friends of his. And I'm also a longtime San Franciscan, since I was in elementary school anyway. And one thing that catches my attention is that when the mayor testified, he said that he based his suspension on the declaration by Madison, and Commissioner Wren, when that first came up, prior to that, said that he thought it would poison the well and we should throw it completely out. Madison never was called to testify. That whole thing is, so that contradicts the idea that Ross is being tried here again for what he pled guilty for. Okay? Now, there have been several of you saying, like Wren said today, that they wish that Ross had done this or done different things during the course of the time since this has taken place. You know, that he should have said something January 5th, that would have made things go away, or that he should have, there are all these different, those are not what he's being tried for. He comes from a good family. He's a good man. He's been voted 3 times by the electorate of San Francisco. He's served and then he was reelected. He served and then he was reelected.
Thank you, ma'am.
He's not, all I'd like to say.
Thank you very much for your comment.
Hi, my name is Atusa Yekan, and I moved from Iran 33 years ago with my family because I found my country of dreams, United States of America, a country that everything is based on justice, a country that relationships, kissing somebody in the right places and relationship and conspiracy doesn't exist. Everything is based on facts, on fairness, on hard work. In a country that they do not bring somebody down because they don't like him. I came to the United States because I believe in America and I'm a US citizen. And this whole thing has been really stressing me and my family because it's an example for all the new generation in this country that you work hard and then in the heat of the moment of the family dispute over your child, you pull your wife or your husband's hand and they get bruised and against their will, you be treated like a criminal. I hear all these words about Ross Mirkarimi's wrong conduct, unlawful conduct. If I wasn't in this room, I would think that he's a criminal who beat his wife. She calls 911 every day, and he abuses her all the time. I would think that he's a criminal. Yeah, he lost his temper for a second, in my opinion, and he grabbed his wife. I tell my husband of 20 years sometimes that I don't like him. I even say bad things to him, but it doesn't mean that I mean that. We're husband and a wife, and we make up an hour later. Is that, can we judge a person, a hardworking person that has a lot of progressive ideas, and he has done a lot of good things in life, during his career, just because of something like that, and make him look like a criminal, a real criminal, while criminals are walking in a street? I'm sorry, I got emotional. That's all I say. I think it's not fair. And we all have conscience. We all sleep at night. We all die one day. We have to go with our conscience and what is right.
Thank you for your comment, ma'am.
Hi, my name is Patrick Connors, and I live in District 5 in Hayes Valley, up the street from here. I voted for Sheriff Mirkarimi 3 times. I've lived in this neighborhood for 10 years. And I also wanted to let you know that today also happens to be my wedding anniversary. 4 years ago, my husband and I were married. We're one of the 18,000 special edition, limited edition same-sex couples in California. So, I mention that because I understand what it's like to be subjected to specious public ridicule as well as political scorn, pretty much for my entire adult life. And in terms of understanding that, I ask that you keep in mind that this commission did not appoint the sheriff. The Board of Supervisors did not appoint the sheriff. The mayor of San Francisco did not appoint the sheriff. Neither did Gavin Newsom, Willie Brown, Rose Pack. This man was elected to office. And there is a method in place for a recall to occur, and the people who elected him should have the opportunity to recall him. It should not be taken away by anyone, any board or commission or mayor. So I ask you to please keep that in mind when you give your recommendation to the board. That process may take time, as the city attorney pointed out today, but this procedure has taken a long time too, nearly 9 months. And signatures can be gathered and could have been gathered in the last 2 months to have a recall begun. So please let us.
Thank you, sir.
Good morning, honorable commissioners. How are you today? You all look very serious. Okay, it's a little humor here. My name is Pedro Fernandez. I'm a former San Francisco policeman. Spent 8 honorable years of the SFPD. I'm a syndicated radio talk shows and a licensed private investigator. I've known Sheriff Mirkarimi for about 12 years now as we work together during community events in his district regarding boxing. First of all, I've got some issues I want to bring up. Mr. Keith here in his office never proved that Sheriff Mirkarimi uses power to coerce any witnesses or dissuade any witnesses. That's never brought up. Mr. Keith accused the campaign manager, Ms. Haynes or Ms. Lanes, I'm forgetting right now, basically of perjury, of lying under oath here today before you guys, and that's preposterous. I don't think she would do that. She's an honorable woman, okay? But that's what he said. All right. I'm old enough to remember George Christopher, the mayor. John Shelley knew Joseph Alioto personally, and George Moscone boxed in front of George Moscone during his tenure as mayor. Okay, the integrity of the office of mayor in this city has been brought into scrutiny. When the mayor was testifying before you, there was an alleged bomb threat phoned in. Okay, the mayor was hustled out of the room. Don't your lives matter? Why weren't you hustled out of the room? Why weren't the citizens hustled out of the room? Why was it just the mayor that left the room if it was a legitimate bomb threat? If there wasn't, the mayor being caught up in his testimony, possible perjury, that's what was alleged by some people, why weren't you guys removed from the room? Lastly, I think there's a double standard because we know the fire chief hit her husband over the head with a glass bottle or a glass on 2 occasions, caused a wound. The husband called 911, said his children were in trouble, the whole 9 yards. Mayor Gavin Newsom said it was a family issue, that the family should discuss it. It's a family matter, and he would let it go at that. I think Mayor Edley has overstepped his boundaries, and I hope that you find that he has as well. Thank you for your time.
Good morning, ladies and gentlemen, and hello, San Francisco, 24/7 on San Francisco Government TV. My name is Paul Currier. Some of you recognized me as a candidate for mayor in 2011, and I was not really well thought of on the campaign trail because I called Ed Lee a organized criminal at that time. Mayor Lee now faces charges before the State Bar for criminal violations of the State Bar Act. Chapter 1, Rules 1 through 100 forbid the misuse of public funds, perjury, and patterns of corruption. Our district attorney, our city attorney, Willie Brown, Rose Pack, all illegally protected Mayor Lee's conveyance of public property for private gain, Mayor Lee's election frauds, collusion, graft, fraudulent conveyance of public property for private gain, and misprision of felony. These are criminal acts. The mayor's misuse of this whole ethics process is transparent. The Ethics Commission has wrongfully postponed Sunshine Case number 11048, where 4 supervisors now face criminal charges for their acts, which have empowered civil rights violations, ADA violations, and numerous illegal evictions at Park Merced. This has damaged many people. We must hold the mayor accountable. It is time to hold the money machine in San Francisco to account, and I call on San Francisco to organize anew around one issue, and that's to recall the machine and throw all the bums out. This is the first time since June 14th we've had public comment. And the last person that made public comment is now evicted. Her name is Lynn Gavin, and she's running for supervisor in District 7. I'd like to submit my 139-word comment for the record. Thank you.
Good afternoon, Commissioners. I may be a familiar face to you. I've been here to many of these hearings. My name is Tracy Lemon, and I'm an employment attorney, and I have been a friend of Ross and worked on his campaigns for the last 8 years. I know him as a good, honest, decent, very hardworking man and very capable political officer. I am personally outraged and have been of Mayor Lee's abuse of discretion and abuse of power to attempt to remove a democratically elected official without pay, pending a 5-month investigation and hearing. Who knew if it was going to be 5 months? It could have been 5 months, 8 months, but that is outrageous, illegal, and most undemocratic to starve out a democratically elected official, deny him the means to pay for his family and his mortgage while he's under investigation where he seems to be presumed guilty rather than considered innocent. I think that this also sets up a very dangerous precedent if a San Francisco mayor is able to have unfettered discretion to remove an official for what he or she refers to as official misconduct based on the vague standards that you have identified and discussed today. I think that gives him too much credit. It doesn't show a good history to that. And the question is, who's next? I note that the mayor himself cannot be removed for official misconduct under the city charter, which is quite interesting because if he actually committed perjury here when talking to you, the Ethics Commission, it would be suitable to bring this up against him. I think this has been a disgraceful waste of public resources, time, and money. I can't believe you've all created 15 inches of documents. I applaud your duty, but I think things have gone too far and really ask you to do two things, is to hold the mayor accountable and consider whether he abused his discretion in starting this whole process. Give that good, careful thought and consider whether turning a car around is actually official misconduct within a meeting.
Thank you, ma'am.
Official duties. Thank you.
My name is Vivian Imperiali. I am a city worker speaking as a private individual on my own time. The mayor's removal of our sheriff invalidated the will of the voters, who embraced Ross and his vision for a better tomorrow. Ross has always invigorated the electorate. His brilliance and integrity inspire us and make us better citizens. City Hall inflicted unprecedented punishment for a misdemeanor. There was no official misconduct. False imprisonment was merely turning around his van to go home rather than take an argument to a public place. Haven't we all done that at least once? Your recommendation to reinstate Ross will restore the morale and morals of San Francisco. Ross may look like one person, but he carries the politics and passions of a constituency. Likewise, each supporter here represents thousands more who couldn't be here today. We are here to convey the magnitude of our support for Ross and the depth of our respect for a man who endured months of scrutiny, humiliation, and forced separation from his family, all while having no income. Ross faced these circumstances with admirable grace, optimism, and fortitude, all attributes we want in our sheriff. As sheriff, Ross will create a model system of promise and possibility that will do this city proud. How fitting that a star is the symbol of the sheriff's office. Surrounded by a galaxy of supporters, Ross is our star. Let him shine.
My name is Marilee Mondahar. I'm the president of the Filipino Women's Network. We have with members nationwide. We started an anti-domestic violence campaign when a young Filipino woman, 28 years old, was murdered by her boyfriend in front of her 2 young children. It took 8 years to give her justice. Domestic violence is a big problem in San Francisco, especially in the Filipino community and many communities in San Francisco. We have worked so hard to help victims come up and seek help and leave abusive relationships. The San Francisco Police Department receives over 4,000 cases of domestic violence annually. Each case could potentially end up as a homicide, and last year, at least 35,000 sought help for domestic violence. Studies also show that domestic violence victims do not call police, and when they do, 78% recant their initial statements. I know because I was a domestic violence victim. I denied being a victim for many years. I came to the U.S. to leave an abusive marriage, to hide and not tell people. I'm a professional. I said, I'm smart. Why am I in a domestic violence marriage and a relationship? So I ask you, the Ethics Commission must set a high bar for what is decent and right. This decision will send a message to perpetrators and victims of domestic violence, and will have an impact far greater than this case. So I urge you to do what is right. I don't think Mr. Mirkarimi can do his job as sheriff. It will just create more fear amongst domestic violence, especially women in abusive marriages and relationships. Thank you.
Good morning. My name is Kit. I'm a fellow for the Philippine Women's Network, and I'm speaking for myself now. I believe that a person in public office should be an example to the public, and Mr. Karimi's actions can undermine San Francisco's domestic violence prevention and enforcement programs. And the FWN is one of those many programs that people can find information on anti-domestic violence platforms. The sheriff oversees some of the country's most innovative anti-domestic violence programs. And to have a convicted abuser in charge of these programs fundamentally undermines their credibility and efficiency. And I, as an individual, am having a diminishing confidence in his department. So as a citizen, as a born resident, I would ask that the commission please set the standard also for the public and for myself and for my friends and family who, like Marilee earlier mentioned, have experienced in these unfortunate situations. Thank you.
Good morning to the Commission. Thank you for this time. I'm going to be reading from a petition that has been sent to all of you, and you'll receive another copy with signatures. I and 2 other friends will be reading from the same petition. We, voters of the City of San Francisco and those who seek fairness and justice for its citizens, are sending this letter of concern on behalf of all San Francisco's residents and families. Our concerns are the following. We believe all elected officials should have the right to hold office and represent their people within the law without the impending threat of expulsion by other members of office. We believe all citizens should be given fair opportunity to make changes for the betterment of their lives, family, and community without their careers being jeopardized as a result. So we are writing this letter in support of Sheriff Mirkarimi, San Francisco's duly elected sheriff, who has enjoyed long, exceptional record of public service involving innumerable significant civic issues. While serving in office, he has spearheaded groundbreaking legislation in support of the environment, drug and gun law reform, as well as advocacy for working class and advocacy for those underserved and underrepresented in the community. Sheriff Mirkarimi has unquestionably been a true visionary for innovative change both in and out of San Francisco. Recent allegations and a misdemeanor conviction involving the sheriff and his family have overshadowed his new position and have cast doubts in the eyes of some on the propriety of his service as sheriff. The allegations and subsequent conviction are indeed serious in light of the responsibilities of an elected official and by no means are to be overlooked. However, We believe the circumstances under which Sheriff Mirkarimi has been suspended do not rise to the extreme level of expulsion from elected office. It is up to the voters of San Francisco to decide whether or not the sheriff deserves their trust and confidence.
My name is Fariba Nejad, and I'm just reading the rest of the letter. Ms. Lopez has spoken on the record in support of her husband, while acknowledging the fight with her husband that led to his misdemeanor conviction. She has clearly stated, "I have never been afraid for my safety in the presence of my husband or for the safety of my son." Her statements were made without coercion while having had no contact with her husband for over 3 months. So without first-hand information to the contrary, we believe it is not the responsibility of general public or those in office to second-guess the statement of Ms. Lopez or to decide the best remedy for her family. The criminal justice system is appropriately running its course, and there has been professional intervention. Nothing more is needed. Sheriff Mirkarimi took office by a public vote of the people, not by appointment. That means any consideration of his removal would have to meet a higher standard if it were to reverse the will of San Francisco voters who elected him to office. Under the circumstances, we don't believe the sheriff domestic dispute raises to that standard, where a vote of people should be overruled again. It's up to the voters of San Francisco to decide with whom to put their confidence as sheriff. Sheriff Mirkarimi bring incredible insight, value, and experience to the public of sheriff and to the city of San Francisco. He graduated as the class president for the San Francisco Public Academy and worked in the district attorney's office for 7 years. For city supervisor, he championed legislation that set new standard for other cities. Thank you.
Thank you.
I am Silvia Ramirez, and I am from United Parents Committee, Comité de Padres Unidos en Español. And domestic violence is an extremely serious matter. And as a result, the city of San Francisco has a rehabilitative process in place of intervention and prevention. Sheriff Mirkarimi has responsibly acknowledged his shortcomings as a parent and husband, yet is fully committed to the system for full resolution, and has said as much as more than one occasion. Through this effort, he's making changes that will make him a better and more informed father, husband, and public servant. If improvement were not an option, such programs would not exist. Now, we need to let the process take its course without casting our own additional penalties upon those already decided by the courts. Anything else will only compound the existing difficulties facing the sheriff, his wife, and their son, and contribute further to the problem, not to the solution. We, as members of the community, civil servants, parents, and in the name of voters of San Francisco, and as a concerned citizens, are signing this letter in support of Ross Mirkarimi's reinstatement as city and county sheriff, the position to which he was elected by the people. We are fully open to any discussion with decision makers on the matter of Sheriff Mirkarimi's role as the sheriff of San Francisco. As a domestic violence survivor, I'm ashamed of these domestic violence agencies because they only need our pictures to get the money to continue operating. Thank you.
Commissioners and ladies and gentlemen in the audience, Let me introduce myself. My name is Emil Lawrence. I've been a resident of the city and county of San Francisco for 44 years. What you have shown the people, we the people, in my opinion, is what a great frame-up can be in the city and county of San Francisco. What you have here, I believe, is the wrong man on trial. You should have Ivory Madison here. For the record, I don't know of any trial court in America that accepts tainted evidence in court. You have evidence here manufactured, according to Elenia Lopez, by Ivory Madison, who claimed to be an attorney, when in fact she wasn't, who claimed to be an expert in domestic violence, when in fact she wasn't, that wanted to manufacture a video the way Phil Bronstein of the San Francisco Chronicle did in his custody battle with Sharon Stone. Now, I bring that to your attention because I worked for Phil Bronstein. I know what the Phil Bronstein method is. As the night cabbie, I helped introduce him to Sharon Stone when I was a columnist there for 8 years. I know what the Phil Bronstein method is. He's the Houdini of the Hearst Empire, the Svengali of the news media. And Ivory Madison used his techniques and methods to manufacture evidence that has duped so far you, the district attorney, the city attorney, and the mayor into bringing a man for trial when there's no trial here at all for this man. I leave you at that and thank you for your time.
Our commissioner, good afternoon. My name is Abdullah Mujahid, and I am here after I thank God to allow me to hear today. You have the person, the only person in California survived with 8-time heart attack. I have 6-time heart operation. I coming here to support the family of Ross Mirkarimi. I'm not coming here for his good looking, but I coming because I know very well how he worked hard for my city, for his community. He make a mistake, he apologized for his wife, she accepted. Why? The love, the child, they have it, they want, raise him. Did we have discrimination to allow him away from his job 8 months? This discrimination or punishment, enough is enough. Wake up. What God? You believe it, any one of you. If you have God, you must understand. God teach us in my country as Egyptian or here, forgiveness. Don't act like discriminated against man. We love him. How many people run for sheriff? He becoming the sheriff of the city. And the city have criminal. We need some tough guy, work day and night like him. Before I leave, I want to put a smile on me, and I want to make a good position of judgment about the man who stay away from his job and he can't support his lovely wife and his lovely son for 8 months. I repeat again, enough is enough. Thank you. And I hope before you make a judgment, before you leave this place, think about God and think about
Thank you, sir.
Forgiveness. Thank you.
Hello, commissioners and everyone. My name is Jocelyn, and I'm here today to tell you about my experience and to speak to Roth. In the first month, he threw our just-cooked dinner on the floor. In the second month, he pulled a chair out from under me as I was about to sit down at his aunt's dinner table. In the last month of our relationship, as I cried about not being capable of making him understand what I was feeling, surely it was my fault, he pushed me out of our bed and onto the floor, calling me a psycho. I'm a battered woman, and I'm afraid. Though the man who battered me is long out of my life, the effects of his abuse are with me every day. I don't dwell on them, yet they regularly inform my decisions. Ross, I don't feel safe around you. We go to the same gym, and when I see you there, I feel scared. I don't feel safe around you because you haven't accounted for your violence. I don't blame you for not knowing how not to violate. Most men are taught to be tough, to win, to get their way. And when you use these attitudes and actions to enforce your will by controlling your wife and you pled guilty to this crime, you didn't account for it. I don't feel safe around you. If you're not willing to hold yourself accountable for your violence, how will you hold your deputies accountable if they violate someone, their family members, the inmates in our jails, or other citizens? What kind of credibility do you have to hold anyone accountable for their violating when you won't do it yourself? I want to ask you this. Would you be willing to leave your job and find out what you need to do to stop being violent toward yourself, your community, your family? Would you be willing to restore yourself to a state of personal acceptance, love, and tolerance? Thank you.
Hello, my name is Dr. Antonio Ramirez. I've been working in the field of domestic violence for 25 years, working with men who are abusive to women. And my job is to hold batterers accountable. Most batterers in my 25 years of work blame the system, blame their partners, blame everything but themselves. Taking responsibility is a big step that batterers need to take. I suggest that as a community, if we restore Mr. Mirkarimi into his position, it will be a lack of accountability as a system and for him personally. So I suggest that he has no credibility at this point because already many batterers are asking me if what I think about his position. So I'm dismayed that we have to go to this extent, but we need to hold him accountable, and I hope that he holds himself accountable. Thank you.
Good afternoon, Ethics Commission. City, hold the commission. Hope you give the sheriff's job back. Hope you give the sheriff back then the county jail. Public comment came and we began to wail. And I hope you'll give him back what you're gonna do with. And you're gonna sing and gonna give him it back. Let's rock. Give this jail back job. Everybody in the whole city hall block. We're gonna give him back his job, don't stop. And you're gonna give it back in here soon. And you're gonna bring it before the month of June. And you're gonna be with, give him back his job. Everybody don't stop, everybody in the wholesale block. Gonna bring us back his job. We can go on together with suspicious sheriff's minds, and we can bring it back once again this time. He's caught in a trap, he can't walk out because he wants his job. Please, baby, we can go on together with suspicious minds and bring us back his job. That's what I got this time. He is the sheriff for the county, and he drives the main road. And I hope you bring him back after this ethics load. And we want him back, yes we do. And we bowed him back this time. And we're gonna bring him sheriff back, and he's gonna really shine. Bring him back this time.
A rock music junkie.
Hi, good afternoon. I think it's afternoon. Yeah, my name is Aurora Grajeda. I am a member of the Hispanic Latinos Anti-Defamation Coalitions in San Francisco. And two things first, just to get out of the way. How can you follow that one, okay? And I love San Francisco, okay? The Trovador of City Hall, that's the new name he has. He's okay with it, okay? I'm going to make him famous. Anyway, commissioners, there are several points I'd like to make. I'm going to start with one very important, President Hearn. You, at some point, were asking us the only reasonable explanation to the video when the allegation that the sheriff threatened to use his power to take the baby away. That is not the most reasonable explanation. Commissioner Hayon, I am sure that you are very familiar with this situation. In the United States, for the last few years, or several years, thousands and thousands and thousands and thousands and thousands of women, parents, are having their children taken by immigration. And there is a situation in which when you have a custody battle between a citizen of the United States versus an immigrant, even a legal resident, the citizen has a lot more power. More often than not, he's going to get, if he's a man especially, he's going to get the custody of the child. That was Eliana's fear. The other one, it is, I don't know if you notice, people who are advocating to the removal of the sheriff, I don't hear them really concerned about the victim or the actual domestic violence. The only concern it is to make an example out of somebody, because this is battery. And I don't think the evidence supports that the sheriff is a battery. He made a mistake for which he apologized, but that is not battery. And unless there is a pattern, I don't think how you can call it otherwise.
Thank you.
Good afternoon, Commissioners. First of all, I want to thank you for your service. I know it's been a very long haul, and that you are all essentially volunteering your time under very trying circumstances. So thank you. My name is Francesca Rosa. I'm a longtime resident of San Francisco, and I'm asking you as a voter to please give us our elected sheriff back. He was elected by the people of San Francisco, and it should be up to us, the voters, not the mayor or the DA or the city attorney, to decide if he is to remain as our sheriff. As for official misconduct, I see none other than that on the part of the mayor, who took it upon himself to defy the will of the voters by removing Sheriff Mirkarimi from his post without due process and without pay. Sheriff Mirkarimi has taken full responsibility for his actions of December 31st. I've heard him, as have many people in this room, take full responsibility. His wife, Eliana Lopez, stands by her husband, and she wants to reunite with her family, despite the ongoing efforts of those who insist in an extraordinarily patronizing manner that they know better than she does what is best for her own family. I agree with Sheriff Hennessy, respected across the political and law enforcement spectrum, that Sheriff Mirkarimi is the best person for this job. He should be reinstated to his office so that he can continue with Sheriff Hennessy's progressive legacy, that while fully cognizant of the need for public safety, promotes redemption and rehabilitation over vengeance and incarceration. Any voters who do not support our elected sheriff can vote him out of office the next election cycle, or they can organize a recall. But imperial whim of the mayor, as opposed to the will of the electorate, is not what I signed on for when I cast my ballot for sheriff last fall. Thank you very much for your attention, Commissioners, and again for your service.
Buenas tardes, comisionados. Mi nombre es Flor Ramos y aquí mi amiga Rosario Cervantes va a interpretar por mí.
Good afternoon, Commissioners. My name is Flor Ramos, and my friend Rosario is going to interpret for me today.
Yo soy miembro del Comité de Padres Unidos y vengo aquí en apoyo de nuestro Sheriff Ross Mirkarimi y su familia. Se me hace tan duro ver tanto tiempo, tantos argumentos, tantas horas y tantos meses, por lo tanto también tanto dinero en este caso.
I represent Padres Unidos, and I'm here to stand for Sheriff Mirkarimi and his wife, Liliana Lopez. And I watched many hours, many months, and all this charges against Ross, and this is not right because they've spent a lot of money.
Yo creo que ya fue suficiente tanto personas testificando, tantos argumentos, y ya esto es tiempo de que pare.
There have been a lot of arguments, and a lot of time has gone by, and I think it's time for it to be over with.
La comunidad está esperando que nuestro sheriff empiece a trabajar en su oficina.
The community is waiting to have our sheriff reinstated and working back in his office.
Por lo tanto, yo creo en Ross Mirkarimi como mi comunidad, también creo en Eliana.
I believe in Ross Mirkarimi as sheriff, and I also believe in Eliana Lopez and for my community.
Y por lo tanto, queremos que este día, ya sea el final o sea una resolución acertada para este caso y terminarlo.
And I hope this is the final where they have a resolution and they can move forward on this.
Gracias por su atención.
Thank you for your attention. Hi, my name is Rosario Cervantes, and good afternoon, commissioners. And I wanted to say that I stand for Ross Mirkarimi, and I'm here for Eliana Lopez. I believe in Sheriff Ross, and that's why I voted for him. And I believe that I'm one of 84,000 people that have voted for him, and I think that he should have a fair process, and I believe the mayor is totally against him, and I want you to vote in a fair process. Thank you very much.
Hello, my name is Patricia Coleman Forsythe. I urge you, commissioners, to resolve to reinstate Ross Mirkarimi as sheriff. You and we in the audience have just a few minutes ago listened to a blonde-haired woman who stood up here, and I'm close enough to the front that I can hear. She was a complete, total stranger and pretender who is not even known to Sheriff Mirkarimi. And it is disgusting that anyone would stand here and lie to your faces. Ross has committed no crime of moral turpitude. 4 of you are attorneys, and I believe that you recognize that Ross was tried on a technicality of the law in a potential domestic violence scenario. More than 4,000 cases, as you heard, police cases are turned over to the district attorney. And of these, a few hundred a year are prosecuted by the district attorney. And there isn't one similar one that we can find where on an offense in any kind of instance matching was reported. There is no recanting here by Eliana. And if you asked her the right questions, you would find out what props were used in order to, before calling the police. I left with each of you a copy of this handout. You've made an issue of Ross not coming out on January 4th or 5th and talking to the public. He exercised his constitutional...
Thank you, ma'am.
Thank you.
Your Honors, Commissioners, my name is Sarush Richard Shahabi. I'm a former United States attorney at the Justice Department, United States trial attorney, and a graduate of Hastings College of the Law next door. I don't know Ross personally, but I've followed this case quite closely, and I find it necessary to speak today to this very important subject matter. There's one singular issue here before the Commission, which is, did Mr. Sheriff Mirkarimi engage in official misconduct in the course of his duties? Since he was not in office at that time, it is impossible for this Commission to conclude that he engaged in official misconduct in any way, shape, or form. And it would be an absolute travesty of justice to do so. Now, there are issues involving personal matters between Ross and his wife. Those personal matters at times become public matters. But in this situation, it is very clear from the facts that I've seen from the court, from the papers, that this is not a domestic violence situation. This was a dispute between a husband and a wife. Eliana finally is next to Mr. Mirkarimi, but because of the judicial process, she was prevented from being and standing next to him. This man has suffered enough. His family has suffered enough. Not one of you individually would want this to happen to you. He has shown contrition for a dispute that he had with his wife, but all of us can understand, if we go deeply to what happened here, that there was an argument. He reached back, he grabbed his wife. She says she bruises easily. She says when her child bumps up against her, she bruises easily. This has happened between my wife and myself, and we are a loving family. Our son, our 3-year-old son, loves us, and when I put myself...
Thank you, sir, for your comment.
Mr. Mirkarimi, I can't imagine
Sir?
what has happened.
Thank you.
Thank you for your consideration.
Hello, Commissioners. My name is David Elliott Lewis. I'm Secretary of the City's Mental Health Board. I'm also a seeker of social justice. I believe that doing the right thing means trying to help the greatest number of people, regardless of whether or not it's popular. And I believe in this case, the greater good would be served by restoring our elected Sheriff Ross Mirkarimi to office. In a city whose sheriff's department is without any independent commission or citizens oversight board, it's crucial that the person at top, its elected sheriff, be truly independent. This person needs to be unattached to a culture that sees protecting its own as more important than doing the right thing. It needs a leader willing to cross that thin blue line, willing to enforce discipline among the deputies, even if it makes them unpopular. Ross is that sheriff. He has proven through word and deed he's willing to disrupt the status quo and act against the political machine to do what is right. That's also earned him political enemies. Where Ross has served the cause of justice, he has made mistakes, especially in his private life. He's been severely punished for this already. Over $100,000 in legal fees, not being allowed to see his wife for half a year. Being scorned in the press, being fired without pay. This is what hasn't happened, however. He hasn't committed any act of official misconduct. His bad conduct, including the misdemeanor he pled guilty to, occurred on his own time between jobs before he was even sworn into office. You know, think about this. Those who claim otherwise really appear to be politically motivated. In fact, some of his critics, including the ones who financed a billboard against him, have been his ones who financed his political opponents in the race. You know, I'm aware this is a highly charged controversy that triggers painful emotions, and I respect that. I hope that you'll...
Thank you, sir.
...and do the right thing. Thank you.
Hi, my name is Victoria Ashley, and I'm on the County Council of the Alameda County Green Party, and I'm also on the State Coordinating Committee of the Green Party of the State of California. The Alameda County Greens support the reinstatement of Ross Mirkarimi as sheriff. Greens in general are passionate about justice and about truth. We're an all-volunteer party, and broadly, Greens support Ross. I'd like to read, in the interests of truth and justice, an excerpt of the statement by the San Francisco Bay Area chapter of the National Lawyers Guild. The National Lawyers Guild, San Francisco Bay Area chapter, urges the City of San Francisco to stop using public resources to oust Sheriff Ross Mirkarimi from office. We are deeply concerned that his suspension without pay by Mayor Ed Lee is an affront to the democratic will of the people of San Francisco, and that the current efforts to remove him from office lack both sufficient due process protections and are politically motivated. Unlike the accused, the mayor has the unlimited resources of the city attorney at his disposal, and 4 of the ethics commissioners are appointed by people who are or will be directly involved in the case: the mayor, the city attorney, the district attorney, and the board of supervisors. At the very minimum, the situation raises the appearance of impropriety, conflict of interest, and bias. Thank you.
Good morning, Commissioners. I think it's still morning, and your work over the past few months, the least to say, is commendable. I appreciate and admire your energy, your accuracy and precision, especially Commissioner Herr, in conducting these hearings. I testified on the first session, which was April 24th, and this is the conclusion of it. I brought up 2 points then. One of them was that Mayor Ed Lee was the Scrooge to have started this on March 20th, that marks the Iranian New Year and Spring festivals. And the nature of that has not changed. The other thing that I underscored at that time was that this whole process was in violation of Sheriff Mirkarimi's human rights. We are not, in the United States, it seems like we only use that term in dealing with some foreign entities. But we better take a look at ourselves and recognize that when we take a job away from someone, we are violating their human rights. When we stop them from choosing their partners or associating with someone of their choice, we are violating their human rights. And at that time, I suggested that the Commission has the choice to toss out the whole thing. They had passed a hot potato to you, and you managed to hold it in violation of his human rights over the past few months. At that time, if you had tossed it, some labels would not carry, but at this point, they do. Despite that, I really appreciate and admire your resourcefulness, your energy, especially Commissioner Herr's conduct of these hearings. Thank you.
Hello, this is Hushain Pakpuri. I'm supporting Ross Mirkarimi. That's very simple. Please reinstate Ross Mirkarimi, Sheriff Ross Mirkarimi, and stop wasting public resources for this case. And at the end, please let people decide, not the mayor. Thank you. Thank you for your effort.
Hello, my name is Brenda Barrows, and I was here on the first day and I spoke, and I'm saying the same thing again. I work in public health, and I work in a clinic where we have women who are abused. I mean, not to say that Ross, he admitted that he did something wrong. He admitted it, and he owned up to it, and he confessed to it. But, you know, I have patients that have been thrown out of windows, done all kind of things, and yet their husbands are allowed to work. They don't take the livelihood away from the husband so that he can't pay for the kids. I mean, some of the things that were done in this case and the level that it has gone to are outrageous. So for the people that want to fight for those women, you know, I know women who really need to be fought for, that you don't hear about their case. You never hear about it. It's not in the press. They just suffer in silence while the same people are here attacking Ross. I don't understand it. It shouldn't happen. And I hope that you guys do the right thing. The wrong thing would be to allow this witch hunt to go on, this political witch hunt. I said that the first day. I say it again. It's a political witch hunt. We all know it. For whatever reasons, the mayor wants him gone. Now, in my opinion, it's the mayor who has been immoral in many ways. He's not been honest, and he got away with it.
Morning, Commissioners. I'm Andrea Shorter, and I am also a Commissioner and serve on the Commission on the Status of Women, where I now serve as the senior ranking member of that commission, having been there for a little over a decade. I currently chair the Justice and Courage Oversight Panel, which oversees the collaborative effort, the multi-agency effort that includes all of our local law enforcement leaders, chiefs, to come to the table and attend to the issues of domestic violence policy. You've heard in other commentary today in terms of the numbers that we have faced here in San Francisco and continue to face with regards to domestic violence. I will not go over that again. I trust that you all understand the severity and the gravity in terms of how the sheriff's position and charge does relate to that particular collaborative process, which has become really a national model. We've come a long way in San Francisco, and we certainly don't want to go back. This is not in remark to Mr. Mirkarimi personally about him or his family. That is not what this is about in terms of what we need right now in order to move forward. This is an issue of governance. It's an issue of public trust and our ability as a city to make sure that we provide every single citizen the utmost trust and confidence in all of our officials. Right now, as Mr. Mirkarimi undergoes a year-long treatment program for batterers intervention, we would certainly hope that that he can focus on that. And right now, we see that it's untenable.
Thank you, ma'am.
Hi, Commissioners. Am I able to put this here? Or do I do? Oh, thank you. Dear Commissioners, thank you so much for your service and your representation to all of us San Franciscans. I do not support domestic violence. I do support Sheriff Mirkarimi, his right to fairness, to redemption, and a chance. Others have been given chances. For instance, our San Franciscan fire chief. I want Sheriff Mirkarimi reinstated. Please remember the burden of fairness and ethics. It's a tough decision I know you have to make, and I trust in your decisions. God bless you, and you are in my prayers. Again, thank you very much for your service.
I didn't mean to do that. Whatever. Bernie Sheridan, thank you for your patience. I wish to raise the question of contradictory situation with regard to testimony preferred by the city attorneys. You cannot at once infer, perhaps unsubstantially, that intervention by the sheriff on one hand, and that he should have intervened, and I paraphrase, on January 5th as a standing commissioner and officer of the court, that he should have confessed all and thrown himself on the mercy of everybody else. That's a contradiction that, in my opinion, indicates a bias and a lack of propriety that should abort these proceedings now. Thank you.
Good afternoon, Commissioners. My name is Sharon Hewitt, and I'm the Executive Director of a program called the CLEAR Project, located in the southeast sector of the city. committed to the eradication of violence, focusing mostly on homicides. Today, I'd like to take this opportunity to thank you for your due diligence in reviewing this matter. We have an opportunity, a learning moment here. I'm here to say and stand with my sisters who have been strong voices for the eradication of violence, domestic violence, but I'm here to also point out, while we will continue to work together, this is an inappropriate and excessive response to what I think is a family and personal issue. I'd like to extend my apologies to the family because the response has been much more severe than the intended incident. I want to say that from the streets, we're asking that you put a little bit more common sense. This is in excess. We have a burgeoning crisis of homicides, and we say to you, please look at the collateral damage in terms of limited resources being directed in a situation in which the voters of this city actually have an opportunity, should they feel that Ross Mirkarimi is inappropriate in his seat, to recall him. Thank you very much for your consideration. And again, my apologies on behalf of part of San Francisco to Mr. Mirkarimi and his family. Thank you for your consideration.
Hello. Yes, my name's George Sheeman. I've been working on police practices issues since the late 1980s and political campaigns all my life, including since 1995, I've worked on campaigns with Ross Mirkarimi. I heard someone earlier say that he should be treated like everybody else, and I've heard that statement all through this time period. And please, I agree, he should be treated like everybody else, and he's not being treated like everybody else. I've never seen a misdemeanor case treated like this. I've been going to court and watching hearings since I was 12 years old. I've never seen anything like this. I know police officers aren't generally treated this way when they're accused of misconduct and that sort of thing. I'm getting phone calls from out of state and from my home county. People say, what are they doing to this guy? What are they trying to do to this guy? Is this political? Well, you know how I'd answer that probably. Even Gavin Newsom, who is no political friend of Ross Mirkarimi, was quoted in the Chronicle as saying they're piling it on him. And he said, I should know because it's happened to me, so I know how it feels. Other people, oh, is that 2 minutes?
I think you have 30 more seconds.
Pardon?
You have 30 more seconds. There's 2 beeps.
Oh, anyway, I was going to say some other things, but the voters, you know, hundreds of people worked on his campaigns. Tens of thousands of people voted for him. If you waver or you're kind of questioning your decision, think of the will of the people. That's what, you know, it's paramount in this country. So anyway, thanks. Yeah.
Please, sir.
Yes. Good day to you, ladies and gentlemen. My name is Luis Muñiz, and I'm just here supporting the Sheriff Ross because I think there's an injustice being done, and I think he's being railroaded. If this gentleman would have asked for a jury trial, he would have never been convicted because this is a very weak case. However, I see a lot of people that are, you know, trying to condemn him, but actually the majority of the citizens of this city voted for him, and I think that that should be considered and respected. We should go, instead of going after him, we should go after these people that are enslaving these girls in the prostitution trade and openly against their will through threat and intimidation. And I think that this city is showing a very bad side that it's unrecognizable. And a lot of people, even the people that don't like Mr. Ross, they ask me and what's going on, and they say, you know, this is unjust, and I urge you to consider, because it's making us look very bad to the rest of the country and the world. Thank you.
Good afternoon, Commissioners. My name is Darrell Lorinda Jones. I was 37th mayoral candidate for San Francisco. I was not allowed out of the box. I was immediately, after asking for protection, hauled off, my campaign papers thrown in the dumpster. My life has been living hell, and a lot of it has to do with what you consider the facts. What are the facts? Have you seen what the sheriffs do to disabled people? I have. I was nearly killed 1,000,000 times. I have had 100 bruises on me, and my domestic case, he was just put back on the street and allowed to go free after a 40-pound pack fell on me and 200 pounds fell on me. I have been, since January, held up by my whole body, held up with 3 holes in my head and a 12-inch chunk for being a seizure victim by a sheriff. Another 300-pound sheriff punched me in the head. I have had my private parts hurt. I have had everything under the sun done wrong and inhumanely done to me. These sheriffs need supervision. They have not been supervised. They have been taught torture techniques. I have come forward on a regular basis pleading. We need cameras. We need supervision. We need other than the sheriffs to be running the show in town. The law enforcement has been illegally hired. I found the man who did the psychological profile for hiring all law enforcement in California. He was obese, Brit, and 500 pounds. It is not okay. When I stood up in San Francisco and said 98% of our police, our law enforcement, if they were dogs, we would shoot them, and they are not accountable for their time, brought standing ovations. We do not have equality, we do not have justice, and we cannot have it until we have a transparent society, until we have equality and justice for all. I do not have any criminal record, but I have been arrested 55 times. I have been choked and stabbed.
Thank you, ma'am.
Injustice in America. Support Ross Mirkarimi. We need that.
Thank you, Commissioners. I will be brief, which you might appreciate considering the line outside. My name is Cynthia Cruz, and I'm here with the League of Pissed Off Voters. I just want to say first that our criminal justice system is broken. We lock people up and we throw away the key. And one of the I guess the thing that happens, or one of the results of that, is that the U.S. has the largest incarceration rate in the world. The League of Pissed Off Voters supported Sheriff Mirkarimi because he's committed to changing that. It's brutal irony to watch this zero-tolerance policy applied to this case and leading to his removal from office. We are very uncomfortable with a democratically elected official being unilaterally ousted from office by his political opponents. We're disturbed by the report that Mayor Lee committed perjury in his testimony. We ask that the Ethics Commission recommend that Mirkarimi be reinstated as sheriff. We don't believe Mirkarimi's misdemeanor rises to the level of official misconduct, and we ask the Commission to fully investigate the Mayor's perjury charges. Thank you so much.
Thank you. Just a couple of seconds. My name is Gilberto Ramos. I've been here in this case for the last several months by the radio in Spanish, Marco Gutierrez. Then I said that this case of Mr. Mirkarimi, I say that, well, it's a wrong case. He has to come back to his job like a sheriff. And it's injusto, I'm sorry with my Spanish, es injusto como lo están tratando al señor Mirkarimi. Él tiene que regresar a su trabajo. Es un caso de a cualquiera le puede suceder, un caso que aparentemente hubo una violencia doméstica, pero al final se ha demostrado, he escuchado a la esposa una esposa muy digna, muy decente, y es un caso que a cualquiera, como seres humanos que somos, nos puede suceder. Él necesita al señor Tanine to come back to his job, and we are saying that we hope so that he come back to his job because es un caso injusto. Muchas gracias.
This one? Okay, thank you. Mr. Mike.
Good afternoon, Commissioners. I'm sorry I can't stand and see all of you. But Ross, I've known him for at least 20 years. I worked with him in the DA's office for a very long time. He's a very respectful man and very friendly, very nice to everyone. But the thing I want to tell you, he was the supervisor for District 5. I live in District 5, and I want to tell you everything that happened in District 5, whether it was a car wreck, a fire, a shooting, a fight, an argument. He was there. I don't care what time of night it was. I don't care where it was. He was there. And he came in his pajamas, because you could see his pajamas under his jacket in the middle of the night to come and see about a child, a 15-year-old boy that got killed. He was very much concerned about this child and his family. And where I live at, if it wasn't for him, and I can't thank him enough for what he did for Marcus Garvey, Martin Luther King Co-op, and getting us the funds, fighting for us for 2 years to get the funds to renovate. We can't thank him enough. I'm speaking for Marcus Garvey, Martin Luther King Co-op. I am speaking for the people in the Western Addition that couldn't make it, but I was going to come if I had to crawl. He's a good person. He's done everything. And I'm going to tell you something. He's going to be a good sheriff. I'm going to tell you why. Because he's got the heart for it. He's compassionate, but he's strong. He don't take no crap. And he know when you fooling him and messing around with his mind, he's not going to allow that. And he's going to do things correct and in order. As District 5 supervisor, that's what he did. He kept things in order, and it has not been the same since he has left. And I'm begging you,
Thank you, ma'am, for your comment.
help us to keep him as sheriff. And I love him to death.
Thanks very much.
I love him to death. Love him too.
Good afternoon, Commissioners, and thank you. My name is Lori Lederman. The Mayor's charges of official misconduct against Sheriff Mirkarimi have resulted in an excruciating demonstration of the abuse of public resources to justify an unwarranted decision by the Mayor to undo a democratic election and to destroy a family. Did the Mayor not consider these two extremely serious consequences of his actions, or did he in fact intend to cause these results? And yet, he made his decision without the most minimal reasonable investigation. He failed to even speak with Eliana Lopez. And then, after taking this extreme action, he sought justification and evidence. And, as the evidence failed to materialize, the charges repeatedly fluctuated. The only evidence is that Mirkarimi pled guilty to false imprisonment, and for that, he is serving his sentence. There is no evidence of witness dissuasion. The city attorney wants you to believe that messages and communications between Lopez, Peralta, Haynes, and Mirkarimi constitute witness dissuasion. Of which witness? They are only evidence of a very upset Lopez, deeply betrayed by her neighbor, trying to reach her husband and seeking advice and support from someone who she knew to be knowledgeable. Who would do otherwise in that situation? The December 31st incident was addressed through the criminal justice process. Mirkarimi is serving his sentence, meeting all of its requirements, none of which would interfere with him performing his job had he been permitted to do so. In fact, he did perform his job throughout the media circus and criminal justice proceedings, and as he testified, made significant progress during that short period in spite of the ongoing deluge of media attacks. Should Ross have chosen some different words or made some different choices during this entire period of time? Maybe so. But any of those occasions when he might have chosen a different sentence, do they amount to official misconduct? I am sure that you commissioners cannot possibly arrive at that conclusion. And by the way, the mayor, too, should have made some other choices, both in word and in deed. If we believe that domestic violence classes work, and why would we require them if we didn't believe that, then we must believe in rehabilitation and redemption.
Thank you.
Commissioners, my name is Dennis Moscovian. I'm a native San Franciscan, and I followed the hearing all the way. Attorney Keith told you to interpret common sense this morning when the chairman asked him as to how he should interpret it, as in part what experts tell you to think. So allow me to offer some common sense, and I'm just a citizen. The wrongful grabbing of Eliana's arm does not rise to the removal from an elected office. There was plenty of innuendo, but no evidence of a pattern of violent conduct. In response to the actual charges, Sheriff Mirkarimi reached a plea deal, which all DAs try to get, pled guilty, and has been diligently engaged in a rehabilitative therapy ever since. So how does the Ethics Commission justify demanding an extraction of more flesh? As for dissuasion of witnesses, again, there was innuendo, but no evidence and clear testimony to the contrary. Moreover, the mayor's case rests on a witness who did not appear, was not cross-examined, and whose counsel told the commission, because I heard it, Ivory wants minimum exposure. Despite her planning to involve D.A. Gascon, Police Chief Sir, Phil Bronstein, Kamala Harris, and Gavin Newsom, which is a clue that there was a great deal of political undercurrent behind this. By contrast, most ordinary citizens like myself interpret lying under oath as serious, especially when somebody is as important as the mayor might have done it. Lying under oath by an elected official is certainly official misconduct, even if you can use legalisms and distort the English language to say it's all irrelevant to what happened on December 31st or subsequently. But if one interprets the lies as going to motivation for removing the sheriff from his office, then the possible perjury goes to right action and decency, which are explicitly required of all public officials, a standard the mayor himself refused to agree applied to himself.
Thank you, sir.
Good afternoon, Commissioners. My name is Danielle Irville, and I would like to see Ross reinstated to his job as sheriff. I believe that domestic violence is a serious offense, and as such, am glad that the allegations in this case were brought forth and taken seriously. However, I do not believe, after all is said and done, that any serious offense was committed here, certainly none that would or should preclude Ross from serving as sheriff. We are all human, including high-level officials. We all have faults and weaknesses, and sometimes in life, those come to a head. In retrospect, it is those times in life that we are thankful for, provided we are shown the way to healing and wholeness, which has certainly been a part of this case, as well as the original intent of the Mirkarimi family. Domestic violence is about violence, but there are many other forms of violence, including being too harsh in one's judgment and being unwilling to really look into all aspects of a case. When I look closely, I do not see a reason to bar Ross from his work. And finally, as much as domestic violence cases are about violence, they should also be about compassion and learning to resolve conflict in ways that meet the needs of all parties. Here we have dealt with the offense. The root causes of the offense are being dealt with, and it is only fair that the voters of San Francisco have their sheriff back, who happens to stand for restorative justice.
Thank you.
My name is Tammy Bryan, and I'm a longtime resident of District 5, and Sheriff Mirkarimi was my supervisor for 7 years, so I do know him pretty well. I want to say to you all today that the matter at hand is whether or not he committed official misconduct, and it is clear that he did not. Official misconduct has to do with his actions related to his elected office, and this incident, nor anything that transpired afterwards, does not even come close to official misconduct. In fact, the city has done an excellent job of demonstrating that no official misconduct occurred. No matter how hard they've tried, the city has not made their case. I work for unemployment insurance, and my job is exploring the reasons why people are no longer working and determining if they qualify for unemployment based on their actions at work, the reason they're separated, based on if there was misconduct. And there was no work-related misconduct in this. I implore you to remember that your duty is to us, the voters, to be an impartial body that works for us and not those who appointed you. And finally, I survived domestic violence 2 decades ago, and I feel offended by the Domestic Violence Consortium exploiting a family crisis for their own agenda, which has nothing to do with protecting victims. The situation between the sheriff and his wife was not a criminal incident. It was only criminalized to try and remove our democratically elected sheriff. Please be independent and impartial when you make a recommendation that there was no official misconduct and removing him was wrong. Thank you.
Hi, my name's Terrence Faulkner. I'm an elected member of the San Francisco Republican Central Committee most of the time since 1974. I've also served on a couple of your minor commissions locally, and I was Republican County Chairman on occasion. I'm speaking as an individual. I attended Joe Mazzola's trial the last time there was a removal like this. And like the Joe Mazzola trial, he was an airport commissioner who offended George Moscone because there was in that case there was a union strike and he was an official of the plumbers union. In this case, Mirkarimi did not have the mayor's support when he ran for sheriff. He's not part of the so-called establishment or machine or whatever you want to call it. His offenses are really political in nature. They're not criminal, etc. The whole situation is one which just reeks with politics at its worst. I strongly urge that you not vote to remove the sheriff. He was legally elected. Nothing that happened in the unfortunate dispute with himself and his wife had anything to do with the office of sheriff. He was not even an office of sheriff at the time when the disputes occurred. Frankly, some of the problems of a guy being a little bit bigger than a woman and sometimes can accidentally being able to do a little damage without intending to do it. I mean, I can only say that happens to be facts of nature. Blame Charles Darwin, nature, and God. I know on one occasion I was out with a young woman about 20 years ago, and we were at a restaurant. She started to fall, and it was down a staircase. I just summarily grabbed her, and at first she objected. I said, honey, I just saved you from breaking your little neck. Sometimes guys are rough. Unfortunately, we're big. I don't think the sheriff should be removed. I think this is a political lynching. End of sermon.
Commissioners and members of the public, and Ross Mirkarimi. You can see me on the screen over there, Ross. I know you. I've talked to you. I was a supporter in your campaign. And I talked to you on the telephone about the program we run, Man Alive, that deals with batterer intervention. We set that program up in 1980. It's become the state standard for batterer intervention programs in California. I've worked with thousands of batterers and programs. We have trained people all over the world, even in Singapore. We have a program in Singapore, President Changi. So I met a lot of batterers and worked with them, and I keep doing the work because I'm very optimistic that if men who are violent get treatment and get help, serious help that deals with the violence, that they can certainly recover, and in the case of a public official, could resume the work he's been doing. And I hope Ross gets to do that, because he's very popular with his supporters. He has an excellent political program, but the fly in the ointment is that he violated his partner. And that's where I think, as commissioners, as citizens, we have to draw the line. There is a certain question about the willingness to do violence, particularly as a public official, when you have 80 people in your jail right now who are there specifically to stop the violence. Command influence is a very important factor. In my contracts I send out to people around the world who want to have this program, our first line is we require the entire command staff of the institution to be present for the first 4 hours of training, so that they will understand the gravity of their role in supporting the work that their prisoners is about to do. So I urge
Thank you, sir.
to take that position. Thank you.
Good afternoon. Excuse me. My name is Karen Levine. I am a retired Sheriff's Department employee of 28 years. I was 3 years as a deputy sheriff and, 25 years running programs in the jails. And I currently work with survivors, female survivors, and perpetrators of domestic violence. And there's a reason why the state set up these 52-week programs. It really requires a complete belief system change to stop violating yourself and others. And that's just the very beginning. That's just the very beginning, the 52 weeks. It is not for nothing that our formerly esteemed Sheriff Michael Hennessy had a rule that you had to be arrest-free for 1 year and off of probation in order to just enter the jail. And that is because people need to heal, people need to make restoration, and people need time to make some change. So I find it very ironic that the sheriff is somebody who would basically, under our former sheriff, not be allowed to enter the jail because of the actions that he's taken. So while I believe in redemption and hope for that redemption for Ross and his family, I do not believe that he can currently serve as sheriff. Thank you.
Hello, members of the Commission. My name is Susie Loftus, and I stand before you as a native San Franciscan, a mother of 3, and a fellow commissioner. I serve on the Police Commission, where one of the things we're charged with doing is holding law enforcement accountable for any misconduct. I served as a prosecutor in San Francisco in the domestic violence unit, and there's one thing that I really want to convey. I think something is really at stake in this conversation. I've watched it online. I've sat in some of these hearings. What's at stake is we've made tremendous progress as a criminal justice community on how we address domestic violence. We've done better at listening to victims and protecting them in the wake of tragedies, and we've done better at healing batterers. No one wants a batterer to continue to batter. But I can tell you, as a misdemeanor and felony domestic violence prosecutor, I have watched men convicted of a misdemeanor push or slap, because just because it wasn't in the papers doesn't mean we never prosecuted pushes or slaps. We did it because it's domestic violence. And I've watched men who plead guilty in court and their body changes. The moment you acknowledge the harm you caused and you stop minimizing it, you can start healing and you can start getting better. And from my experience and what I know about domestic violence, I have never seen any of that from Sheriff Mirkarimi. And we have landmark, nationally recognized programs to heal batterers, of which he would be charged with overseeing. These are men who are going to be sitting in our jails talking about how they're going to change their ways at a time when their sheriff minimized his conduct and got back to being sheriff. And I think that that's what's at stake here. We've made progress and we don't want to go back. I really hope that you'll find his official misconduct and have him removed. Thank you.
Hello, my name is Jill Zuiza. I'm the Interim Executive Director at Women Inc. It's an anti-domestic violence agency. And I want to share from our perspective what really resonates about this situation. And it's something that we've talked about a lot, our team. For a survivor to reach out for assistance, even at an agency like ours that exists to serve them, it takes a lot of guts and courage. And when setting with those clients, the majority of them don't feel comfortable sometimes reaching out to the police department, and we do a lot of work with them to try and demystify that process for them. We tell them about the laws. We can vouch for our police department. And their concern is, well, they're not going to care. You know, who cares about this? This happened in my home. This happened with my partner. Who's going to care? And our message has always been, they do care. It's against the law. And we also talk a lot about domestic violence is more than just someone grabbing someone on the arm. Domestic violence is about that pattern of power and control and that privilege that comes into, I have the right to do this to you. We do so much work with our clients to get them to the point where they are able to reach out and feel good reaching out to this vast network of services. If someone was arrested for domestic violence and they're allowed to stay at the head of this system that we vouch for, what message does that send to the people that gather the courage over years, sometimes decades, to reach out for help? Are they right? Does our criminal justice system care? We should. We all should, as citizens of this community. And I know you all do. So that's that. Thank you.
Thank you. My name is...
Excuse me one second. The level of disruption will be a problem. Maybe the...
Excuse me, it's a little bit hard for us to hear in here because of the noise outside. So I don't know if you can do something to move people further away. Thank you.
Thank you. I'm sorry. I just want to be able to hear everybody who speaks.
Thank you. Thank you for your time. My name is Deborah Hanula. I am a resident of San Francisco, but I am also an attorney and have been in good standing in Washington State. I was on the task force and formed the task force on police-perpetrated domestic violence after the murder of Crystal Judson in Tacoma, Washington. So I know this intimately. I was a public defender for many years, so I represented batterers as well. The sheriff needs to be removed. I was also a judge pro tem, and as all of us know in the position of judges, not only does it have to be fair, the person has to be fair, but there must be an appearance of fairness. There is no appearance of fairness with this sheriff. In Washington State, we formed a task force with Supreme Court Justice Barbara Madsen as my assistant, we were co-chairs. We had a task force of police, prosecutors, batterers, victims, everybody on there, 80 people, and formed the officer-involved domestic violence policies that say for every police agency in the state of Washington, you must have mandatory minimum policies in place to handle officer-involved domestic violence. I haven't seen anything like that here. You don't have that, step one. Step two, I had Diane Wettendorf, who's an expert on police-perpetrated domestic violence, come out to train the advocates, to train the police, to train the prosecutors. And when I say I mean my entire task force. I am alarmed as now a citizen of San Francisco when I see the same thing going on. No, we don't have a murder-suicide, but do we need to reach that point before we already have policies in place to handle this? I'm not going to turn to this sheriff and assist him because he hasn't been held accountable. He pled guilty to the crime, and yet he doesn't take responsibility for it.
Thank you, ma'am.
Good afternoon, Commissioners. Beverly Upton, San Francisco Domestic Violence Consortium. We are so honored to be a part of this process and be able to have public comment today. San Francisco has made huge gains over the 35 years that this work has been happening. Our homicide rate for domestic violence is down over 80%. Used to be 12 to 15 women a year died from domestic violence related injuries. Now, 1 or 2. Each one is a tragedy. San Francisco has been headed in the right direction. The facts are clear in this case. Ross Mirkarimi pled guilty and was convicted of a crime of domestic violence against his partner. He's on 3 years probation. A probationer on domestic violence probation cannot be the supervisor of one of the world's best violence intervention programs, which is what RSVP in the jails currently is. We'd like to see San Francisco continue in the direction that it's been going. We think we're headed in the right direction. We urge you to remove this sheriff. He has lost the confidence of San Francisco and is no longer fit to serve. It's an honor. When we have someone who tarnishes the badge of people who are trying to do good work, it does a disservice to us all. Thank you. The world really is watching.
Hello. My name is Sydney Hodgkinson. I've been a law student in this city, I've been a victim in this city, and I've been at a few of these hearings. With ethics so in question, such as have been the ethics of Ross Mirkarimi, I don't see how, from any of the perspectives I mentioned, he can be an adequate representative of our city. It's very hard for me to speak to you all, but coming from the perspective that I do, as people have mentioned before, when it is something such as coming forward and speaking to what has transpired, there should be no question that the law follows through. There should be no question in the head of our police department what the ethics of that department are. We're representing, the city, the victims, and so many of the other supporters that are here. Thank you for evaluating this case closely, and please consider that.
Good afternoon. My name is Orchid Pusey, and I'm here with Asian Women's Shelter with some of my coworkers behind me. And what I want to do is first thank you for your work and your time. And second, to say that I want to offer you the opportunity with arms open and heart pleading to restore my faith and trust as an advocate with fellow attorneys and community workers in the city and county of San Francisco. I want to let you know that, I will and we will lose our pride in our city if the person who is the key figure for public safety and the key leader in ensuring that systems of responsibility, of safety, and of rehabilitation are led by someone who pleads guilty in our court in San Francisco and then the same day says to the media that it was about money and saving money. That breaks my trust. It also shows to me a lack of plain old skill and initiative in being a public leader and modeling the taking of responsibility, because nothing that is harmful can change without the bravery and the courage to stand up and take responsibility. And I have been looking for that and waiting for it, and I have not seen it. I also lose my trust when someone purports and doesn't refute when others make reports that this is about a single bruise or this is about one single heated argument during the holidays, which we all know are extremely stressful. I want to say that through my work and through the work of the people who are standing behind me, which covers over 50 years across us, 50 years every day of working with survivors of violence, that survivors are terrified already, terrified to come forward and to cooperate and to seek support from the city, from the people who are supposed to keep them safe. And I want to ask, how terrified do we want to make them? Do we want to make them more terrified or less? And people who have...
Thank you, ma'am.
Thank you.
I like to use the overhead. My name is Paulette Brown, and I lost my son, Aubrey Abacasa. Could I use the overhead? To homicide. Yesterday was his anniversary of his death, August 14th, and still no justice. And I'm here to say that I'm talking for all the mothers out there. And I have this because I know I don't have a lot of time. Why are we wasting money on this when there's unsolved homicide cases out there that our families are hurting? And we need justice. We're wasting money on trying to convict the sheriff or something. When what about those people that are out there that are doing crime or killing people, and they're not being convicted of anything? Our children are still dying. I'd like to use the overhead. You have loved ones. Their parents are grieving. What do we do about these unsolved homicide cases? What do we do about it? There's my child that I have to remember laying there, and this is my son. I'll never see a graduation in my life again. There's me standing over my son, and here's my son laying here on a gurney dead. What do we do about this? We're wasting money in the wrong places. The sheriff was there when our children were murdered. Give him credit. What about that? We forgive our perpetrators that have murdered our children. What about the forgiveness of our children? We forgive them. Why are you doing this? Let him do his job and solve these cases for our children. How many times are we going to cry out there? How many times when we have somebody that will help us, but you're taking them away from us? What do? I'm not here just because of him. I'm here because of our children out here. And Ross was there when our children were laying in the street, bleeding and blood in their guts and brains are laying on the street. Look at my son. Look at him.
Thank you, ma'am.
Am I fine?
Good afternoon. My name is Ana Soto, and I am representing Padres Unidos group. I am here to ask to please put our Sheriff Ross to work, and please tell the mayor to spend our money on better stuff, like give it to the city college, for example. And this is the first time I hear that people can lose their trust and job just because he grabbed his wife by the arm. I know there are some people that did more ugly stuff in San Francisco, and they are still holding their job. You should know exactly what domestic violence is. I've been there, and it's nothing exactly like that. Please stop all of this, sir. Thank you.
Hi, my name is Beatriz. I have been a domestic violence advocate for more than 6 years. I am concerned about what this process has communicated to immigrant victims of domestic violence. Every day we are working hard to make sure that immigrants who are here from all over the world are clear about their rights and understand that in the United States they have the right to be free from violence, abuse, and control from their partners. Supposedly the law protects them. If Ross Mirkarimi is not permanently removed from office after admitting to knowingly abusing his wife, it will definitely stop women from reporting, especially immigrant women who are already scared to ask for help, afraid that no one will believe them or listen, or that they will be deported because of their immigrant status. Do the right thing, support the mayor's position. Thank you.
Hello, my name is Lucia Reagan, and I'm a family advocate for domestic violence. If Ross Mirkarimi is reinstated as San Francisco Sheriff, it will send the wrong message to victims of domestic violence. I work with victims to report their abuse to the police every day. I am deeply concerned that failing to hold Mirkarimi responsible for his actions will have a silencing effect on survivors citywide and beyond. They will be scared to come forward, afraid that their batterer will also get away with the abuse. As a result, they will stay in danger. Please really think about your recommendation to the Board of Supervisors, as victims' lives could be held in balance. I urge you to support the mayor's decision. Thank you.
My name is Barbara Marquez, and I am part of the domestic violence community.
San Francisco is a city known for taking a stand against causes that which we find important. We cannot, as a city, allow a person who has clearly abused his power and used his strength against women to work as a representative of government protection. His conviction clearly creates a conflict of interest. We as a city cannot allow a person who has pled guilty to domestic violence to represent law enforcement and expect the public to trust him. What message are we sending to other cities? If he remains sheriff, Ross Mirkarimi will set a precedent in his department about the seriousness of domestic violence and what type of behavior will be tolerated. I urge you to support the mayor's position. Thank you.
I'm an advocate for domestic violence victims, and San Francisco's domestic violence community has a proud history of working with the police, the sheriff, the district attorney, and all elected officials to create a model system to protect victims of domestic violence. San Francisco must remain the safe harbor and not allow Mirkarimi to undo that hard work and cause us to be a national embarrassment. Thank you.
I have been in the field of domestic violence for 7 years, and I'm a resident of San Francisco. And I'm deeply concerned about the message it will send to survivors and to batterers if one of our city's top public safety officials is allowed to remain in office after admitting to a domestic violence crime and while on probation for that crime. As sheriff, he is charged with overseeing the incarceration and rehabilitation of batterers, and above all, of maintaining the safety of the San Francisco community. But how can the survivors in our community feel safe if he has admitted to hurting his own partner? I urge you to support the mayor's position. Thank you.
Good afternoon. My name is Jennifer Rose, and I am both a local advocate working at La Casa. I run our shelter, and I do national work as well, training and technical assistance to programs around the country. The facts matter, and the fact is Sheriff Mirkarimi committed an act of violence. He said so himself. But context matters too. The individual charged with being the lead law enforcement officer of the city of San Francisco has put his needs in front of his families, his son, the city, and its citizens. His behavior since the incident is more disturbing to me. It's consistent with that of a man who batters. He's minimized, denied, blamed, and shown complete disregard for the consequences of his behavior. Is this the character and values of an individual we want to lead and protect our city? Is this the individual who victims will feel confident will do their very best to protect them? Is this someone who will ensure accountability?
Good afternoon. My name is Kira Milich. I have lived in San Francisco since 1996. I'm a lawyer, a former director of the Project to End Juvenile Life Without Parole. I volunteered and voted for both Ross Mirkarimi and Mayor Ed Lee. I mostly volunteered for Ross Mirkarimi because of the sheriff that I believed that he would be, and he has proven to be, which is a man that is all about accountability, restorative justice, rehabilitation, and criminal justice reform. With realignment in this state, we sorely need a sheriff who has that perspective. As far as the official misconduct proceeding, I am greatly concerned that one man can unilaterally remove an elected official from office and thereby totally disarm the democratic process. I believe Ileana, I believe Ross. When we talk about facts, we look at the people that were involved. Both of them have been very clear that there is no such concern of domestic violence, which I fully oppose domestic violence. However, I believe Ileana, I believe Ross. I would like the sheriff that our city has voted into office to be reinstated so he can do his job. Thank you very much.
Good afternoon. My name is Carl Kruth. I want to talk for a moment about principles of lenity, which is associated in court process with rules of lenity, and they apply to ambiguities in the record. And one of the things that we see in this case is a great deal of ambiguity. What I'd like to submit to you is that official misconduct must be divided into two principles and one overarching nexus. And if you look at whether Mr. Mirkarimi was in office at the time, perhaps you have some ambiguity about that. If you look at whether there was misconduct, perhaps there is some ambiguity about that as well. And if you try to find a nexus, I think you will find a glaring ambiguity. And principles of lenity should apply to these ambiguities in the record. Thank you.
Thank you very much. Thank you for the comments of the public. I think that, oh, there are still people. Why are,
I'm sorry, Commissioner, there are other people out there. I don't know, maybe they went to lunch or something. I'm sorry, now my friends are now.
okay. I don't know. How many more are out there? Roughly 30 more? I think we should continue. Let's continue. Please.
Good afternoon. My name is Kathy Black, and I'm the Executive Director of La Casa de las Madres. Domestic violence is a serious public health and public safety problem. It defies common sense that a sheriff convicted of a domestic violence crime would then oversee the incarceration and rehabilitation of others convicted of these crimes. I am concerned about the message it'll send to survivors and batterers if one of our city's top public safety officials is allowed to remain in office after admitting to a domestic violence crime. This is bigger than one case. This is about survivor safety and batterer accountability. It is about showing our community that San Francisco will prioritize safety, the safety of victims and survivors, and take domestic violence seriously, no matter who is perpetrating it. Any sheriff who has pled guilty to false imprisonment, admitted under oath that he committed a violent act against his wife, and that at the time he did it, he knew it was a crime, is not fit to be sheriff. Thank you very much.
Good afternoon, Commissioners. My name is Catherine Berg. I'm the Associate Director of La Casa de las Madres. I'm a San Franciscan, and I've been an anti-domestic violence advocate for more than 10 years. I'm disturbed by the repeated efforts to minimize the crime of domestic violence. The arguments you've heard from Mirkarimi's team roll back more than 35 years of developing expertise, understanding, and protections for victims, survivors, and perpetrators of domestic violence. Ross Mirkarimi admitted to committing a violent act against his wife. He admitted that when he did it, he knew he was breaking the law. He pled guilty to false imprisonment in a domestic violence case. Will you tell San Franciscans and those around the country who are watching this process that the perpetration of a crime rooted in the abuse of power and control by a former San Francisco supervisor and a sheriff-elect does not fall below an acceptable standard of decency? The facts do matter. There is a conflict of interest inherent in his knowingly committing this crime. There is a conflict in claims of contrition refuted by an unwillingness to take responsibility and blaming others for the consequences of your choices and your actions. I urge you to let the facts stand and support the mayor's position.
Good afternoon, Commissioners. Thank you for your patience. My name is Sharon Johnson. I am the former director of the Commission on the Status of Women from 1989 to 1994. I worked as a legislative aide in City Hall in 1979 through 1987. And I am here because in 1981, when I was a legislative aide for a then supervisor, we wrote a letter to the Commission on the Status of Women asking them to please give money to the Family Violence Prevention Fund, which is now Futures Without Violence, to use specifically for messaging that domestic violence is not a private nor family matter. It is a matter of public safety and public health. For all these many years, we have worked hard to have that just roll off the tongues of our elected officials, the officers of our city and county, to be aware of the fact that domestic violence is a very serious matter. And since that time, we're happy to say that many homicides have decreased. In 1990, when I was the executive director of the Commission on the Status of Women, we started a report called the Venus Sharon Report. And it was the first case study that we did regarding domestic violence for a woman who had gone through all the traditional procedures of restraining orders, and she, for a 12-month period and 15th-month period after her husband was released, he shot and killed her. Through that report, we were able to do a lot of changing city county policies. I hope that you will honor the hard work that many women and men have done for the past 40 years on domestic violence. Thank you.
Good afternoon. My name is Chrissy Kiefer. I'm an artist, an activist, and a mother. One of the most profound plays of the 20th century is Arthur Miller's The Crucible. Miller brilliantly commented on human morals, authority, and mass hysteria. He parallels the events of Salem in 1600 to the blacklisting and discrimination against those labeled as a communist during the 50s. This play shows how mass hysteria can sweep an entire community and erase all logical thought and rationality. The climax is the yellow bird scene where young women in a courtroom pretend to see a bird in the rafters. Their hysteria whips up jealousy, frustration, and vulgar revenge, transforming a sound and tranquil town into one that is predominated by revenge. This is how I felt about the initial press coverage and the charges of the mayor and the actions of the DV advocates as they bonded and pointed fingers at their own yellow bird. Seeing something that was not there, demanding vengeance, shocking to watch as they made every effort to destroy a family, a career, the wishes of the voters, not unlike some hysterical 16th century witch hunt. I, for one, do think this has been a witch hunt and a very scary precedent for all members of our community. If what can happen between Ross and Ileana can become front-page news, many San Franciscans should run for cover or move out of town. Mr. Mirkarimi was tried in the press, then tried in the courts, and now being tried in the Ethics Commission, and then tried at the Board of Supervisors over a bruise. Not one thing about this has advanced the understanding of violence against women. People are so outraged, but where's the outrage about the assassination of abortion doctor George Tiller in Colorado? How many articles are there in the Chronicle about the rape of women in the Congo? When we entered into arms deal with Saudi Arabia for $12 billion, did anyone bring up the fact that women are second-class citizens? Do we even know that 13 Republican men in the Senate recently voted against the reauthorization of the Violence Against Women Act? And yet this is where our progressive city wants to put their time and money. As a feminist, most troubling for me is using women's issues to cut this progressive politician to his knees. This is the oldest trick in the book. And interesting, today Ecuador gave Julian Assange asylum. Please put this to rest by doing what is the most important for the future of San Francisco. Give us back our world-class status as a city that takes seriously the real issues of domestic violence and respects the will of the voters.
Good afternoon, members of the Commission. Mr. President, good afternoon. My name is Arthur Murillo, and I am a Hispanic transgender woman. I am also an elected delegate to the 2012 Democratic National Convention, and I'm here today to express my support for Sheriff Ross Mirkarimi. I believe that the evidence presented against him does not warrant his removal from office. The public elected him overwhelmingly. He's a very popular sheriff in our community, and he's the kind of sheriff that makes me feel safe. Given that there's a lot of trafficking of women in the United States, and some say here in San Francisco, I would ask that all this efforts that have been put towards Ross be put towards all these crimes that are being put against women, that are being forced to work, much human, serious crimes. And I think that we are misdirecting our efforts here. I would ask that we reevaluate the situation and hold hearings on other matters that are of severe concern to the city and county of San Francisco. Thank you for your time. Have a great day.
Hi, my name is Lindsay Vurick, and my son-in-law was a member of the San Francisco Police Department, and he thinks this is a travesty because he knows of so many instances that were much more severe that are not prosecuted there, and this is a very minor domestic violence case. And so it's somewhat of a, I can only see it as a consolidation of power, political power kind of effort. And the last hearing, there was very instructive testimony by a lesbian woman who was actually has credentials as a domestic violence worker. And in her case, she was one of the first people to talk to Ileana, with Ileana hearing in the background, Ileana begging them not to call the police. And so this is a case that's been blown way out of proportion and cost the taxpayers a lot of money, and it isn't about domestic violence. It's way disproportionate and destroying a family and a child too. So I hope you consider that in your vote. Thank you for your time.
Good afternoon. My name is Jeff Myers, and I have not prepared any remarks. I hope you'll be refreshed to know that. I don't want to repeat any of the accusations, any of the critiques of procedure or the interests that have been represented here. I merely want to be here to testify as to the absolute probity of Ross under every circumstance where I've ever seen him engaged. He has always, in my sight, been the perfect advocate for women's rights, for the sensitivity to all minority and disadvantaged people. And I've seen that borne out in long periods that I've spent alone with him and Theo. And I've seen Theo do things that didn't please Ross. And I've seen how perfectly, calmly Theo could accept the judicious parenting that Ross offers. This is a sensitive, kind man, and whatever the accusers have suggested about him, I suggested it is absolutely false. Thank you.
Good afternoon, Commissioners. My name is Catherine Howard. I have known Ross Mirkarimi for years, and I believe he will be a good sheriff. I support reinstating him as sheriff. A great deal of press has been spent on this issue. How many of us would have been able to hold up to the assault in the press? This has been a political witch hunt. I hope that you will be able to look at this objectively. To prove that you are objective, I hope you will also put the same energy into other matters that have been referred to this commission, specifically Sunshine Complaint number 11049, George Wooding versus the Recreation and Parks Department, notice and referral for willful failure and official misconduct. This complaint was forwarded to you on December 5th, 2011 by the Sunshine Ordinance Task Force and has yet to be heard by this commission. I respectfully ask you, why is that? I ask you to show everyone you are not today following a political agenda. Please follow up on the complaint I mentioned, 11049, and this will show that you are trying to follow your hearts. And please reinstate Ross Mirkarimi. Thank you.
Good afternoon, Commissioners. My name is Michael O'Connor. I am a local small business person. I just finished 2 terms on the Small Business Commission, and I'm a resident of District 5. I have witnessed the above and beyond Call of Duty approach that Supervisor Mirkarimi, then Supervisor Mirkarimi, took to our district. We saw him showing up nightly in the middle of the night at murder scenes, homicide scenes, because he wanted to be front and center and put his incredible passion and commitment to our district at the front. And he worked as hard as anybody in this building. Speaking as a commissioner, former commissioner, I would ask that everyone in this, all 5 of you, really, really look at yourself, and you cannot call in this vote. You cannot listen to upstairs. You cannot you have to go with your conscience on this. And this man is a good man. He made a mistake. All of us, at some point in time, we're not perfect. But under no circumstance can these votes be called in. I saw it on my commission. I had no interest in staying on my commission. Another great commissioner quit my commission because we saw evidence of votes being called in because commissioners were being told how to vote from upstairs. That cannot happen in this hearing. This is a good person. He has a right to retain his position as sheriff. Thank you.
Hi, my name is Jim Warshell. I've had the privilege of knowing Ross for over 7 years. He was my supervisor, and I aggressively supported him in his run for sheriff. When I walked into the room, there was 6 speakers ago, a very impassioned woman speaking in Ross's behalf, and I could make my comments very simple by saying ditto to everything she said. Instead, I'd like to take this from a slightly different point of view. I also serve on the district attorney's community board on hearing low-level crimes and getting them resolved through a restorative justice process. We had a luncheon where he brought in a speaker from Oakland who gave a very informative speech about how restorative justice is really what we're after, not only in low-level misdemeanors and infractions, but even they should be front and center in our mind in more important crimes. Afterwards at the luncheon, I asked the district attorney, isn't this almost a poster child case of, clearly something happened here, and now we have a wonderful person, loves his wife, loves his child, is well suited to this job. Shouldn't we be seeking to find restorative justice so we all move forward constructively? He said yes. As soon as Ross pleads guilty to something, then we can have the restorative process begin. I would look to you to think about where is restoration. Ileana clearly wants him to keep his post. The public is very, very strongly behind him. Look to the restorative thing. Here we have a fabulous public servant who is dedicated, a loving husband and father, and we look to you so that this can move forward in a restorative and constructive.
Hi, good afternoon, Commission. My name is Richard Stone. I'll speak as both as an individual and as a member of the San Francisco Green Party. And I, throughout the years, ever since becoming a Green on the day that that the United States decided that for some reason they invade Afghanistan, I have worked on many campaigns. Both Greens and Democrats and Independents alike, and including Ross's in 2004. I worked out of his office, 2004 and 5, eventually became aware that to use the term that the previous gentleman used, that restorative justice was a hallmark in a lot of his. Of the legislation and issues that he worked on, and ever since the incident between him and Ileana happened, I have seen the party that I work for going from a position of doubt, especially amongst some of the female members of our party and for people who are strong advocates for domestic violence, to understand that as everything unwound, that you basically have 2 separate issues here. It's the issue of domestic violence, which me and most of the doubters that I know of who now believe that he's actually taken due course in doing it, and but most of all, I believe that in terms of the Green Party, we would like to see Ross reinstated to his position, because we believe that's the that's the way that that the things have the process is unraveled, and we believe that the process is two different issues, and that is his. And that is the domestic violence part, which we believe he's dealing with, and the fact that that he's.
Hi, my name is Manashek Barry. I'm a civil engineer practicing in San Francisco. I don't know Mr. Mirkarimi personally, but I follow what happened. The question is question of ethic, and I'm sure you all are ethical person. Even unethical person thinks that he or she is ethical person. But the question of ethic is not what you think. You have to be in a position and act as an ethical person. I watched Mirkarimi during the whole process. I've seen him very ethical, very gentleman through the whole process. I have not seen anybody even coming close to him as his action being ethical. So I hope you consider that rather than what the book says, what you think and all that, him in action. Just follow what he's done during the whole process, and he's seen a lot of injustice, but he acted very ethically. Thanks very much.
Hi, good afternoon. Barry, Toronto. I actually live in San Rafael, but I have been following this hearings online at the same time, and also looking at your backgrounds, because on the website you have your biographies. And I want to point out that each of you are appointed by a different entity. And unfortunately, 3 of you are appointed by parties that have a very important concern in this process. So I think it's important, whatever your decision is, that you need to talk about the fact that the person who appointed you may decide that you may not be wanted to stay on this commission. I have had some qualms about this commission because I had filed a couple of complaints about a former MTA board member who's no longer on the board, who actually ended up helping bring a lawsuit against the city as a result of some of his participation in the process, so of putting sticking his nose where he shouldn't. And I asked for your help in this, and I got some help from staff, but it should have gone further. So I'm really so my concern is that you are supposed to deal with ethics and not with politics, and that is the truth. You're not supposed to bring politics into it, and if you do, you need to acknowledge it, that is going to affect your opinion. And regarding Ross Mirkarimi, I watched the witness, Eliana Lopez. In Yiddish we have a word, what a shena punim. What a beautiful face. What a spiritual human being. And to take her testimony as a joke, as not the fact that this is a strong person, she can take care of herself. Then if you don't take that into account, and this just became a political ploy because people were disappointed in the election. Thank you for your time, and good luck in your decision. Thank you.
Commissioners, my name is Deborah Walker. I stand here in support of Ross Mirkarimi, Eliana Lopez, and Theo, the family that's been most affected by this whole process. I've paid attention. I've watched as the questions were asked by you all. This is a process that should never have happened. And everything after that fact has basically been created to justify a bad act. Initially, there should not have been harshness between people who love each other. As people who have families, you probably understand it gets to that point. But this process, especially the removal of an elected official, should never have begun. I really feel for you because it was begun, and you have had to go through the process of wading through the mountains of evidence. I sit as a commissioner. I understand that you really have the law to look at here, and that is really what I suggest that you do. The facts from the people who were there, Ross and Ileana, are the only people whose evidence or whose testimony matters here. And what we are seeing now, and what we saw from the beginning of this case, is the piling on to justify the I think, irresponsible act of putting this forward. As a voter in San Francisco, as someone who actually voted for Ross Mirkarimi every time he's run, I ask you to honor my vote and the vote of over 85,000 other people who asked to have this man as our sheriff. Certainly, this process has punished not just Ross, but Ileana and Theo as well. And you have the power now to stop it and to restore some sanity, which I think not referring this case on would do. Thank you.
Thank you.
Good afternoon, Commissioners. My name is Michael Tong. I'm a city resident and a supporter of Ross Mirkarimi. Thank you very much for letting me speak, and thank you very much for all the work that you do on this. I know it hasn't been an easy process, but people really appreciate what you're doing. I've watched these proceedings from the beginning, and I think, well, one thing I had to talk, just as a side note, I was here during the bomb threat for the mayor, and it kind of would have been nice if you told some of us about it. I mean, so we could have left. Just so we didn't get blown up, but whatever. I think I've been watching this, and it seems like what's been going on here is you had two people who had a personal problem that didn't want to be turned into a reality show, and it's been kind of taken advantage of. Sheriff Mirkarimi was duly elected, and he was elected by the people, and I think it should be supported, and I think we should actually abide by that. And if the people do want to try a recall vote, they can. But I think he has the support of hundreds of us voters, and as you can see by here today, by having to list through the testimony, you can see that. So I would urge you to vote to not uphold these charges. Thank you very much.
Good afternoon, Commissioner.
You can raise the mic if it moves.
Good afternoon, all the Commissioner. I come here to stand for the truth and justice for all, and I think I stand for Ross Mirkarimi on this matter. And I want to read something for you here that I made. I think Mr. Ross Mirkarimi have already pleaded guilty of the lesser crime of domestic violence, and as such, he had been cited and met the 3-month suspension for his job as a sheriff. To think that he should be permanently removed from his position as elected official, to my opinion, constitute double jeopardy. No man should be tried twice for the same crime, if this is a crime we call. As just a reminder, there are 3 basic requirements for removing an official or for voluntary vacation, which are, to me, which I learned from the books, which are gross negligence, disability, and gross incompetence. I think we should not try a family here. We should promote family unity. And if the wife stands for his husband, then no law should jeopardize that interest for the sake of justice and truth. Thank you very much.
Hi, my name is Michael Sandberg. I live in District 5, and I'm a 35-year resident of San Francisco. I'd like to ask the people on the Ethics Commission whether during their lives they have never done anything which they regret, something that happened out of anger, possibly, or something that happened out of greed or maybe even out of stupidity. I wonder if there's anybody on the Ethics Commission that will answer that. This is part of what we're facing now. I feel this is a political case, getting back to reality. I know there are other factors involved, but to me, this boils down to a political case. There are people in the city, whether it's the San Francisco Chronicle, the mayor, Willie Brown, Rose Pack, et cetera, who have been forcing this as an issue from the get-go. When the Chronicle had editorials every day for the first couple of weeks, I knew there was something fishy going on, and that this was much more than just a case of the sheriff-elect getting into an argument with his wife. So I hope, you know, I don't know your background. I don't know the background of the commission and what politics are involved in the commission, but I just hope you make the right decision, because if you don't, I feel there will be a very, very strong movement against the mayor and against the policies that have brought this on. Thank you.
Hi, my name is Helena Brook, and I'll be brief. I really like Ross Mirkarimi, and I really like the work that he did as a supervisor, but in the position of one of the top law enforcement people in the city of San Francisco, I wonder, as a woman, how if I were in a situation with a husband who was abusing me, and I said, that's it, I'm going to get out, and he said to me, the sheriff didn't, you know, they let him keep his job. You think anyone's going to listen to you? So I think we really need to think about the position that he has and the message that that gives about our city. Thank you, and to its residents.
Thank you. Can I ask for a status update as to how many people are outside? 8 more?
Is it possible to say that no one...
Can we bring everyone who's in line right now into the room? I'd like to say that I appreciate the comments of the public. It's the public's right to participate in this process. It is an important and integral part of the process. The comments, of course, are not evidence, and I have noticed that some of the comments have become fairly repetitive. Of course, we are not in any way going to limit your right to participate, but I would urge, if there are some who feel that their comments have already been made through the voice of others, you would help us in our efforts to hopefully bring an end to this process today, if some of you would consider foregoing the opportunity to continue to speak. Again, I want to be crystal clear that I am not limiting your right to be here. I just ask that in light of the probably lengthy deliberation that we have to conduct today, it would be, I would appreciate your consideration in thinking about deferring to others. Okay. And speaking briefly, if that's possible. Thank you. Please proceed.
Good afternoon, supervisors. My name is Guadalupe Ciordia Ortiz. I came here today on behalf of Comité de Padres Unidos. This is a grassroots organization here in the city of immigrants. And Mr. is right. I'm not going to take any more of your time repeating what you know already. I'm here today to appeal to the sense of justice that you might have inside of you. You were here and you are here today because you were rightfully elected for us, the citizens of this city. It is the same as we did with our sheriff. We need him back to work. We need him to start working for us. That's why he won the elections, and I want you to consider that, because next time might be one of you, and we have to stand here for you too. We are going to come and say, wait a minute, this is unfair. Please don't do this. I'm here to support Ross Mirkarimi because we need him right there at his post, and I hope you do something about that. We hope. It's not me. As a Latina immigrant, I feel highly disrespected by all these people, where all these organizations here in the city of San Francisco supporting families in domestic violence. This is not a case of domestic violence. We're everybody. We need this family together. We need all of this to be done in the right and just way. And thank you very much for your attention and consideration today.
Hi, good evening. My name is Michelle White. I am here to stand for not only Ross Mirkarimi, but for the family and for any of you that would be in this case or going through a situation like this, because I think he's done an incredible work as a supervisor, and I don't want to extend much, but I really appeal for you to consider his career, his thoughts, and the benefit for the community that he would bring and that he has brought all through his career. Thank you very much.
Honorable Commissioners, Eileen Hansen, former Ethics Commissioner, and I want, first of all, to thank you for your service. I know the kind of time and energy this takes, and I understand there are tremendous pressures on you, so thank you for your professionalism and your fairness. I had not intended to speak today, but I was struck by something I heard earlier, which is that both parties concur that relation of duties is key to whether official misconduct occurred. So we know that with regard to misconduct, that has to be related to carrying out the duties of the office. Conduct unbecoming maybe wasn't so clear, but what I heard today was that both parties concur, as I do, that both wings, both prongs of official misconduct have to be related to the duties of the office. I do not believe that this case rises to the level of official misconduct because I do not believe that the behavior or the conduct are related to carrying out the duties of this office. I ask that you concur with the parties and find that no official misconduct occurred. I do not believe this case is about whether domestic violence occurred. I don't think we need to recharge that case. Supervisor, the sheriff pleaded guilty to a related charge. That's concluded in my mind. I don't believe this is about whether you are minimizing domestic violence. I believe this is about official misconduct, and I don't believe it occurred. Thank you.
Nice to see you, Ms. Hansen.
Thank you.
Good afternoon. My name is Ernestine Weiss, and I'm here to talk about official misconduct. This is not official misconduct. He wasn't an official yet, so it has nothing to do with his job. He is a decent man. I can tell you about domestic violence when I had an infant in my arms and my husband shoved me. That is violence, not a little tug of the arm. Come on, let's be reasonable and understand what justice is. If Willie Brown could father a child in office at 68 years old as a grandfather, didn't get a slap on the wrist. Gavin Newsom had an affair in the office, took drugs and alcohol, not a slap on the wrist. How can you call this misconduct in comparison? How can you sit there and judge this man? This is wrong from the beginning to the end. Please use your good judgment and sit there and weigh the facts. This is not official misconduct. It's not violence because I had a little bruise on my arm from something else. That's no proof. You weren't there. You weren't there. You didn't see how hard it was or how little it was. So some people bruise very quickly and easily. That's no proof of violence. So come on, use your good judgment and be fair. This is not justice. If Willie Brown and Gavin Newsom, who were mayor, could get away with that, and here you're trying to hang this man up unreasonably. How dare you sit here in judgment of a man? Think of your conscience. What if you were in that position? It's not fair. You have to equalize the justice scales, right? I'm not a lawyer, but I know a lot about the law. So do your job and tell this man he's to report for work as soon as possible.
Okay, before we move on, I appreciate that members of the public are going to have reactions to things that are said. This is public comment. This is not evidence. So I feel like we can have a little bit of more reactions than we can in other parts. But please respect the speaker. Please respect this process, and let's not sort of delay things by having lengthy outbursts, please. Thank you.
Hello, Mr. Hur. My name is Francisco, and I'm standing here on behalf of our sheriff,
Speaking to the microphone, I'm having trouble.
Mr. Mirkarimi.
Use the microphone, sir.
Okay. Thank you. Our sheriff, Ross Mirkarimi, and his wife and his little boy. And I hope you stand on family's unity, family's values, family's rights, and human rights first and all. Like the lady who precedes me talk about justice, I think justice has to be taking care as a justice. Yes, if you take the perjury issues in count. It's not, and then the Commission is not ready to take on our sheriff last rule. I mean that we as an immigrant support him, and we work so hard to make him elected because he stands against a brutal, secure communities, against our immigrants. And then that's why we stand and we support him, and he is our man in the San Francisco City Hall. And I want to also congratulate the attorneys, the lady for Ileana Lopez, and also the attorneys for Mr. Our Sheriff. They just did a very good job, and I hope, please, keep fighting, don't give up. We are behind you. Thank you.
Hello, my name is James. I volunteer down at United Players. It's an organization to help kids stay off the streets, San Francisco. Not too long ago, there was a community event called Silence the Violence, which this man, Ross, spoke. He inspired me, and I believe that he's being wrongfully accused here of all allegations. This man is a compassionate man. He has his heart in helping people in the city, communities, which I don't believe a lot of people do nowadays. So I'd hope you keep that in mind. God bless you all.
Thank you, ex-commissions, for having me speak. And I'm glad to see Ross back with his wife and his family. I'm the executive director of a youth program called United Players that we're working in a lot of parts of San Francisco. And, personally, I don't know what happened. Don't nobody know what happened, except him, his wife, and God. I don't think nobody should put judgment on anybody. You know, it says in the Bible, if I tell you you got a splint in your eye, what about the log in your eye? Well, now, I'm not here to speak about all the issues. I'm just here to speak on what I know about this man personally. You know, I've been doing this 17 years now, and for me to come out and speak for somebody to support him, it's serious to me. And I truly believe the actions that I have seen Ross do in the communities of San Francisco has saved lives. The streets speak about Ross. They are out there, the families, the kids, the mothers. They really see how much of an impact that he made on the people out there when he was district supervisor. He has always came out and demonstrated through his actions that he cared for the people. And I see, you know, how much it affects somebody when you take your kids away from somebody, because it almost happened to me. So I commend that brother. We need our sheriff back. There's a lot of violence going on the streets. We need somebody who's a leader like him to step up. We need him back. I just want to say this, and I'm going to finish. You know, there's something about forgiveness. A lot of people don't know about forgiveness, but when you forgive others, God will forgive you for your stuff. I love San Francisco, and I'm sure Ross loves San Francisco through his actions. But does San Francisco got love for Ross? Thank you.
Good afternoon, ladies and gentlemen. I met our sheriff or district supervisor last year when I first met him at the Silence the Violence. My husband was the 6th homicide last year. To see an official, a city official, somebody that sits on the board, come to where we're at out there and care and give time to us to hear our stories and comfort us, not for votes, but because he truly cared, meant a lot to me. And don't I have a right to vote? Because everything I voted for, you people, I'm not going to say specifically, you push it out. Go on City Hall, people in the office drinking white substances everywhere, but they move to higher seats on panels. People that keep it real and stay with the people and care and try to make communities grow and prosper instead of destroy and locked out, how come they get left out and pushed out? I have a 4-year-old daughter and a 16-year-old son, and their daddy is in heaven. This gentleman's lawfully wedded wife and his son can't even be with him because of political smearing. It needs to stop. People like that care. We need law enforcement that cares about what happens in the communities, that has a strong hand in the law force, not for votes, not for pretend, not for shiny stars, because they care. God bless.
Good afternoon. My name's Anita Ann Lucretia Cabrera. I'm a citizen here in San Francisco. I teach. I've been teaching at San Francisco State University for 16 years, and I have 3 sons. And the first time I met Ross, he said to me, "You're not very politically involved, are you?" I said, "Not really. I like to teach my students about politics, about the process. We listen to both sides. We listen to all sorts of texts and analyze them. We talk about discussion. We talk about spin. We try to look at euphemisms and that kind of thing." And my children, though, are more politically active than I am, and they got really caught up in the campaign. And during that campaign, I got to meet all these constituents from all over San Francisco, men and women from all sorts of economic and educational backgrounds and from all sorts of causes and groups. And to a person, they were behind Ross because of what he did, not because of what he said, but because of how he changed their lives. And I became a pretty big supporter of Ross myself. And then when this incident happened, and I got to witness the way the Chronicle handled it, the way Mayor Ed Lee handled it, the way the supervisors handled it, I lost my faith again in politics. And I can't believe that anyone, after the Joanne Hayes White incident several years ago, my God, that this man is being hung out to dry like this. I just ask that you guys find it within yourself that we as citizens depend on politicians to break the stereotypes that so often we have of them. Do you know what I mean? I wasn't ready to speak, but I just hope that you look and listen to what the people have said and do the right thing. Thank you.
Hello, Commissioners. My name is Babette Hogan, and I'm an 8th-generation San Franciscan and a resident of the 5th District for over 12 years, during which time I've gotten to see a lot of Ross's work. And I have to say, when I first moved to that district, I was a little afraid of my neighborhood. But that was quickly overcome, in part, by the great work that Ross did on the streets in my hood. So I am very appreciative of his work. I would like to also speak to you as a media professional who has not all too recently been falsely arrested in a whole other state, where the conditions between journalists and the Sheriff's Department is not quite so easy. I'd like to commend the relationship that our police officers hold with the citizens of San Francisco. We have a fabulous, fabulous county, and I'm very proud of it. I do not believe that our media has properly represented what has gone on, and for that I am ashamed of our media. Our First Amendment rights are insulted when paid advocates can come and make their arguments for a national case using a case that is completely taken out of context and out of reality for political gain. I ask that you consider true and long-term democracy for our city and county, of which I am very proud. Thank you very much.
Good afternoon. My name is Zarek Shapiro. I'm a lawyer here in the city. The question before us, before you, is whether or not our sheriff committed official misconduct. Official misconduct, if we look at the plain language of the term, means misconduct by one who's in office. He was not in office. Therefore, he cannot commit official misconduct. I mean, what official misconduct would mean if he had been in office, that's another question. That question is not one you really ask to answer. The question is whether he committed official misconduct. And Ross, who I've known for a long time, did not commit official misconduct because he wasn't in office. It's that simple. He's done an awful lot of good for the city as a supervisor, as a leader, as a sheriff, and I would ask that you reinstate him in office. Thank you.
Hi, I'm Jeannie Maher, like so many others, a resident of this city, and I want to thank you all for the time that you have devoted to this matter, and I don't envy you having to have done that, but thank you again. I think that we've heard some very thoughtful comments from a number of people on both sides. I did hear a supporter of Ross Mirkarimi tell me that at the end of this process, we will find a man much better than he began. And I can only hope that that is the case. I think that that is possibly the only thing that we and his family can do is hope that he will find from this experience that his conduct was not becoming to whether he is sheriff designate or sheriff. I cannot imagine that someone incarcerated in the jail for domestic violence would want to sit and listen to him talk to them about what they should avoid doing. I don't know that that is possible. And I really beg you to consider what it is that you have to decide and what you have to refer on to the Board of Supervisors and the outcome of your action. Thank you.
Good afternoon. My name is Tracy Brown, and I came before you to share the Latino Democratic Club resolution in support of keeping Ross Mirkarimi for sheriff. This case really comes down to two women and their truth, my friends Ileana Lopez and Lynette Peralta Haynes. These are two women with small children, two women whose lives have been torn apart over this whole tragic series of events. This is a San Francisco that belongs to families. This is a San Francisco that values families, and yet this is a San Francisco that has went after two women with families and almost drove them away. I heard testimony that Lynette was harassed during her work hours, during her high-risk pregnancy. This is not my San Francisco. I expect my San Francisco to be a San Francisco that values families, that helps families, that provides services and intervention to families. My San Francisco values a process that is fair and equitable, and a process that is the same and consistent across the board. This is not what I'm seeing. This is not how these kinds of cases play out. My San Francisco treats everyone equally. Please, please, this is up to you guys. Please let this be our San Francisco. Please let this be a San Francisco that we are proud of, that values families, that does not allow for political games to get in the way of small children's lives. Thank you so much for your time.
Okay, we're gonna stop right now. This is it. Catherine, this is exactly why we needed to take public comment. This is why the court reporter shouldn't have to take public comment. If she wants to stop, it's not, but this is not evidence. It doesn't have to be in the record. And if we stop, tell her she can stop. Okay, I want to say one thing for the commissioners. The court reporter has been going for 3 hours, which, as someone who's familiar with court reporters, that is not okay. But this is not evidence and does not have to be included in the official record. Is there an objection to the court reporter not taking public comment from the parties?
No. Is it recorded?
We will continue.
We will continue to record, as we always do, public comment, but it will not be transcribed because it's not part of the evidence in the case. Thank you.
We can go? Okay. Thank you. Good afternoon, Commissioners. My name is Valerie Toulier, and I know you've heard probably the same points over and over again, but I do want to say that what Sheriff Mirkarimi did was accept responsibility for what he believes was his wrong. But does it raise to the level of misconduct, official misconduct? No, it doesn't. I'm a little bit concerned as a Latina that Ileana did not give permission for the DV community to make her a poster child. I understand why the DV community is connected. Their purse strings, their grants are connected to the City Commission and to the city politics that are in, and I respect that. I respect people wanting to stick up for their purpose and for their funding. However, I do ask that and I am a former commissioner on the Commission on the Status of Women, so I speak from experience. I do just ask for equity. I just ask for the justice to be even-handed. I know that the case for Fire Chief Joanna Hayes has come up, and that was to the level of a 911 call. And I just ask that if we are going to do justice, that we do it fair across the field, and that one person is not isolated and targeted, as I feel that Sheriff Mirkarimi has been. The last time that I was here at a commission meeting, you all were very reasonable. I pray that you continue to be reasonable and fair. Thank you very much.
Thank you.
Good afternoon. Domestic violence is not a private matter. As a woman and as a mother, I agree with that statement. However, an argument between a husband and a wife is. This was nothing more than that. I am more concerned with a mayor who perjures himself and gets away with it. I am more concerned with a bomb threat that put everyone's life supposedly in danger except for Mayor Lee's life. This young family over here, they love each other. They are united. They are stronger now than they ever have been, and they want to be together. But the political witch hunt that they are victims of is bent on destroying them. One more thing. People are incorrectly saying that he was convicted of domestic abuse. He was never convicted of domestic abuse. You must act with ethics and justice and immediately reinstate with back pay the democratically elected Sheriff Mirkarimi. Thank you.
Yes, good afternoon. My name is Hiroshi Figueroa, and I'm in the Japantown community. And I just am astonished that this has gone on this far. If you want justice, if you want a equal playing level, I can't believe that this is coming up before this commission. As previous speakers have said, there was a fire chief that had a 911 incident. We had someone who pledged that they would not run, and I think that those are, more serious than this. So I think this needs to be dismissed. Unbelievable. Please dismiss this.
Good afternoon. My name is Juana Villegas, and just for the records, I don't live in San Francisco, but I believe it's important for me to be here because whatever happened in San Francisco can pass by in other cities or states even. So I am making a point about the bomb because it's really important. Because you want to talk about ethics, how come you can talk about ethics if you don't even say to the people who was here on danger, they can die, but nobody cares about the lives of others, only for the mayor. And I believe that is not fair to hear that. And about the family, the Mirkarimi family, I really believe that he has to replace on his position because he was elected. And it's a lovely family that finally, after 7 months, they are together. For the first time, these 3 persons are together. So put your heart on your hand and think on justice for this family and for the people from San Francisco who elected him to get that position and get back his pay, because it's totally unfair that this man can't even pay for a coffee at this moment. His son has to lose the school year because he don't have money to pay for the school. Put on the shoes of him, please. Thank you.
Good afternoon. My name is Roger Scott. I'm a teacher at City College, and I'm a longtime union activist in AFT Local 2121. I have a high personal regard for Sheriff Mirkarimi. However, I would be here speaking on behalf of either of his 2 critics, the mayor and the district attorney, if they were in the same position, because I think there is no legal or procedural justification for removing him from his job. I think he's been treated specially in a very negative way that negates the popular choice of him as a sheriff. I also think that there's been too much adverse publicity in the press owned by the distinguished 1%. I believe that the most revealing misstep in terms of justice for Sheriff Mirkarimi was the press conference by the district attorney when he said with a straight face to the Chronicle and other major media people, I had serious misgivings about the sincerity of his plea bargaining, of him during the plea bargaining. Have you ever heard of a district attorney anywhere in the world questioning the sincerity of the defendant who chooses to make a plea bargain? I think that's the most revealing misstep in this whole history of denying him the due process based on the voter's choice and the due process he's guaranteed excuse me, under the law and your procedures. Thank you.
Good afternoon, Commissioners. My name is Jose Morales. I'm a member of many organizations in the city, especially Senior Action Network, San Francisco Tenants Union, and Just Cause, Causa Justa. And, of course, this is not justice. What has been happening to Ross, we stand for Ross, you know, where I'm standing, and I believe that he had been abused just for something that you call a domestic violence. But what was the domestic violence? It was just an altercation, the squeeze of arm of his wife in the heat of the argument and caused a little bruise. But why should that be considered domestic violence when, and battery, you would believe that someone that is being battered, you hit it with a bat or cause a big accident. So I would like you to really reconsider what you were saying, because I was here in the other room that you were questioning where this was a domestic violence and all the problems. But he has been an excellent, wonderful person as a supervisor. He has passed many laws, and he has the ability to produce those laws, and will be, and I would like to say that as a sheriff, he will be much superior to anyone. Well, he wants to become as great as the previous sheriff, Hennessy. So I would like you to be really fair. Do not be afraid of your position or the political. This is all political. As Ileana said, she was not considered.
Thank you, sir, for your comment. I want to thank the public for your comments. We will be adjourned until 3:30. I would like to inform the parties, we're going to go, hopefully we're going to go as long as it takes, so we expect you will be here for as long as it takes. Anything else from the commissioners regarding the schedule? Okay, we'll see you at 3:30.
SF Gov TV, San Francisco Government Television.
This is another one of our great lookouts. We are at Mount Davidson. Mount Davidson has the highest point of elevation in San Francisco, hitting a whopping 928 feet. This is the place for you to bring someone special, don't forget the dogs, and enjoy all the pathways, trails, and greenery that surrounds you. Mount Davidson provides a peaceful 38-acre oasis of public open space and great hiking trails. The spectacular view offers a perfect place to watch the sunrise or sunset with someone you love.
It's just a good place to get away from, the hectic life of the city and come up here, listen to nature, get some fresh air. Oh, the view is fantastic. I think it's better than Twin Peaks.
Wear sturdy shoes to conquer the western slope trails, where the densely overgrown vegetation and fog trim give hikers the feeling of being in a rainforest. Mount Davidson is also a great park to escape from the noise and bustle of the city with your partner. Take the 36 bus and it will drop you right at the entrance. It's quite a hike to the top here at Mount Davidson, but the view is worth every step of the way. This is the place and the lookout to bring that someone special. Golden Gate Park's largest body of water is the very enchanting Stowe Lake. It's a popular spot for strolling as well as picnicking and pedaling around in boats, which can be rented at the boathouse. Created in 1893, the lake was designed for leisure boating and a promenade for horse-drawn carriages. The 12-acre donut-shaped lake surrounds Strawberry Hill Island, a wooded hill named for the wild strawberries that once flourished on its flanks. A pleasant trail follows the lake perimeter passing Huntington Falls, a 110-foot waterfall. 2 bridges connect the Lakeshore Trail to Strawberry Hill Island, where trails follow the shoreline and climb to the hill's summit, the highest point in Golden Gate Park at more than 400 feet. You can still catch glimpses of the western side of the city through thick groves of trees that make this hilltop a romantic lookout. For public transit, take the N train. Stowe Lake is ADA accessible. Stowe Lake has a peaceful atmosphere where you can enjoy the warm San Francisco day with sunning turtles. Amble along the lake and watch many ducks, swans, and seagulls gliding, nesting, and dozing. Stowe Lake is a tranquil spot to stroll, enjoy each other's company, rent a boat, and sail away. Many couples come here to take a boat ride around the lake, floating under the bridges, passing the Chinese Pavilion and the waterfall, for a quiet getaway from the busy city life, making for a very memorable and magical experience. Located on 19th Avenue and Sloat Boulevard, the wondrous Stern Grove is the place to wear your hiking boots, bring the family, don't forget the dog, because Stern Grove has so many strolls to offer you and your loved ones. Sigmund Stern Grove is a truly hidden gem in the city. The park is rich with high eucalyptus trees and lovely nasturtium. Long paths that allow you to meander around the trees are perfect for dog walking in a wooded environment.
I enjoy the space and the history behind the space, the diversity of nature that exists out here, right here in such an urban city, and concrete and streets and cars, that we have this oasis of a natural environment. Kind of reminds us of what San Francisco initially was.
There's an off-leash section for dogs and plenty of parking. Plentiful transit on the 23, 28, 28L, or 91 bus can get you there easily. And the park is ADA accessible. And the park's far west end is Pine Lake, one of the city's few remaining natural lakes. This is your chance to stroll around the lake together hand in hand and let the kids run free. The lake also has many birds to watch. Stern Grove is the place to find some solitude from the city fervor and appreciate what you two share with great strolls and wonderful breaths of fresh air. Come and experience Lafayette Park and enjoy the people, puppies, picnics, and sunshine. This is a lovely place to take an afternoon stroll with your loved one hand in hand. Located at Gough and Sacramento Streets in the middle of Pacific Heights on top of the city's steep rolling hills, Lafayette Park offers a great sunny square of peaceful beauty. Large trees border long lawns of grass and greenery. The park features comfortably spaced tables and benches, a playground, restrooms, and 2 tennis courts at the end of the park. There are plenty of flat areas for football, frisbee, and picnics. Lafayette is very much a couples park, and there are a multitude of activities you can experience together. Stroll on the pathways that cross the entire park, bring your dog and watch him mingle with the dog-friendly community, or just picnic at one of the many picnic tables and enjoy all that Lafayette Park has to offer together. Many couples find that this is a perfect park to throw down a blanket and soak up the sun. This wonderful hilltop park is a majestic place that you can share with someone you cherish. Lafayette Park is located along the routes of the 1 and 10 buses and is also easily accessed from the 47, 49, and 90 buses. It is ADA accessible. Starting off our picnic segment, we are here at the lovely and historic Palace of Fine Arts, located in the bustling Marina District. Originally built for the 1915 Panama Pacific Exposition, the palace is situated along San Francisco's northern waterfront, near Presidio's Chrissy Fields and Letterman Digital Arts Center. The Palace of Fine Arts is ADA accessible and is easily reached by the 28, 30, 30X, and 91 bus lines. With its elegant rotunda, Corinthian columns and colonnades set against the reflecting waters of the surrounding lagoon and fragrant eucalyptus trees, the Palace of Fine Arts is one of San Francisco's most romantic settings for special dates and memorable proposals. The Palace is also a perfect picnic spot where you can relax with that special someone while listening to the water and fountains in the lagoon and gazing at the swan sail gracefully by. Beautiful to view from many locations along the lagoon and inside the columns is an ideal place to walk around with your loved one. The Palace of Fine Arts is the most popular wedding location in the city park system. Reservations for weddings and other events are available at sfrecpark.org. A Shakespeare's garden contains plants referred to by William Shakespeare's plays and poems. Welcome to the beautiful and unique Shakespeare's Garden here in the famous Golden Gate Park. Located near the D. Young Museum and the California Academy of Sciences, Shakespeare's Garden was designed in 1928 by the California Spring Blossom and Wildflower Association. Flowers and plants played an important tool of imagery employed extensively throughout Shakespeare's literary masterpieces. Here is a truly enchanting and tranquil little garden tucked away along a path behind a charming wrought iron gate which weaves its own romantic magic. This garden is the spot to woo your date. Stroll around and appreciate the beauty of its unique setting. The overarching cherry trees, the gorgeous brick walkway and the brick wall, the enchanting stone benches, the rustic sundial. Share the bard's words as you read the bronze plaques on the rear brick wall that fill the garden full of Shakespearean quotes and famous verses from Shakespearean plays. This compact garden is a sweet park gem to share with someone special. So pack a picnic, find a lovely bench, enjoy the sunshine and soft breezes, and let the whimsical words of William Shakespeare float you and your loved one away. This is one of Reckham Park's most popular wedding locations and is available for reservation. Hop on a 29 bus and have no parking worries. Shakespeare's Garden is ADA accessible. Just a little pocket park located at the bottom of Russian Hill, Fay Park is a secret garden with an intimate and captivating appeal. Carefully tucked away on Leavenworth Street, 1 block from the bottom of the crooked part of Lombard Street, Fay Park makes the top of our list for most intimate picnic settings. Avoid all tourist cars and parking hassles by hopping on the Pal Hyde or Pal Mason cable car, or the 30, 41, 45, or 91 bus. New walkways, deck, and balustrades installed by Reckham Park in 2006 made the garden ADA accessible. Fay Park's garden was designed by famous landscape architect Thomas Church in 1957. Grow old along with me, the best is yet to be, is inscribed on a sundial at this little gem of a park. A lush oasis anchored by twin white gazebos, lovely decks, and splashes of colored roses blooming year-round. This is the place to tell someone something special or the place to declare to friends and family the commitment you two share. Weddings and event reservations are available with Reckham Park for this adorable hidden gem known as Fay Park. We know there are many other lovely romantic parks in San Francisco. We hope you've enjoyed this short tour of lookouts, picnics, and strolls that are available every day in our parks. I'm Jamie Hopper with the Recreation and Parks Department, and until next time, don't forget to get out and play. For more information about reserving one of these romantic locations or any other park location, call 831-5500. This number is best for special events, weddings, picnics in Golden Gate Park, Stern Grove, and the County Fair Building. Or for any athletic fields and neighborhood parks, call 831-5510. You can write us at Permits and Reservations, 501 Stanton Street, San Francisco, California, 94117. Or just walk in and say hello at Old Log Cabin, Stowe Lake Drive, Golden Gate Park. And of course, you can find more information and reach us at sfrecpark.org.
an open account, please.
Oh, okay. Everyone deserves a bank account. And in San Francisco, anyone can have a bank account thanks to an innovative program, Bank on San Francisco. With Bank on SF, everyone is welcome. Even if you're not a U.S. citizen or have bad credit, you can have a bank account. And qualifying for a bank account is simple. Just live or work in San Francisco and have a form of ID.
Okay.
And that's it.
Okay, perfect.
We started Bank on San Francisco 6 years ago to really reach out to folks here in the city who don't have a bank account. We wanted to make sure they know they have options, which would be more low cost, more successful for them than using check cashers.
Check cashing stores can be found all over the city, but their convenient locations come with a hidden price.
Now the fees are kind of off the hook.
I remember one time I came in here and was charged a fee to collect a MoneyGram, which is pretty preposterous.
People who use check cashers, particularly people who use check cashers to cash their paychecks all year long, they can pay hundreds, maybe even $1,000 a year just in fees to get access to their pay.
I don't have that kind of money.
How are they going to pay the rent? How are they going to live?
It's hard, man, when you're out here.
Yeah, I wouldn't have to pay it if I had a bank account.
Bank accounts are essential. They keep your money safe and they help save for the future. But most banks require information that may limit its pool of qualified applicants, encouraging them to turn to costly and unsafe check cashers.
I don't feel quite safe, especially carrying the money order that I get home.
Without a bank account, you're more vulnerable to loss, robbery, or theft. Thankfully, the Bank on SF program was designed to meet the needs of every client, so qualifying for a bank account is no longer a problem.
All right.
Yeah, that's it.
Great. Thank you.
Thank you. Even if you've had problems with an account in the past, have never had an account, or are not a U.S. citizen, Bank on SF makes it easy for you to have an account.
Many people don't have a bank account because they might be in the check system, which means they had a bank account in the past but had some problems managing the account and it was closed. That gives them no option but to go to a check casher for up to 7 years. And so we wanted to make sure to help people who are previously in the check system as well have a second chance checking account.
To find the account that's best for you, just follow these 3 easy steps. First, find a participating bank or credit union. Just call 211 or visit one of our partner banks or credit unions and ask about the Bank on San Francisco account. Most participating branches will have this Bank on SF sign in their window. Second, ask about opening an account through Bank on San Francisco. A financial partner will guide you through this process and connect you with the account that's best for you. Third, bring some form of identification. A California ID, foreign ID, or your passport is fine. Now you've opened your account. Simple, right? That's exactly how it was meant to be. You can even access your account online, set up direct deposit, and make transfers. It's a real bank account.
It's been very exciting. We see a lot of people open up a second account. Of course, people never had bank account before, or people who have problem with open up a bank's account, people who don't have 2 IDs, and with minimum deposit. I thought it was really exciting to have those people who we can help.
Well, Community Trust, a division of Self-Help Federal Credit Union, has been a great partnership with Bank on San Francisco because we're able to offer checking, savings, money markets, certificates, and loans to people who might not be able to get accounts anywhere else. So even if you've had a previous bank account at another financial institution, if you had any problems with that account, we can still open an account for you, and so you don't have to go to a check cashing place, which might charge you anywhere from 2 to 10% of your monthly income.
And to help manage your new account, you can enroll in free educational services online. Just visit sfsmartmoneynetwork.org.
There are many benefits that the San Francisco Smart Money Network provides. It's really the one-stop shop for all your financial questions.
With services like financial education classes and one-on-one meetings with advisors, SF Smart Money Network makes it easy for you to learn all you need to know about managing, saving, investing, and protecting your money. The network offers access to hundreds of free financial education programs. To help narrow your options, just fill out the quick questionnaire and you'll be steered toward the programs you're looking for.
We wanted to make sure everybody has a chance to manage their money successfully, keep their money safe, and avoid getting ripped off.
What do you think of it? Doesn't it sound like a cool deal?
It sounds very good, and I think people should try that one.
To find out more, visit sfsmartmoneynetwork.org or call 211 and ask for the Bank on SF program. No more hassling with these expensive check cashing stores. Now you can have a bank account. Let Bank on San Francisco help you open one today. Voting. We often view it as a fundamental right and the very heart and soul of our democracy. The right to vote allows us to express support for a motion, candidate, or party, and it's the most significant way to have our voice heard. But historically, the right to vote was limited only to men. Exactly 100 years ago, women were first allowed to vote in California. But the battle for women's voting rights, or women's suffrage as it's often called, was not an easy one. It took more than 70 years. It all began in 1840 when two women were barred from attending an anti-slavery convention in Europe. This prompted them to hold a women's convention in Seneca Falls, New York.
Lucretia Mott and Elizabeth Cady Stanton got together and organized this conference, which basically modeled itself. They issued a proclamation kind of modeled on the Declaration of Independence, which was a Declaration of Independence for women. And we rightly mark kind of the beginning of the women's equality movement in the United States from this point.
At the time, women were banned from inheriting property, serving on juries, signing contracts, and voting in elections. Suffrage leaders like Elizabeth Cady Stanton and Susan B. Anthony dedicated their lives to reform and campaigned vigorously for women's rights.
Suffrage in the middle of the 19th century was not a galvanizing force for organizing women to accomplish some goal. It was diametrically opposed to the predominant kind of ethic of the age, which was this idea of gendered spheres, that men were supposed to have one role in society and women were supposed to have another role.
Many feared women would be corrupted by politics and even argued it wasn't their place.
Women in the 19th century campaigns had to convince male voters that having the vote wouldn't change anything, that women would still be devoted to the home and the family, they would remain pure, they would remain innocent, that having the vote would not corrupt them.
In spite of opposition, reformers gradually built support through state and local campaigns, and California was amongst the trailblazers.
Leaders like Ellen Clark Sargent organized in their homes. They had private meetings that they called parlor meetings. They had afternoon teas. They spoke of these meetings as though they were just social calls and not explicitly political activism. They did everything they could to ground their campaign in femininity and domesticity so that their activism would not be threatening.
Despite their efforts, the link between suffrage and prohibition made it tough to win over voters in the big cities, especially San Francisco.
The problem in San Francisco was that women's suffrage as an idea was associated with temperance. Susan B. Anthony made that connection herself in the 1880s when she abandoned the Republican Party and she joined the Prohibition Party. Prohibition was a deadly idea in San Francisco because liquor was the foundation of the local economy. It was also the center of masculine public life. Anything that touched on the possibility of prohibition was completely unpopular.
The first campaign in California was a great effort, but not a success. In 1896, male voters rejected a ballot that would have approved women's suffrage in the state. But the war was not over. Less than a decade later, a crafty protest brought new life to the movement.
Lillian Harris Coffin and the Woman Equal Suffrage League march on the Republican convention in Oakland, and this time they did something even more unthinkable. They had a suffrage march. They had about 300 women who marched down the streets of Oakland to the convention center carrying a women's suffrage banner. It was still a very public demonstration and a signal that women now considered the public sphere properly female, that they were entitled to be there.
With a new strategy, the reformers joined together for another campaign.
Selena Solomons in 1910 opens a club in downtown San Francisco on Sutter Street near Union Square that she calls the Votes for Women's Club. And she offers lunch every day to the shop girls and the working women. And her idea is that if she can get the shop girls to come in and have lunch, then she can interest them in suffrage literature. And the lunchroom was a tremendous success.
So there had to be a social transformation in the way people thought about women's equality, women's rights, and women's role in society before you could have a successful, truly successful campaign. And what happened with women's clubs is they began to build the base of support for that, that transformation, that social transformation. They pushed the boundaries of what was possible for them outward, and they began to engage in civic and public work.
What followed were parades and rallies, door-to-door canvassing, street speeches, plays and pageants, reaching every voter in the state from San Diego to Sacramento. The eyes of the nation were on California in 1911 when male voters flocked to the polls and approved women's right to vote by a narrow margin. It was the 6th and largest state in the nation to approve women's suffrage. A decade later, women received full voting rights in the United States after the passing of the 19th Amendment. And to help newly enfranchised women exercise their responsibilities to vote, a new political club was founded.
The League of Women Voters was started in 1920. Really, it was a movement that was created from the momentum of all the suffragettes moving forward with getting the right to vote. When the 19th Amendment was ratified in August of 1920, all of those suffragettes now were interested in educating the new 20 million new voters.
Today, the League has chapters in all 50 states. It is nonpartisan and does not endorse candidates, but it is very much political and works to influence policy through advocacy.
100 years ago, our voice wasn't heard. In fact, they weren't even going to give us the right to vote. That's how insignificant our voice may have been. And I really hope people vote. It's our one way to have our voice heard.
To celebrate California's 100th anniversary of women's suffrage, events and exhibits are taking place throughout the state. The Bancroft Library in UC Berkeley is having an exhibit which highlights the women's suffrage movement. It chronicles the women's struggle in California towards finally winning the right to vote. So how long has this exhibit been going on?
It was installed the week of August 20th. A lot of people don't realize that California actually allowed women to vote almost a decade before the nation did in the 1920s. All these materials were pulled from the Bancroft Library collections. We have a huge amount of manuscript and ephemeral material regarding this time period. This exhibit is going to be open until the end of December and possibly longer if there's enough interest in it.
We're at the 37th annual Solana Stroll Parade, where a group depicting and honoring the 1911 suffragists will march today in commemoration of 100 years of voting in California.
100 years ago this year, we won the right to vote. This would have been worn around that time, around 1911, and here we are, dressed as they would have dressed.
So whether you're marching for a cause or voting in the next election, make your voice heard and vote. I'm Nona Melkonian. Thanks for watching.
Today, Rudy, hi. Okay, thank you for joining us today. My name is Malia Cohen. I'm a member of the Board of Supervisors. I represent the Southeastern neighborhoods, also affectionately known as District 10. I am very pleased to thank everyone for being here today. Thank you, Pastor Bryant and the Calvary Hill Church for hosting us today and opening up your wonderful sanctuary. Where are you? Oh, there you are. Thank you very much. I appreciate that. I'd like to first introduce Mayor Lee. He will begin to talk to us in greater detail about some of our initial proposals that we're going to be presenting to you today to address our public safety challenges that we've recently been experiencing here in the southeastern part of the city. Thank you very much, Mr. Mayor.
Thank you.
You're welcome.
Thank you. Thank you. Thank you, Supervisor Cohen, and I want to also express my appreciation for the other supervisors that are here and also have been engaged with us. Certainly Supervisor Alagi, who's here, Supervisor Wiener, who's here, and then last week Supervisors Avalos, Campos, and others, Supervisor Chu, Supervisor Kim, had all weighed in on an ongoing discussion about our neighborhood public safety. I also want to express my very deep appreciation for our city's clergy community, the Interfaith Council, and certainly my personal thanks for today, Pastor Brian and his church and his staff for welcoming us all here in this very integral part of our city, and all the other clergy that are here, as well as the NAACP, represented by Pastor Reverend Amos Brown and his staff, along with all of our other community agencies, from the police chief to our public safety clusters, our juvenile probation, adult probation, community-based agencies, our city administrator's office, and the number of community groups that have engaged me and my staff and all of the supervisors around this very serious question about our public safety in our city. No doubt, many of you have known and heard in the past couple of months my very deep concerns about our safety, particularly of our young kids, and particularly of our African American kids. Not everybody can be a Gabby or an Olympic hero in our sense. Not everybody can do that. Not everybody can participate in all the 5,000 jobs that Eric McDonald and I and Hydra and everybody are creating in the internship programs that are paid that we signaled this summer. Not everybody can be successful in everything that we do to try to set up those conditions for people to be successful. And there are some who unfortunately touch our juvenile and adult probation criminal justice system, our DA, our police, and we try to find ways to correct that path and to create supportive mechanisms. And we are rich in services in many ways, with interventions as much as we can to redirect our youth or to help victims and their families as best we can. Sometimes not perfectly, but the best we can to assist them in their recovery on these personal tragedies that we hear too often happening in our own communities. And so it was right for me to talk about this in a very deliberate way, to talk to other mayors across the country and ask them what they are doing, to find out what is working and what is not working, and then to bring back that conversation in a very direct way to our own communities here in San Francisco. And I know every person who are standing beside and behind me love our communities, love this city. They wouldn't be here unless they did, from the labor groups to the clergy groups to the community-based agencies. They really have a deep, deep love, and I know it. And I know that we've had these very sensitive discussions about these programs called Stop and Frisk that's been done in other parts of the country, and I had a chance to review them. Well, in agreement with our local leaders, in total agreement with the community-based agencies and the civil rights organizations that have had a very deliberate reason to engage me on this, we will not be implementing the Stop and Frisk program or variations of that here in San Francisco. We do not We do not wish to be distracted from the real reason we are here. We love our kids. We love our families in the Bayview, whether they're in Sunnydale or in Alice Griffith or in Potrero Hill or in Pingyun or in the Mission. We love them so much that we have to do more to care for them. We have to find those connections. There are too many stories that we're hearing from our clergy when it's too late, when we're having those individual funerals, when our parents and our brothers and sisters are crying over things that have already happened, where the jobs that Mohammed and Eric are helping me create there didn't reach these unfortunate young kids, where our police commissioners and our police chief, working in concert with adult probation, juvenile probation, didn't quite get the person who signed these papers, put their names to it saying, I won't go back to where I was found with the guns, or associate with those very known individuals that are participating in gang mentalities. They signed those papers, and yet within days, they're found. We're not reaching them. We're not penetrating those kids. We have to step it up. And this is why our supervisors and I have been talking very, very deliberately to come together with all of our community groups to forge our own San Francisco plan, as we are just as serious about trying to get to these individuals and prevent crime from happening and prevent their lives from being destroyed. You know, we created over 5,000 jobs this summer. You can't give jobs to dead kids. That's just the reality of it. No matter how often we try, these kids, if we don't get to them now, we don't prevent their truancy in middle school, if we don't redirect their interests in how to resolve a problem that they have, be it an individual case or some hatred or something that's going on in their lives. And this is why we're investing in a three-pronged approach today that we want to announce, a San Francisco-based program. The first, we are going to interrupt the patterns that we see out there. And I need everybody's help to interrupt these lives that are being wasted and going down. Because right now, whatever we're doing is not good enough to interrupt these patterns. And I'm going to ask the churches to step it up. I'm going to ask all of the law enforcement to step it up. And we have identified at least 100 to about 180 adults and young kids who have, in most cases, have touched the criminal justice already. And we have to interrupt their lives right now and make sure the interruption is serious enough for them to pay attention. And then we have to do the two other parts of this program that are as essential, because interruption is only temporary. And we've talked about that. We've talked about how temporary that could be. Not good enough to just incarcerate a kid for a day or two in juvenile detention or cause them to have a probation. That's not enough interruption. We have to step it up. So while we interrupt, we've asked the police commission and the police chief to work with adult and juvenile probation to do better predictive policing in our communities, to work with all of us in the community to take a look at all the data that we have, including anecdotal data, information that is given to us by people who are talking through their clergy or through their friends or through juvenile probation officers and others. Not to squeal, but to get better information so we can predict where the crimes will be connected again in a very specific way. And we know some of those areas already. They've happened over and over again. But predictive policing is about using the best data and the best systems that we have, not only to respond with officers on the street, as sensitive as they can be, but we also have to predictably and before the events happen, saturate those areas with our probation officers, with our crime prevention, with our CRN partners, with our Safe Patches partners and others that can help provide a deterrence on a sustained basis. That's predictive policing. And then the most important part of this three-part is community organizing, something that has never left me in all of the years and all the time that I've worked in public office here. It's always been about stronger community building. And this is where our youth advocates, our school advocates, our family advocates, our victim advocates, all of our church-going folks, as well as people that are not going to go to church, but might touch us on a community service basis, job training programs, job prevention programs, that we have to step it up in our community organizing and work even closer together to prevent and to provide alternatives before things happen, to suggest dispute resolution and abilities to argue is fine. But fighting and using violence as the answer, that's not an answer for anybody. So, our San Francisco approach, one that has been derived from all of these very hard meetings that we've had to face each other down and say, well then, if we're not for this other program that is happening in Philadelphia and Chicago and New York, what do we stand for here? What are we doing actively to turn the tide here as these numbers tell us we're on an uptick? Well, we've got to interrupt. We've got to have better predictive policing with all the different law enforcement agencies. And we have to have probationary programs that really penetrate the isolation and the loss of hope that many of our youth and families are facing. And we've got to have stronger community organizing from the church, from all of the different religious-based groups, but from our community. And we've got to build hope and faith in our young folks so that when we have jobs, and we've been told it isn't just the jobs. I can quote you numbers on end that we have jobs here in the tech, bio-life sciences, all of our city agencies that come together to provide paid internships. But it's about the training. It's about getting up every day. It's about having financial security. It's about creating hope that they can take care of others. And we've got to talk to the young girls of our communities as well. Not just young men, young girls as well. That they have to talk with each other and with us about how we can reach these young people in a very way so they're not signing these probation forms in a very empty kind of compliance way, but that they really mean that they want to change their lives around, and we have to provide that hope. We have to have everybody's cooperation. So this three-part program we are going to invest in. There'll be a budgetary priority, but also certainly this mayor and these members of our Board of Supervisors are going to work closely together to prevent more lives from being lost, and to also work with our housing authority and all of our community partners. But it begins with this pronouncement today. It begins with National Night Out. I think it's very appropriate that not only myself but others in this room join in all of our communities to express our support and our love for our communities by being with everyone together in National Night Out. It's not just one event. It's got to be every night. We've got to have these conversations that reach all these families that could be hurt or already are hurt, that we got to restore and have restorative justice on our side working as well. So all of the efforts that we are announcing today may not sound brand new, but they are a reinvigoration of where our hearts are, where our minds are, and where our commitment is throughout the rest of the city. Thank you very much.
All right, thank you, Mr. Mayor. Also want to acknowledge President David Chu joined us, as well as Supervisor Kim is also here, and Olage and Wiener are with us as well. Thank you, Mr. Mayor, for your thoughtful words, and that's a wonderful, great epiphany. No stop and frisk. Did you guys hear that? Thank you. What is critical is that we need to begin to interrupt this cycle of violence, and there are 5 key things that I just want to recognize with you, to share with that we recognize the links between poverty and the lack of economic opportunity to to the propensity to commit crime, and that the role that young men and women are playing in these incidents tailor our programs, that they're not exclusively just for men. I think that is a critical point, that there are women that are raising our future generation. And while we have significant city resources dedicated to violence prevention and response, that they should be significantly coordinated and better utilized. So I'm proud to see so many of our service providers here with us today, as well as our community partners. It's not just about government, and we need to make sure that we have a comprehensive approach that is not just tailored to individuals and to individual communities, but will most likely tailor the individuals that we know to be perpetrators of gun violence, but also keeping in mind the relationship of their family, that everyone is connected to a family, and that's the entire family unit that we must begin to heal and provide research, not research, but outreach towards. And we also need to better realize the opportunities for employment on all sectors, not just on the ground doing construction. So without that, I'd like to bring up our Chief Sir, who after serving as captain of the Bayview Station is now our police chief, and for a number of years he's intimately understands the challenges that we are facing as a community. Thank you.
Thank you, Supervisor. Thank you, Mr. Mayor. With regard to the interruption, obviously the police department is going to play a major role in that. In the first 5 months of 2012, we had 14 homicides by firearm. In the next 2 months, we had 15. So we had more homicides in the last 60 days in San Francisco by firearm than we did in the entire first half of almost the year. The shootings are the problem. The guns are the problem. In discussions with this entire group and many people behind the cameras, it's about getting to the guns and affecting some long-term change, so we're not revisiting this every 3 to 5 years. So to that end, what the police department will do, we'll take our zone strategy that's been effective almost decade by decade as we unfortunately suffer these spikes. We're going to use real-time information through a new web-based system that the department just got in the last 12 months to get out in front of the violence. We're working very closely with juvenile probation, adult probation, parole, the district attorney's office, and more, all those in the room, to achieve or arrive at the list that the mayor spoke of. This list we don't anticipate will be larger than 200 suspects that are on parole and or probation. If you are on parole or on probation, plan on seeing a police officer, a probation officer, or a parolee every time we see you. We'll be knocking on your door. We'll be seeing if you're compliant with your conditions. And if you have a gun, I would suggest that you turn it in either directly to law enforcement, or I know that the faith community has offered to be a safe harbor. Anybody that knows where there's a gun in San Francisco, get it to somebody that can get it to us. If there's less guns on the street, we're going to have less gun violence. I know some people will say, oh, well, the people that don't use the guns are the only ones that turn them in. It doesn't matter. Many of the guns that we come across are taken in burglaries and the like. We just can't have the guns on the street. By targeting particular neighborhoods where the violence is occurring and focusing on those individuals most likely to commit the violence and or become victims of it, we believe we can get out in front of this in the immediate right now. So that's the case for the interruption. We will be blocking it. We will be working closely. I see many of our friends from the district attorney's office here to vigorously prosecute those that are in commission of crimes, especially if you are on our list. We are one list you do not want to make, okay? We will be trying to get those people back off the streets for as long as we can, whether it's in county jail, prison, and then those folks that are not on the list, we'd love to work with you, as the mayor said, to get you into something productive, positive choices, jobs, more education, again, to try and break this cycle. We will be using the same system and hopefully software that we can get to later to get, again, predict where the next violence may occur and then deploy our resources there so that we're efficient and even more so, we're not random in our application of our efforts to eliminate this violence. And then all you have to do is look at the room. It's unbelievable the amount of people that are now in the conversation, and we need to stay in the conversation. Even if this current spate of violence subsides, it has traditionally presented itself, and it'll come back. We will be tracking our list and anybody else that makes the list forever. We all know that, you go online now, you can always go and find it forever. If you make our list, we will track you in and out of the justice system. And if you leave the system forever, that's fine with us too. I might also add, if anybody wants to turn in a gun, we don't need an arrest with the gun. We just want the gun. So if again, like the mayor said, if you're worried about being proclaimed somebody who's a tattletale, that you're working with the police, get that gun to the clergy. They've offered to receive it and then get it to law enforcement safely. I don't care if we get an arrest. We just want the guns. We know who we're looking for on the other side of that. And then lastly, the mayor spoke to the kids and the supervisor. It is so important. It's an absolute fact that 74% of our prison population didn't finish high school. 82% of the crime committed in this country is committed by high school dropouts, and 94% of victims of homicide under 25 are high school dropouts. It's about finishing high school and then going on to better things. We will be working with the school district to find those kids that are most likely to be truant and or at risk of not finishing high school, do whatever we can as an entire city to get them across the high school finish line. If we can do that, all those other numbers go away, and think of all the monies that could be productively spent towards ending violence in the long term here in San Francisco. So I can't even tell you how much I appreciate the mayor and the Board of Supervisors' leadership and all the friendship and love that's in the room. Let's make it a safer San Francisco. Really, really, really appreciate the help. Thank you.
Next, we will be bringing up the Director of Adult Probation, Chief Wendy Thill.
Yep. Thank you. The Adult Probation Department is working collaboratively with our criminal justice and public health partners to create short and long-term effective interventions to provide offenders with meaningful opportunities to change their lives, which will also reduce crime and victimization. We have to create a way out. Our public safety and community-based organization partnership will include a continuum of employment, education, housing, mental health services that will enable individuals to break the free from violence and long-term criminal behavior, disrupting the intergenerational cycle of crime. In response to the mayor's direction to immediately interrupt, we're working very closely with our criminal justice partners. But in addition to that, we've opened an office in Bayview to bring our staff closer to the population that they are here to service. That office opened on August 1st. In addition to that, through the support of the mayor and the board, we will be completing evidence-based, individualized risk and needs assessment of those probationers and post-release cases that we're supervising, and employing the use of investment of over $4.7 million in the city's money that they've invested in the employment, education, mental health, housing, and treatment. We've also created specialized caseloads for those high-risk transitional age youth, including gender-responsive caseloads so that we can meet the needs of our young men and women. In addition to that, we have an enhanced collaboration as a member of the Gang Task Force and working with Department of Public Health, Crisis Response Services, and also utilizing sanctions and reward given to us by recent realignment legislation, including the use of electronic monitoring technology. In addition to that, we will be opening a community assessment and service center that will provide wraparound services, again providing individuals opportunity to change their lives. Education and service and skill development is key for long-term change. Thank you.
Okay, I know it's getting hot in here. Hang on, we only have 13 more speakers, so just kidding, we don't have 13. I'd like to bring up to you one of our newest community partners. He's the pastor of this church. This is Pastor Joseph Bryant, excuse me.
Thank you, Supervisor Cohen. Good morning, everyone. Welcome to Calvary Hill Community Church. The space that you are standing in, the space that we are gathered in, is called The Rock. When we moved into this community, we wanted to have a space that will be designated for reaching our community and kids, ROCK, and how symbolic and fitting it is for us to be gathered here as we applaud and affirm our mayor and his administration for his engaging mannerism over the past several months, as myself, along with several members of our faith community, have been the recipients of his encouragement, his open door, his open heart, and his open hands to listen to our voices as we have expressed the concerns of our community in and around safety and violence in the neighborhoods. Our mayor has heard the voices of the community, of the faith community, of the labor community, and of concerned citizens. And today we stand in junction with him, partnership with him, and commitment to our mayor and to this great city that we will stand together to ensure the futures of our youth as we bring improvement of services through education, economic opportunities, employment, and all the things that make for a positive and a great city known as San Francisco. We are here today to ensure that all of those partners that stand together are unified as one. And in the spirit of our Rainbow Push leader, the Reverend Jesse Lewis Jackson, we want to make sure that in San Francisco, for our youth and for our communities, we continue to keep hope alive. Thank you.
And in part of keeping hope alive, we have to provide an economic engine to get our young people back to work so that they're able to take care of themselves and oftentimes their family. And with that, I'd like to introduce to you Mr. Eric McDonald. He's the Executive Director of the United Way. Thank you.
Thank you. So good morning again. Welcome, everyone. We are excited and thrilled to be partnering here with the mayor. What's clear is that while the unfortunate rise and peak of gun violence brings us in the room, it also presents us what we believe is an enormous opportunity. These spikes are cycles that come and go, as Chief Sir referred to. And what we have now is an opportunity to cast a vision. We know that without a vision, people perish. And so that we can cast a vision and develop a resulting action plan that is based upon mutual respect, mutual trust, and mutual accountability. The mayor and all of our city partners to create that plan where we will engage all sectors. We will engage residents. We will engage the private sector, certainly creating workforce and job development opportunities. We will engage our faith-based community who are already providing tremendous leadership, and we will ensure that there is a coordinated, comprehensive plan that is sustained. Because other things that our communities have experienced, unfortunately, is a process that brings the city in, and then the city goes out, and then the city goes in, and that's nobody's intention, and yet it's the life cycle of the epidemic that confronts our community. Today we're saying we will commit ourselves to a sustained effort to ensure that we create a new vision, a new opportunity for our communities to thrive, so that in the end, there's opportunity for our young people, there's opportunity for our adults, and there's opportunities for our communities to thrive. And so finally, I'd say that the opportunity we have requires, I would offer, if I may be so bold, requires that everyone who claims to love San Francisco plays an active role in helping this plan sustain itself. It's not the city only. It's not the clergy only. It's not the nonprofits only. It's not the private sector only. It's residents. It's everyone playing a role. And I would challenge everyone in a very basic way. What are you doing today to be a part of the intervention, the interruption, and the opportunity for young people in particular to realize their potential? I believe today we can do it, and I'm honored to stand with the mayor, the supervisors, and all the city partners to help make this happen. Thank you so much.
The next man I'd like to bring up is Sululagi Palega, a man that probably needs very little introduction, but he's one of our community partners that's been helping us coordinate this conversation so that it's not solely happening in isolated ethnic communities, but that we are talking to one another. And Sulu is a fantastic representative and my brother in the Samoan community. Come on up.
Thank you. Thank you, Supervisor Cole. First of all, I'd like to thank the mayor and the chief and other city officials, and definitely the clergyman. But I want to thank all of y'all, because y'all see it every day. You are there dealing with it every day. As the chief said earlier, we need them guns off the street, because the people that got the guns are bold. The incident happened in Alice Green. After they had shot this man, they came back and wanted to leave their mark the day before the funeral. That's bold. knowing that the police is around. That's both. We need to all work together, come together, as the mayor said. Let's take an effort to make sure that this is a safe city, a place we all like to live in, and a place we want to see our kids continue to play. Because public housing does house a lot of residents of San Francisco, but sometimes those kids can't even go outside and play. I'm sure the chief's got that on his mind. He's going to make sure that change. I'm sure Mr. Alvarez has got that on his mind. It's going to change. And you heard the mayor. It's going to change. So let's get together. Forget about yourself. It ain't about us. It's about them. Because you all ain't packing. I hope not. You know. Y'all ain't committing crime after hour. I hope not. Because a lot of you seem a little old to do time. You know. So I just, you know, want to make sure everybody hears it. Not only the people at the top, but all of us here at the bottom are trying to make sure this thing works. Because without our kids, we ain't got no future. You can kid yourself all you want. You got 2 contracts. When you're born, you're going to die. And hopefully, before you're gone, you've left a legacy of some people that can carry on and move it forward. Because that's what we're talking about, the future. You know, we'll all probably get to a point where we say, hey, I'm going to move, I'm going to do something else, but those kids still got to be here. San Francisco still is a resident family community. So I want to see that grow. And again, I want to thank the mayor, his staff, the chief, and the people that have been working with us, because when we got the first response, we made sure that we responded with them. So God bless everybody, and let's keep up the work. And like the chief said, if you know somebody with a gun, they ain't got to turn it in. Go to your pastor, the preacher next door, or somebody say, and just give them the gun. And let's get it off the street, because if you don't use it, somebody might beat you up and use it. All right? So thank you.
One of the critical partners that are also in this room that gets little attention is our media partners. Oftentimes, you guys are the first on the scene to report a lot of information, and oftentimes our narrative is a story of crime, destruction, and hate and turmoil. And so we're looking to our media partners to remember that there are uplifting, positive, and exciting stories that are happening, and we look to you to respond when we send out a release. Please come and report the positive things, the kids that are going to college, the kids that are taking care of their business, that are buying homes, and that are absolutely working. This is definitely a two-way street, a partnership. So I definitely am reaching out to the members of the public and the members of the press to help us, the bloggers, the journalists, the photojournalists, the members with the cameras here today, that we are standing as one as a community, because we are all of our collective interest is tied together. And I'd like to bring up to you now and introduce to you a man named Amonte Jones. He is going to give us our youth perspective. He is the future, that of which Sulu spoke of. Well, many of us have spent our lives growing up and working in San Francisco. To put it frankly, this is just the future right here, and I'm just going to leave it at that. Thank you very much.
Hello, I'm Amonte Jones, and I've been working for the Garden. I would first like to thank the sheriff, the police, and the PUC for the opportunity working at the Garden Project, and it's my 3rd year working at the Garden Project. And the Garden Project helped me with a lot. It helped me pay bills with my mom, and also helped me continue going to school, because it's hard. People need money to go to school, and people need money to pay bills and put food on their table. And it's real hard because my mom, she's on SSI, so I have to help her out with the money I get, and if I'm not working during the school year, I cannot help her out, and then she has to borrow money from other people and pay them back, and that's a hassle. And also, if she can't make money, then I'll probably be on the streets selling drugs, robbing for myself to put money in her pockets, but I'll also be like making a risk to get killed or go to jail, and I don't want to do that. I want to go to college and see what I could do in the future and have a good future. And I'm nervous. I'm sorry. this is my first time.
College student, right?
Yeah.
You're in college? Tell them what you're studying.
I'm a college student. I'm going to San Francisco State University, and I'm going to try to do nursing, register nursing, because that's something I'm interested in. Something I've been interested in since my brother got killed 4 years ago, and that's what made me not want to be on the wrong path, because I don't want my mom to hurt and lose another child, and that hurt my feelings that my brother's not here with me. He didn't see me graduate off the stage or nothing, and yeah.
All right. Thank you. Thanks very much. Thank you. Thank you, everyone. Not only is Amante our future, but he's also a healer. So with that, I just want to say thank you for your time today. We appreciate everything that you have done, and we are honored by your commitment. Thank you.
Let me say something before you break. I'm Amos Brown. And as the mayor said, could I have everyone's attention? Could I have everyone's attention? I'm president of the National Association for the Advancement of Colored People. And for the NAACP, colored comes in all colors. But there's one color in the rainbow that is diminutive and almost diminished, and that is the black color. I want to thank the mayor for listening to those of us who met with him to share our perspective on what we should do collectively and not in isolation, to make sure we won't have another press conference to bemoan, to complain, to whine and cry about this problem of violence. Some don't like to hear this true statement, but the Bible says, ye shall know the truth, and the truth shall set you free. This community will never be free. We will never be liberated from this problem until all of our allies and our friends acknowledge that the epicenter of this problem comes from folk who look like me. I have presided over too many funerals, possibly more than any preacher in this town. Persons who were not members of Third Baptist Church, but we graciously let them have our facility to accommodate them. I feel that we have something to shout about today. No stop and frisk. The mayor has said that. But Dr. Benjamin E. Mays, the mentor of Martin Luther King, said, he or she who's behind in the race of life must run faster in order to catch up. No, we don't have stop and frisk. But in this city, we got to run faster to make sure that there's not another death, but we're going to run fast and make sure there are jobs, run fast to make sure there's education, run fast to make sure that there is housing, to run fast so that we will love each other. This is what NAACP is committed to. And I end by saying a lot of good has been stated here. We heard some great rhetoric, some terrific ideas and plans, but this is just like getting ready to drink a cup of coffee. You can have all of the cream, all of the coffee, all of the sugar, but like Maxwell House slogan says, it will never
Okay, we are back in session after the lunch recess. We're now going to enter the deliberation phase of this hearing. And I want to remind the public that, or I should probably warn the public, this will be no surprise to you, that given the divergent views that we heard during public comment, I can almost assure you that you will hear something that you don't like coming out of the mouths of the commissioners. I ask, however, that you respect the process, that we don't get any clapping or jeering or really any sounds from the audience. We really need to sort of focus here and try to reach a resolution of this matter. As a result, I'm again instructing the sheriff to, sir. Excuse me, Sheriff, the law enforcement in the room. If you see anybody make an outburst, please remove them from the room. I would actually prefer if you had somebody else in here too, so that you had 4 eyes on it. And we're just going to have a no tolerance policy on this. I apologize in advance, but this is really what we have to have. Okay, my proposal for how to go about deliberating on these issues is to start with the factual issues, then move to the legal issues, and then ultimately discuss our views on the ultimate issue of whether the facts as applied to the law constitute official misconduct. Does that sound acceptable to my fellow commissioners?
Yes.
Okay. I will introduce each of what I consider to be the salient facts. I'll express a quick summary of my view and invite discussion on whether we think this particular fact was established. I think obviously there were a number of facts that were presented in front of us over the course of the last several months, but I think we should hone in on the ones that could possibly sustain a charge of official misconduct. And I think those facts that we should discuss are as follows. First, whether the physical abuse of Sheriff Mirkarimi against Eliana Lopez occurred. Second, whether there is evidence that, a preponderance of the evidence that the sheriff abused his office by threatening to use his power as the sheriff to take away custody of his child. Third, I think we should address the dissuasion of witnesses, Ms. Lopez and Ms. Madison. Fourth, I think we should address the gun issue. And finally, I think we should address the support, the sheriff's failure to support and encourage victims to come forward. First, the physical violence against Eliana Lopez. I think it's beyond dispute that that occurred. I think that that conduct was clearly wrongful. It was clearly unlawful. And frankly, I found it disturbing that the sheriff got up here and testified in a way that sought to minimize the severity of that conduct. Is there any discussion as to whether or not the mayor was able to establish that the sheriff willfully abused his wife on December 31st, 2011?
I would just echo what you said. I agree that, to me, the evidence shows that a more serious incident occurred than just what has been characterized as an arm grab. I think there was a tremendous amount of evidence that shows the severity and the seriousness of the incident that took place. We have the video that was a more or less contemporaneous account of what happened, which was corroborated by what Ms. Lopez told her neighbors shortly thereafter, and which the sheriff's own witness, the campaign manager, did describe as a domestic violence incident. So I do think the evidence to me shows a more serious incident than what the sheriff has sought to minimize in these proceedings. So I would echo and agree with Chair Herr on that fact.
Commissioner Studley.
I think this is in addition to what Commissioner Liu was saying. For me, the video is also the more credible source as to whether there were previous acts of physical abuse, to use your phrase, because I thought that they were the contemporaneous and clearer articulation than the testimony here about whether physical acts had taken place before than the testimony that we got in this proceeding.
Any other views from the commissioners?
Well, let me add my views as a layperson. Following all the legal issues that have been discussed, to me it's very simple. Number one is the video that we have seen that Ms. Lopez taped, albeit with the assistance of her friend and neighbor, Ivory Madison. But there's no way to look at that video and not believe that something serious occurred, regardless or despite whatever she may say now. But at that moment, that's a very emotional and, quite frankly, disturbing video, an indictment of her husband. Now, she's an actress. I don't know. Was it an act? I have no way of knowing. I believe what I saw. And so that is number one. And number two, in the end, Ross Mirkarimi pleaded, made a plea bargain. So he pleaded guilty to perhaps something lesser. I don't know if it would be lesser or greater in terms of false imprisonment. But in any plea deal, there's a lot of discussion, and perhaps by pleading to this, he avoided a much more serious issue. I don't know, we didn't hear what those discussions were between all the attorneys in coming up with that plea deal. But I think those two things are an indictment of what occurred. It's true, none of us were there. We don't know what took place. But based on those two things, something serious did take place, and the sheriff ultimately pleaded guilty to it.
The second fact that I think we should discuss is the alleged abuse of office. The sheriff's threat to use the power of his office to take away custody of his child from Ms. Lopez. These allegations are disturbing. There was evidence about the use of the term powerful in terms of what the sheriff said to Ms. Lopez. My preliminary view, though, is that there's not enough to sustain a charge of official misconduct based on this allegation. I do not think that the mayor has proven by a preponderance of the evidence that there was a threat by the sheriff to use the power of his office to take away his child. I think the allegations are too vague to be proven in this case. And I welcome the views of my fellow commissioners.
Agree.
Totally agree.
Yeah, I would agree with you. I found the testimony unconvincing, or I was not convinced by the explanation that it meant the power of the custody laws. But even if I read the I'm a powerful man or I have power, that it wasn't connected enough to anything else to make it a ground for a conduct violation. I was troubled by it. I didn't like the sound of it, but there are a number of ways to interpret it, even if I leave aside the unconvincing power of the custody laws. Power of my connections, financial power, citizenship power, some of them, articulateness, English language speaker, whatever it was. But I think we would need more crispness or more of a nexus to think that it was abuse of office by threatening to use that specific kind of power in a judicial setting.
The next fact that I think we should consider is the dissuasion of witnesses. There were two witnesses who the mayor identified as being dissuaded. The first was Ms. Lopez, and I think we should take them one witness at a time. Now, Ms. Madison does testify in her declaration that Ms. Lopez told her that the sheriff instructed her not to go to the police and not to tell anyone about the abuse. Now, Ms. Lopez, of course, contradicts this in her testimony. Given that the sheriff chose not to cross-examine Ms. Madison on this point, I do think we need to take it as credible, but subject to the fact that I do think it's hearsay. And I did not see any non-hearsay evidence from the mayor's side to show that the sheriff made attempts to dissuade Ms. Lopez from going to the police. Now, the mayor primarily made his case on the inferences caused by the telephone messages, the text messages, and the emails. And one could certainly infer from those messages that the sheriff told his wife to call Ms. Peralta-Haynes, that he instructed Ms. Peralta-Haynes to try to dissuade Ms. Lopez from talking to the police or reporting this incident, that Ms. Peralta-Haynes was successful in that effort. That is a plausible, I think that is a plausible read of the facts, but I don't think plausible is enough to prove by a preponderance of the evidence that those actions in fact occurred. Of course, I also would like to say that I didn't find Ms. Lopez's testimony with respect to the conversations with Ms. Haynes to be particularly credible at times, but still I think, on balance, the mayor was not able to sustain this piece of evidence. I welcome the views of my fellow commissioners.
Mr. Chairman, I take it when you say that you're talking about as a separate charge of misconduct.
Correct.
Because as we get further in discussion, I do think there is some relevance to at least the conclusions I reach about the pattern of phone conversations between Ms. Peralta-Haynes, Ms. Lopez, and the sheriff. And when I pressed her on saying, were there any discussions about sort of how you would strategize? Oh, no, all we were doing was to support Ms. Lopez. Well, in the real world, the sheriff was facing the fact that this was going to go public, and how do you spin it? And that's what those conversations, I believe, were probably about. And that they were more, how can we deflect what's going to be obviously our political enemies using it to their advantage. But I don't think there's evidence to support a separate charge of misconduct under the charter based on that.
Any other views from the commissioners? Yeah, I too, that was really the part of the testimony that I found not credible as well. This notion that they had these conversations, that the sheriff was clearly involved in those conversations, and that they weren't, that Ms. Peralta Haynes was somehow not interested in protecting the sheriff as well as Ms. Lopez. I did not find that credible.
Well, in addition to which, Ms. Peralta Haynes testified that she couldn't remember the substance of many of those phone conversations. And I don't recall how many there were, but during the course of the day, there were, 20, 30, 40 phone calls or something? And so to say that you don't remember what you were talking about is completely non-credible. She may believe that she doesn't remember it, but I was not convinced at all.
I would agree with your conclusion. I think there is a very plausible or possible chain that would explain why, explain better than Ms. Lopez calling someone she didn't know very well and remembering her domestic violence background over that long, that would be different from what the testimony. But I don't think what we have is enough to sustain a separate charge.
I next think we should discuss the witness dissuasion charges with respect to Ms. Madison. Here I don't think it's particularly close. I mean, again, it's plausible that the sheriff instructed Ms. Haynes to talk to Ms. Madison and tell her not to cooperate with the police during the brief conversation they had on the telephone. But I do not think we're close to the kind of evidence we would need to find that the sheriff sought to dissuade Ms. Madison or Mr. Mertens from cooperating with the police or reporting the incident. I welcome the views of my fellow commissioners.
I would agree with that. I mean, I think there was an unbelievable amount of text and phone calls during that day, January 4th. We counted up, I think, over 20 calls and texts between the campaign manager, Ms. Peralta Haynes, and Sheriff Mirkarimi, and then over 30 calls and texts with Ms. Lopez throughout the day. But at the end, it looks like the campaign manager was really at the hub and the center of all of the activity that day, and I do not think that there's enough evidence to take that and infer by preponderance of the evidence that the sheriff was orchestrating it necessarily. I do think there was some interesting coincidence that after a number of these texts or phone calls shortly thereafter, Ms. Lopez would send a text or call Ms. Madison and say, don't call the police, forget everything I told you, but I don't think there's enough to connect it with the sheriff orchestrating it or directing it.
And I would concur with these two, but like Commissioner Rennie on another point, I want to leave aside the atmosphere that was created later and the whole sense of, for the moment, call it respect or disrespect for the participation of witnesses and whether that was a sort of conduct and tone that were being, in which the sheriff was engaged. But on this point, I agree with you.
Okay, the next issue I think we should address are the guns. You'll probably recall that when this first came up in the Daniele declaration, I suggested we strike it, that it seemed very tangential to what was going on in front of us. Frankly, the sheriff didn't help himself when he got up on the stand and testified inconsistently with what he told Inspector Daniele. Again, Inspector Daniele was not cross-examined, meaning that we need to take his admissible testimony, the portions that are admissible, as I think we need to consider them credible. And so I do think the mayor was able to establish that the sheriff told Inspector Daniele that he sold his gun in 1996 to a fellow cadet, or I can't remember the exact individual for whom the sheriff said he sold the gun to. So the question then is whether that was simply a mistaken statement or whether that was, in fact, a willful attempt to deceive the inspector. This was a closer call in my mind than I thought it would be when the evidence came in. I do think, though, that in light of the fact that all the guns were collected at the same time, that I do not think the mayor sustained by a preponderance of the evidence that the sheriff was willfully attempting to deceive Inspector Daniele when he said that he had sold the guns in 1996, or sold one of the guns in 1996. Both sides of the argument require some, trying to connect the facts with argument, but as with some of these other facts, I do not think that it was sustained by a preponderance of the evidence. And I welcome the views of my fellow commissioners.
I'd be interested in, and maybe you are subdividing these pieces related to the guns, but the matter of, do you think of it as a separate question about the matter of providing the guns to returning the guns to the sheriff's office and not to the police department and the related potential
I was
resistance?
thinking of them as separate
Okay.
issues.
I wish I had been told, for example, whether there was another gun as to which that description applied, and so that it was, a mistake about somebody who held several licenses, or whether it was, which would tell me more about whether it was an intentional effort to mislead, but we didn't have that. We didn't know whether there was a gun that met that description. It just wasn't the third gun in this setting. So it's hard to connect the dots.
It is, and I think if the gun was not collected at the time of the other guns, I would probably have found that it was willful, because then I could see the motive for the misstatement. As it stands, I think it's equally likely that the sheriff misremembered having disposed of the gun as it is that he intentionally tried to deceive Inspector Daniele. Okay, with respect to turning over the guns to the police department, again, frankly, I think it was childish. I think this idea that you're going to have a dispute with the court and between departments about who should have the guns it's not something I would expect from our sheriff. I would hope that our sheriff would comply with the letter of the law and would follow the instructions of the court and ensure that the weapons were turned over to the police. But I don't think that whether the guns were with the sheriff or with the police can amount to something that could lead to official misconduct. I mean, the guns were with law enforcement. They were not within the sheriff's custody and control. And so I do not think that the fact that the sheriff's office had the guns rather than the police department can support a charge of official misconduct.
I would agree with that. I think the testimony was inconclusive and actually pretty confusing on that point. There was some testimony about whether he was supposed to turn it over to his attorneys and who was even present when that conversation took place. I don't think the testimony was very conclusive. And then at the end of the day, the sheriff's attorneys are correct that the mayor testified that he did not think that in and of itself could sustain a charge of misconduct.
Commissioner Studley?
I agree with your result, and I also agree, however, with your comment about behavior, a way of acting that I find uncomfortable. I hadn't thought of childish, but that applies. I think putting members of the staff of the Sheriff's Department into the position that the sheriff did while he was their supervisor, to return the guns to Sheriff's Department staff and expect them to hold on to them and not give them to the police department, and the inconsistent instructions that we heard testimony about is insensitive to the dilemma that he puts his line officers in, and I think that was troubling. But this is not we're not here judging people's judgment, although I think it was poor judgment.
Okay, the last factual issue that I think could sustain a charge of official misconduct is the efforts to, the failure to support and encourage potential victims and witnesses to the domestic violence. I think the standard here for official misconduct with respect to these allegations is higher. I think the mayor has in some ways conceded that. The failure clause requires that the officer fail to perform any duty enjoined on him or her by law. I do not think that the sheriff was required by law to make public statements supporting Ivory Madison. He was at that point a criminal defendant, and I am not comfortable with suggesting there's some duty that a criminal defendant needs to go out and make public statements supporting someone who is a witness in a criminal matter against them. Even aside from the criminal matter, I think it's a dangerous precedent to say that an elected official can be held to have committed official misconduct by failing to support individuals who are, at least from his perspective, attacking him. So I do not think that this course of conduct where he failed to encourage and support victims and witnesses can sustain a charge of official misconduct, and I welcome the views of my fellow commissioners.
I think I would agree with that, particularly with respect to himself being the criminal defendant at that point in the process. It would be, I don't know that we would require, or that the law would require him to encourage witnesses to come forward against himself in a criminal process where he is the defendant. I think that would be an awkward precedent to set.
I agree that it is a higher bar and that an individual has a right to mount a defense. That said, I wish this element broken out this way wasn't explored as thoroughly as some others. And what I'm left not knowing is whether others who were mounting a much more aggressive public campaign of criticism were doing so at the direction of, the invitation of, the "I can't do it, but would you do it" guidance of the sheriff. It is not a pretty picture of what happened, and I think it has led the public to see this in a much more political and aggressive light than it would have been had that commentary about witnesses not taken place. The press, of course, has its own attraction to certain stories that you can't lay at the feet of any of the participants either. But I don't see the steps to be able to support it rising to the level of either failure to perform a duty enjoined on the sheriff or falling beneath the standard of decency, good faith, and right action required by a public officer, particularly when that person is defending criminal charges.
I appreciate your emphasis on the second clause as well, because I think you're right. It could conceivably fall under that. And I agree with your points, and I also want to echo something you just said, which concerned me when I heard the sheriff testify to it. I mean, these really are disturbing allegations. The sheriff makes an apology to Ms. Madison in his plea statement and gets up on the stand and can't really explain what he's apologizing for. I mean, these are the sorts of things that make clear to me that the conduct was poor. I'm just saying that I don't think it amounts to official misconduct, but I don't want there to be any illusion about my view as to whether it was appropriate conduct or not in terms of what I would expect from an elected official. But I do not think it rises to official misconduct.
You're talking about just this particular item of
Yes,
encouraging
right. This
of witnesses.
particular item, yes. Any other views with respect to the factual allegations? Now, of course, the parties submitted a joint statement which was somewhat helpful in us trying to determine what facts we really need to find and discuss here. We've addressed, I think, the most salient ones. There are a couple, though, that I think we may want to address just so that we can ensure that we've established the predicate for our discussion of the law and the application of the law to the facts. I think it is undisputed that the sheriff was elected on November 8th, 2011, and that he was sworn in on January 8th, 2012. I also think that there is, it was proven by a preponderance of the evidence that he did engage in actions at the sheriff's office, that he was getting up to speed on what his duties would be in the interim between November 8th and January 8th. I also think that it was established by a preponderance of the evidence that he pled guilty to false imprisonment.
Can I
yes.
just ask, since you're going through it, was there an agreement as to, he continued to serve as supervisor until he was sworn in or until the end of the year? What was the transition? I guess, was he in office as a supervisor, or was that not addressed by the parties? I'm not trying to add in a new issue, but I thought that
I don't remember the testimony about when he finished his duties as
here would know.
sheriff. Do the Mr. Keith or Mr. Wagoner, do you recall the testimony?
There was documentary evidence submitted showing the sheriff's letter of resignation as a member of the board of supervisors that essentially was concurrent with his becoming sheriff.
So January 8th. Got it.
So he held public office
He did hold
on
right.
December 31st as well.
I think that's an important fact that that also was established.
And I think it looks like it's undisputed between the parties on that point, too.
The parties apparently disagree as to whether the sheriff restrained Ms. Lopez and violated her personal liberty in paragraph 5 here, but I think that was established. Any disagreement regarding that?
No, I think that was well established by the sheriff's testimony and by his guilty plea.
Okay, we then invited the parties to submit additional findings of fact, and we gave each of them 5. I did not find any of them relevant to our determination. But if any of my fellow commissioners would think that any of them should be discussed or addressed, I welcome that. You know what? I should. I want to say one other thing about. I think I take that back. Fact 12, which was identified by the mayor, I think is relevant and one that, but I think one that we address that has to relate to the gun charges. I think the remaining, for example, 13, I think is a legal conclusion. 14, to the extent that it hasn't been discussed, I think is irrelevant.
I'm looking at number 9. I say that because it relates somewhat to the issue in 14. Number 9, indicating that the matter, there was a private matter and denying ever verbally or being verbally or physically abusive are at least troubling to me in light of the later admissions, or at least later plea and comment and testimony here.
Let's talk about that, because both you and Mr. Rennie have raised sort of the course of conduct after the arrest. Are you of the view that statements that were made that are reflected in paragraph 9 and also reflected in paragraph 14 have been proven by preponderance of the evidence?
I'm sorry, I didn't hear. Been what?
Have they been proven? And do you think that they are relevant to our determination?
You mean as to whether he made that statement?
Yes.
That it was a private matter?
Paragraph 9 and 14.
14.
My understanding is it wasn't denied. That it wasn't disputed that that statement was made, and what the response that the defendant gives was that it was, he says, the sheriff's private family matter comment was in a statement given to him by his attorney at the time. Well, still his statement.
Really?
He isn't disputing that he made the statement. Maybe he got bad legal advice.
Any dissenting view towards that? To that? I'm not asking about the bad legal advice comment. I'm asking about in general. Okay. I guess in my view, 9 and 14, to the extent they're factual allegations, some of them are not. I think the mayor did establish that the sheriff made a joke about the press coverage he was receiving at his inauguration. You know, I personally did not think that was a joke about domestic violence. Ultimately, I don't think it matters. I don't think any of these allegations, whether proven or not, could sustain a charge of official misconduct. But I certainly could see if someone thought that the joke was about domestic violence. I don't think it's outside the realm of possibility, but I just didn't think that's what he was saying.
I didn't feel that it was a joke about domestic violence per se. I think is a humorous reference to his personal situation, the one in which he found himself vis-a-vis the media and legal situation. So perhaps it was inappropriate and ill-advised, but I don't think he was making fun of domestic violence as an issue.
Are there any other facts that were in the joint submission that any commissioner would like to address?
Chair,
Yes.
I would like to address the sheriff's proposed fact number 18. The sheriff had proposed the factual finding that many individuals have served honorably in San Francisco law enforcement agencies who have been convicted of crimes, citing to Sheriff Michael Hennessy's declaration. And I did want to address it because when I first read Sheriff Michael Hennessy's declaration, it did give me pause for that very reason. But his declaration was so conclusory and was not very fact-specific. And in this case, as many people have said, facts do matter, and it is a very fact-specific inquiry. And then Sheriff Michael Hennessy did not make himself available for cross-examination after the commissioners had asked repeatedly about whether he would make himself available for cross-examination. He chose not to. And so I was not able to give his statement very much weight. So I did want to address that although it did give me pause, I really couldn't give it much weight when he wasn't making himself available to testify.
I would agree with that.
I think there's no way we can judge this one as a matter of fact, nor is it our obligation to do so. There's been, if it has any relevance at all, it would be to appropriate response or discipline for a matter, a wrongful behavior or act of official misconduct, if one were found, not to whether somebody did it or didn't. I have found a lot of what we've been offered with regard to assertions that other people have done other things to be a lot like the comment to the state police, but other people were going faster than I was. That's not the trooper's responsibility. What did you do? And we're the ones in conversation right now. So I don't think that there's a relative standard here, and so I find that it's both unhelpful and unprovable.
Agree. Any other facts that the commissioners think we need to discuss? I think we've discussed all of the ones that are relevant. Like Commissioner Studley just said, I think there are certainly many in here that are not relevant, but anything else factually that we need to discuss in order to establish? Okay. Next, I think we need to address the legal issues, some of which are likely potentially more thorny than the factual issues. It seems to me that the parties have agreed that we need to read the charter provision at issue consistent with the option 2 that we proposed at the last meeting. Option 2 requires that every subclause following the first including in the provision has to relate to the duties of his or her office. Is there any disagreement among the commissioners as to whether that should be the framework with which we should by which we should inform our
as
discussion.
I've made clear, I do not agree with that interpretation of that statute. I think that there are two distinct provisions that they are defining as an official misconduct.
So, Commissioner Rennie, you do not think that it's a fair reading of the statute to put the colon after the first including? Have the first clause begin with any failure, and the second clause to begin with conduct that falls below?
No.
Why not?
I think the or is disjunctive, and everything that goes before the or relates to wrongful behavior relating to the public office. That the second clause provides for misconduct being any conduct that falls below the standard of decency, good faith, and right action impliedly required of all public officials. And I gave the example that you take the Penn State matter with Joe Paterno. One could say he didn't violate any law, but he had a moral obligation, a standard of the position he was in to report what he had found out, not to let it just go or say don't come back. And my belief is that's what the framers were intending, is saying that we've got some standard. Now, the question has been raised, well, that's so vague and ambiguous, and I guess my answer to that is, and the case has said, is it may be ambiguous, but if the act that you are claiming violated that section, and if any reasonable public official would know that act violates it, the vagueness is not really a defense.
I mean, it's the mayor's position that your reading is unconstitutional.
I understand that.
But Commissioner Rennie, if you're looking at option one as the interpretation, which I do have to say that has been my initial take on it, that I think that is likely what the framers intended, would we be reading into it the phrase required of all public officers, the phrase required of all public officers to relate to the position in question? And perhaps that's why it's not vague as applied.
But the statute, I think it could be well read that you look at the particular position, public official, and say, did he or she conduct themselves in a manner which violates a sense of decency, good faith, and right action, or you say, regardless of what the position was, is the action or the conduct, does it fall under some general belief that it would be considered to violate the standards of decency and good faith and right action. So I mean, I don't think frankly, I don't think in this case it makes a lot of difference whether you apply it to the office or whether you apply it generally, saying that no public official should conduct themselves in the manner that occurred on December 31st.
Mm-hmm. I have for a long time thought that it was a very tough decision which of these two it was. And when I look at option one, the question came up this morning about whether, if it were intended to apply to each position, of all or each public officers, and why standard was singular instead of plural, I think you could get to the same place. So I'm agreeing with Commissioner Rennie here. If you're trying to make that one make sense, the standard of decency, good faith, and right action required of all public officers could include to carry out a number of things and carry out the duties of your particular office. So I think that it's torturing it to try and figure out the all or the each, because there's another logical, both substantive and grammatical way to get there. Because the standard could be do all of these things that are common and then do the things that your office calls upon you to do, whether you're an ethics commissioner or a sheriff, a school superintendent, or a supervisor. That doesn't help you with the whether we're all on paid option 2 question.
Yeah, but I mean, I had actually, Commissioner Studley, that similar thought in mind as well. I mean, the only way to read, I think one plausible way to read the section like Commissioner Rennie does, but to find it constitutional, would have to, almost by definition, require some relationship to the duties of office. So, and I think that's what was Commissioner Liu's point as well. Mm-hmm. And so in light of the fact that I think both readings are, based on the language of the statute, both readings are plausible, I think we should accept the reading that directly requires this relationship through the meaning of the word, since we'd have to imply it anyway in order to interpret it in a constitutional manner. Which is why I think we should agree with the parties and apply option 2. And I understand that there will likely be significant debate as to what the nexus has to be, but I do think that is the most correct reading, perhaps, in this case. Commissioner Hand, do you have a view as to which reading is appropriate?
Well, I kind of agree with Commissioner Rennie, but again, I mean, this falls beyond my area of expertise. And I guess my question in terms of pertaining to, or as it relates to the duties of office, my question would be then, since the sheriff, in this case, while this took place in that twilight zone, if you will, between when he actually, when he was elected and between the time he actually took office. Nonetheless, as sheriff-elect, his duties or his as sheriff relate to areas of domestic violence and, really quite a swath that San Francisco has cut nationally in terms of what we do. So it seems to me that if we read it that way, to me, that still means that what he did relates to the duties of office. Now, I don't know if that falls under the legal discussion that we're having, but that's how I would interpret it.
Okay.
Well, let me ask you this question. At the time of the incident, he was a member of the Board of Supervisors, which made him a public official, which meant he was subject to the language of this section. Now, if he had, hypothetically, if he had run for re-election and been re-elected to the board, do you read that to say that, well, because this doesn't relate to the activities of the board? It was just one thing to talk about a sheriff, and you say because of all of the supervision of domestic violence and lawbreaking. Are you saying that an act of domestic violence by a member of the Board of Supervisors could not be official misconduct?
You're asking me?
Yeah.
Well, so I think there are two parts to your question. One part is the timing. Are you asking about the timing? The fact that he's
No, I'm asking about if you interpret it that it has to relate to the office. If he had been reelected to the Board of Supervisors, are you saying that he would not be subject to a claim of official misconduct because of domestic violence? Because you wouldn't have the same arguments that you would have about the duties of sheriff. But as I read the statute, it certainly would be an indication of conduct that did not meet the standard of decency, good faith, and right conduct.
My answer to your question is that no, I do not think it would be official misconduct. And the reason is because I think the precedent that we have that actually talks about, albeit in dicta, what relation to the duties of office mean is pretty clear that there has to be a direct relationship of the alleged wrongdoing to the office held.
But that dicta was before this ordinance was ever passed.
Well, the ordinance had been passed, and the language that is now in the ordinance, this in relation to the duties language, is the same precise language that Mazzola addressed.
Yes, the first part, but the second section, the or clause, was not before the Mazzola court, and the dicta has no relationship to what was the meaning of the conduct which falls below the standard of decency, good faith, and right action.
Certainly, if we were to follow option one, which is what you're advocating, then I would agree with you that yes, then there would not be a nexus requirement to the relation of the duties. And in that case, in my common sense view, does domestic violence fall below my standard of decency that I expect of public officials? Yes. But I don't think that's what we are being asked to apply. I think if we don't find a nexus to the relation of the duties, then we are opening this provision up to abuse and manipulation down the road by in a way that we're not really going to like. I mean, I have grave concerns about what the next case looks like unless we interpret this in a way that I think the voters intended, and also that is narrow and understandable for elected officials.
If I may just add one thing, I think one issue that has been brought up consistently, particularly in public testimony, is the issue of fairness. I think we all agree that life is not fair, and certainly government and politics least of all. But I mean, I think it is an issue that we do have to at least think about and include in our deliberations. I mean, there's certainly all kinds of misconduct, and some of it has been referred to specifically on the part of other elected officials in San Francisco as well as other places. So, I mean, we see plenty of official misconduct across the board in this country. Not everybody gets hauled up on charges, and I think then the issue of fairness is, of course, who's going to bring charges. So charges were brought in this case, which is why we are looking at it. And so in terms of some element of fairness, I do think that this particular charge, as it relates to this particular office, is very relevant. It isn't just some elected official acting out, you know, taking his clothes off on a tweet or what have you, but something that really speaks to something of which San Francisco is a leader, and the sheriff is a leader in law enforcement and in the area of domestic violence. And so I think that there is a direct correlation between these charges and what the sheriff of the county of City and County of San Francisco does, and that is important to me.
Mr. Embledge.
One suggestion just for you to consider. If there's a disagreement on the commission about whether option one or option two is the appropriate interpretation, you might consider reaching a conclusion under each option. And I say that because obviously your recommendations are going to go to the Board of Supervisors. If you were to make a recommendation under option one, but the board believed that option two was the better interpretation of the charter, the board might justifiably say, well, what would the Ethics Commission have done under option two? I don't want to make your job any more complicated than it is, but I think you might consider making findings under each option.
Views of my fellow commissioners? I think ideally, I would like to make a recommendation to the board that is a single recommendation. I think we're making the board's job harder if we don't come up with one recommendation. And although I think it would be easier for us to sort of have a number of permutations of our recommendations and then send them all up, and we may need to do that if we can't reach a majority on some of these things. But my preference would be if we could figure out what we think the right option is and to make a recommendation.
I have go ahead, Scott.
Well, and I wasn't presupposing that your recommendation would be different. It may very well be,
right.
And I don't want to prejudge what I'm hearing here, but it may very well be that the recommendation you make, you might make the same recommendation under either option.
I see.
And I think as a matter of process, we might see where we are aligned and where we have differences and whether there are differences under the same option, different views, or different views depending on which option we proceed. So we might get closer by doing it, and we might yet, I think you're right that we would still have a preferred pathway or a recommended analysis. It may be that there's a footnote that says even if you go this way or if you were to go that way, here's how we thought about it. Because that could become part of the later interpretation and could help people who, if the supervisors go back to try and parse it themselves. So it may get to where
I think that's a good point.
as close as we can to what you want, but it may be a way to find what's common and what's different.
As I have said, I'm not sure the result in this case is any different. What I'm concerned about, that this commission sends a message to the elected officials, is you can do anything you want if it isn't in relation to your duties. When I think there's a provision that puts a higher standard on our elected officials than just how do they conduct themselves vis-a-vis their official duties.
I think that's a fair point. The countervailing view there is this. I have not seen any evidence suggesting to me that the mayor had any improper motive in bringing these charges. This, to me, is a statute that is subject to a number of interpretations. I think the mayor, in light of the seriousness of the allegations, had every right to file the charges. Now, we, I think, need to interpret it, and I think we're going to do this mayor, future mayors, and elected officials a service if we interpret this in a way that is clear. And I have a lot of concern about where you draw the line if you don't relate it to the duties. The other thing I want to say about this is not the only provision in law to protect the public from elected officials doing wrong things. There's a criminal process, there's a recall process, there is process within one's own department whereby an official can be reprimanded. So I think the voters intended official misconduct to be something narrow because it provides the mayor with a very strong tool that really could disrupt an elected official. And like I said, I do not think the mayor engaged in anything improper here or that there's any improper political motive. But you could certainly see that possibility, especially if we interpret this in a way that's so broad as to encompass any number of any amount of personal misconduct that doesn't relate to one's job duties.
So maybe we should take the option number 2, the tougher, higher standard, and then see where we are with that, and then see if we need to discuss option number 1 some more.
I think that's a good idea. So under option number 2, I think I'm guessing, based on what I'm hearing, that the the debate is going to be about whether the relationship to the duties has to be a direct relationship, meaning something that's performed on the job or purporting to be on the job, essentially under color of law, or whether it must instead just merely affect the elected officials' abilities to perform the duties. Probably shouldn't have used the word merely. I don't mean to suggest that it's a lesser option by any means. But is that pretty much what the parameters are if we're considering what relation to the duties means in option 2?
I think it's a good start, and let me start with something that seems to me pretty clear to help us go down this road. I don't think that the duties of office can be limited to the handful of specific affirmative tasks enumerated in the charter. I think that's just a poor reading of the duties of office.
Completely
there are
agree.
a whole lot of affirmative and negative instructions or explanations of duty. What the charter, as I understand it, attempted to do was enumerate some of the specific responsibilities at the charter level for those jobs, like operate the jail so that you could tell the job of supervisor from the job of mayor, who has another set of things enumerated in the charter. But nowhere does it say do not lie, cheat, and steal, because I don't think we expect the charter to do that. That's either implied or in the SIA, but it is a part of the obligation of office, and I think the duty and obligation of the office are related. So at least the argument offered to us that the limit of what the sheriff has to do is in that handful of specified tasks and nothing else identified by the mayor, assigned by the Board of Supervisors, selected by the office holder, him or herself, as a good way to advance the purposes of that office, are not part of the job, just seems to me thin. And if anybody challenged that, I would say, if you drove your official car to it, it's not just the limit of those 5 items. The sheriff's job is much, much broader than what the charter says specifically for all time that person must do. So not that it's easy after that, but I just want to, for my part, sweep away that argument constraining us, and then we can figure out what the duties of the office of sheriff are, if people agree with me.
I agree with that. Okay, so given that I think we agree that the duties are broader than what is described in the charter, what then are we to make of the relationship test? I am torn in some ways because, I am troubled that there is case law that addresses what is expected of an officer. I think those cases could have some relevance to what we are discussing. Now, of course, there are no cases that connect whether that standard should be imported into an official misconduct analysis, and that's sort of where I am a bit stuck, and why I come out, in my view, that the relationship has to be direct. But I again, welcome views of my fellow commissioners as to whether this relationship does have to be done while performing your duties or purporting to perform your duties, or whether there can be a different type of relationship that can meet this official misconduct standard.
Well, I don't think it has to be while carrying out or while, I don't think the conduct or the misconduct, the wrongful behavior itself is constrained to being performed while carrying out your duties. I don't read the provision to be that narrow. And I agree with Commissioner Studley that the duties are not just simply the ones enumerated in the charter. I think that there's been a lot of testimony and evidence that the duties of the sheriff are much broader than that. And as Commissioner Hayon very aptly put it, that the sheriff would be overseeing a lot of anti-domestic programs and overseeing that relationship. So I agree that there would be a correlation between that function of the sheriff and being convicted of a domestic violence crime.
I guess the problem I have with tying the relationship to the effect or the the ability of the sheriff to perform the job going forward is that it doesn't seem to work from a timing perspective. I mean, we're talking about this, to me, this provision is talking about wrongful behavior that at the time you're doing it is in relation to your duties. And I think a lot of the testimony that we heard is about whether or not the sheriff is going to be effective down the road. He very well may not be effective as a sheriff. But I don't think that's sort of I don't think that's in our purview. And if we're going to say that essentially what his expert said, what the mayor's expert said was that any misconduct by a sheriff is official misconduct. And that again is something that troubles me because it seems the parties concede that there is a difference between personal misconduct and official misconduct. And the evidence we heard does not give me any comfort that we can pick that line.
Go ahead.
I'm just wondering how you're getting to that time issue, because within option 2, any wrongful behavior in relation to the duties of office, including conduct that falls below the standard of decency and right action required. And the standard required could well have a going forward element to it. The standard that we expect is so that you can do your job going forward. It's not either historic or at one moment in time. So you may be looking at something that I'm just not seeing in the second line or in the other case law, which I know you know better than I do.
Well, I mean, it's a good point. I mean, I do think a standard is something that you should be able to look at now and know is fixed. And if the standard is, we expect you to act in a way that in the future you will still be effective even if you do the act,
Okay, let me try this.
It bothers me.
Making up hypotheticals on the fly is always risky. But if I held public office and I admitted to or were convicted of perjury in another jurisdiction in a matter not related to my city responsibilities, I lie in my family's estate matter, that is wrongful behavior, and I'm the district attorney. Is that, if you think that the standard that I should be held to as a law enforcement officer is related to not perjuring myself, then would it be in relation to the duties, even though it is not, even though both the time and the substance are distant from my job here in San Francisco?
I would say that is not in relation to your duties. And again, the reason being that I do think there has to be a greater connection. I mean, there's another line between perjury and lying. If you lie to your husband, if you lie to your friend, is that conduct that falls below the standard of decency that I would expect of a public official?
But if I perjure
Maybe.
myself or lie in a legal proceeding and my job is legal, does that go to the standard of decency?
Well, again, I've always read this to be a standard, which is why I think it has to tie to the relationship of the duties. To read it to mean multiple standards, and to change all to each, to me is difficult in light of the
in option
words.
2, we may not need to do that, but so even if we have a single standard, and I'm a public official and my perjury is in a public proceeding, do you think the voters, when they passed this, wanted me to come back, having been convicted of perjury, and continue to hold my office on the same terms as before? Or would they believe that there had been official misconduct? Or, no, because that's the term we're trying to, would they believe that I had committed any wrongful behavior in relation to my duties?
So I don't think that in other words, that your scenario, I don't think it matters whether you're the district attorney or a board of supervisor or any other public official. I mean, it's, but I mean, I guess you're right. I mean, for me to be consistent in my view, I would have to find that is not official misconduct in the performance of your duties. And
any of our duties.
Right. And so, but I can also make up a hypothetical that, would pushes the other way. Is private. If you're in a bar and you're intoxicated in public, is that official misconduct? Certainly, if you're in your office and you're intoxicated repeatedly, I think that to me is clear that could constitute official misconduct. But is it below the standard of decency and good faith and right action that one could deem to be publicly intoxicated in a bar? Is that what we expect of our law enforcement officials?
I don't want to be flip and say not in San Francisco. It doesn't. No, but I'm trying to figure out why. So what we're trying to do is get closer and closer, figure out what the line is between the things that we're describing. Justice Rennie is pondering.
Chair Herr, so I think that I definitely see what you mean, the interpretation that you're giving it in relation to the duties of the office. I read the second provision, conduct that falls below the standard of decency, to relate to the office of sheriff, but not necessarily to mean that it has to happen while carrying out the duties of sheriff. I think there still has to be a nexus and a relationship to the office. I don't read it as restricting it to while carrying out the duties of the office. So I think maybe that's where we differ on the interpretations.
I think you're right. And my interpretation is a little bit broader than that. I would say it's in relation to the duties means while you're performing your duties or purporting to perform your duties, sort of acting under color of law. If for example, the sheriff had, in fact, used his authority as sheriff to dissuade a witness, even though he wasn't the sheriff at the time, wasn't in office or at the office when he was doing it, I still think that could sustain a charge. What I am worried about is a relationship that is so general that what we're talking about is the effect it has on his ability to do the job going forward. I do not think that's what the voters had in mind when they wanted to remove someone for official misconduct.
And I agree with that, so I'll clarify that is not what I intended. I wasn't saying that we have to find whether or not he would be ineffective or effective as a sheriff going forward, just that there would be, for instance here, applying the facts here, whether being convicted of the crime of false imprisonment, being convicted of a domestic violence crime falls below the standard of decency that we expect of a sheriff, the office of sheriff. Not that necessarily that he would be ineffective going forward in carrying out the duties of a sheriff, but just simply taking this prong that, as Commissioner Rennie pointed out, was not dealt with in the Mazzola case. Does that prong, would that meet the facts here to sustain a charge?
Mm-hmm. And while I can agree with the point about Mazzola, if we're talking about option one, and in light of the dearth of case law that we have at our disposal, I think that if we're following option 2, Mazzola pretty clearly talks about this definition of unlawful behavior by a public officer in relation to the duties of his office. It's the same language. And Mazzola then goes on to say that the acts, they must be committed while in office. Official misconduct requires a direct relationship of the alleged wrongdoing to the office held. And explains why Mazzola's is not, because he wasn't performing his duties. So I guess that's where I get hung up, is how to reconcile those.
Right, and I think I'm just reading Mazzola as pertaining to the first prong, and that makes sense to me that that's a more narrow and restrictive view, but not addressing the second prong, which I think Commissioner Rennie pointed out was the gap that the voters decided to fill, because it was not addressed prior to.
But if we're going to say that the second prong has to relate back to this in relation to duties portion, then I don't see how the second prong, if it has to relate to the duties, should be interpreted any differently than in Mazzola. I mean, we're still talking about the same language, but maybe I'm missing what you're
saying. Why have the second sentence if it doesn't mean something other than what Mazzola was talking about?
What I'm saying is that I think Mazzola is explaining what in relation to the duties means. Now, conduct that falls below the standard of decency could be broader than, for example, a refusal to perform a duty enjoined by law. But they still both have to relate to the duty. So I'm only relying on Mazzola to the extent that it helps me understand what kind of nexus is required between the conduct and the relationship to the duties of office. I agree with both of you that 2 is broader, that the decency standard is broader than, for example, the failure to act standard. Can we again, I'm just trying to figure out ways for us to move the ball forward. Are we in agreement that there is this distinction between personal misconduct and official misconduct?
I'm sorry, how do you mean?
Is there a difference? Can a sheriff engage in misconduct that is not official? Wrongful behavior that is not official misconduct?
Yes.
Yes.
What would be an example of such a thing?
I promised my husband I will be home this time by 7 o'clock. I am not. That is personal misconduct. I have broken a promise to a family member. I don't think it's actionable at work. Just to get the ball started.
Do you mean conduct that is unlawful that would not constitute official misconduct? Is that what you mean?
Well, what is conduct that would fall below the standard of decency that would not relate to the duties of sheriff, or what is? And perhaps Commissioner Studley's example is a good one.
Breaking a promise to a friend or family member. It's not unlawful. So if you want unlawful ones, we have to search further.
Perhaps just conduct that does not end up being unlawful if there's no criminal conviction at issue. But it's something that was tasteless.
Mm-hmm. So
there are all sorts of speech acts that might not be appropriate or tasteful or respectful that are not, that are wrongful behavior but not official misconduct.
So then what is the principle you use to draw the line?
Well, to be honest, I don't think we need to set a bright line rule necessarily, unless you're uncomfortable with the facts as they are and you need to set a bright line rule. I just think we need to figure out whether the facts here rise to that level. I'm not sure we need to set just a bright line rule for any time this comes up.
I would agree with that. I just ask because I'm trying to get comfortable with this idea that what I like about bright lines is that it's easy for the next person to follow. And I think in a vacuum, bright lines are better than not bright lines.
It's hard to find a bright, oh, go ahead, sorry.
But I understand that that's not, our task is not to sort of create you're right, we probably could decide without establishing a bright line rule. But I'm just trying to get comfortable with not having a bright line rule and where you would, how you would decide similar issues if we went with a more vague rule.
I was just going to say, it's hard to draw a line with only one dot. And part of our problem is we have just this one matter, and we don't know whether we're worried about a slippery slope or a floodgate problem if we don't provide enough guidance, or if we do something that's hard for this or subsequent mayors to interpret. But it's asking a lot to try and intuit a line and a formula for something that happens so rarely. So we shouldn't do it willy-nilly. We should do it as coherently as we know how. But I'm with Commissioner Liu that we may be overburdening an already complex process by trying to imagine all the other possibilities when there's no population to reflect on.
Well, I have a question. The last time this even came up, I guess, was with Supervisor Jew, although it didn't actually come to, a hearing, and it was actual criminal misconduct. And then prior to that, Mazzola was the only previous case. Is that correct?
I think
that we know of?
I think Mr. Wagner said there was one in 1932.
Okay, well, Mazzola's been since then.
Right.
So I guess what I was trying to say earlier in terms of the fairness issue, I mean, so you have this description or this definition of official misconduct on the books or in the charter. But the fact is it isn't used very often. It's used subjectively or even arbitrarily, dare I say. So, it's not a matter of law that because someone in elective office misbehaves in some way, that they will automatically be charged with official misconduct and then go through some kind of process, be it something before the Ethics Committee or even criminal. And if it's criminal, that's a whole different matter. So I guess your concern is you don't want this to be, in the next time this comes up, you want it to be clearer and not as murky as what we've had to deal with. But there's a lot of personal misconduct that goes on that it falls below the standard of decency. Some of it has been already referred to in this room. But, no one did anything about it, or nobody said anything or brought it up. So I don't know what bearing that has exactly on how we should decide this definition, but it seems to me that it still needs to be as broad as possible, because that's the only way that it's going to be used if I understand that.
If it's as broad as possible, then I think you put the mayor in a tough spot if it's too broad, because then every time the mayor uses it, he's going to be accused of using it for political purposes. Because it's so vague and broad, it's always going to be subject to that challenge, and he may always feel like he has to bring it up because he doesn't want to be looked at as, letting official misconduct go. Or on the flip side, the defendant is always going to say, well, look at all these people who do all sorts of bad things. Why did you choose my bad act?
Right. But obviously it doesn't come up very often.
But it may come up a lot more if we don't create a bright line or interpret it in a way that can be easily understood. And I agree we don't have to come up with a bright line rule, but I think we owe it to the public to really try our best to come up with an interpretation that is clear and can be followed, even if it's not perfectly bright line.
Just to say parenthetically, and I don't know if this is appropriate or not, but often when there is a case of misconduct, usually it's personal misconduct in the political arena across the country, usually those individuals on their own resign without having to force any kind of public process such as we've had to go through. So, because we know of many very, very well-known cases of misconduct, but those individuals at least resigned in a timely manner.
That is true. As a result.
Or took more affirmative steps to mitigate or demonstrate that they could carry out the responsibilities or cooperate in other ways, reflecting the seriousness of the problem.
Well, Chair Herr, I'm not necessarily advocating this as the rule to adopt, your quest for a bright line rule, but one fact that was compelling to me that I think differentiates from the examples that the public gave of why other types of personal misconduct didn't amount to charges and rise to this level is the fact that this resulted in a criminal conviction. And when we took in the evidence to look at the facts, there were a lot of disturbing facts that went along with that criminal conviction. And so that's what I find compelling about this, that perhaps differentiates with, members of the public talked about officials having affairs or so on and so forth. That's the distinction that I see.
So that any criminal conviction would inherently be relating to the duties of the office and fall below the standard of decency?
Well, I think there would still have to be an inquiry about what office that was and what the duties were and what relationship that office might have to the crime. But I'm not saying it's automatic necessarily. I just think it's a factor to definitely be considered.
I think that's interesting. What do people think about taking a short break and then maybe reconvening and sharing our views on the ultimate issue? Sure. Okay, let's take 10 minutes. 5, 10.
SF Gov TV, San Francisco Government Television.
Okay, we are back. We are back in session. Before the break, we had been discussing our views on the legal application of the facts in this case. We've had, I think, a robust discussion. I think at this point it may be useful to take a straw poll of how various commissioners would apply the law to the facts in this case, assuming option 2, and then perhaps we can address option 1 after that. Yes. So just to be clear, option 2, actually, do the parties have the, or Ms. Singh, you have option 1 and option 2 there, don't you? Can you put it on the overhead? Option 2, please. Thank you, Mr. Umlich. Maybe we can make that a little bigger.
Okay. He's trying. Tap it when it gets.
Mr. Keith, didn't you effectively use this earlier today? Okay.
Somebody stands here and keeps doing that.
Okay, well, I'm not sure anybody can read that, but the...
Maybe somebody could read it out loud so that they understand what the language is.
Sure. The way I read option 2 is official misconduct. Official misconduct means any wrongful behavior by a public officer in relation to the duties of his or her office, willful in its character, including, number 1, any failure, refusal, or neglect of an officer to perform any duty enjoined on him or her by law, or 2, conduct that falls below the standard of decency, good faith, and right action impliedly required of all public officers, and including any violation of a specific conflict of interest or governmental ethics law.
That's option 2.
That's option 2. That's option 2. So if my fellow commissioners will indulge me, I'll sort of summarize my view. I think you understand it, but perhaps I can give one last shot at explaining it. I think this charter provision was meant to be narrow. I think it provides the mayor with an extraordinary tool that can be very useful and very consistent with how the public intended it to be used. Given the force of the tool, I think the people wanted it to be interpreted narrowly, and I think, to me, the best way to interpret this provision is to have as clear a line as we can as to what it means to relate to the duties of his or her office. And while I appreciate the suggestions that perhaps this could be limited to unlawful conduct, and thereby create some kind of line, or that we could import rules that are used in the employment context. I think the only principled way to limit this provision is to have a direct nexus between the wrongful behavior and the relationship to the duties. I don't think the provision can be fairly limited to unlawful conduct, given the purposeful word of the use wrongful rather than unlawful. And I don't think that it can be read to import multiple standards when it refers to only one. The misconduct in this particular case, I think, was egregious. For all those domestic violence advocates who came here and spoke today, I appreciate your attendance, and I don't want you to interpret what I'm saying to suggest that domestic violence is a private matter or not a very serious matter. But private and public does not mean the same as personal, and does not mean the same thing as official. And I firmly believe that the people intended official misconduct to be something limited because of the concern that it could be used in the political process. I also understand that the evidence likely show that the sheriff is going to have a hard time performing his duties going forward. And yes, a sheriff who commits an act of violence, I think, in my mind, does fall below the standard of decency that I would expect of a public official. But again, I don't think it's our job to determine what his level of efficacy is going to be going forward. And I would implore my fellow commissioners to take a narrow and principled view of this clause that will enable those who use it going forward to apply it in a consistent way. There's a reason why we've only gone through this once. And I do have concerns that a broad reading of this statute is going to could potentially lead to hearings like this that are potentially used for improper purposes. I welcome the views of my fellow commissioners.
Well, I do agree that there must be some relationship to the office, that the wrongful behavior has to have some relationship to the office, but I do believe that the intent of the voters was to add a clause that was not there at the time of the Mazzola case because they knew presumably what the law was at the time and they chose to add a second clause. So I would read the clause in a very similar vein, also in a narrow vein, as relating to the office, but I would read that second clause as conduct that falls below the standard of decency, good faith, and right action impliedly required of all public officers, and in that vein, that it be connected to the office of the sheriff. So I would read it as applied to this case. Conduct that falls below the standard of decency, good faith, and right action impliedly required of the sheriff. And that's how I would interpret the provision.
And would you find that official misconduct occurred in this case?
Yes, as to what's alleged in counts 1 and 4, as to the 1 and 4. The physical conduct, basically.
Well, I've expressed my view as to what I think that second provision provides, and I think the voters would be shocked if we were to say a public official who pleaded guilty to false imprisonment had not engaged in official misconduct. They would say clearly a public official who has pleaded guilty, particularly given the circumstance of this case, that conduct clearly falls below anybody's standard of decency, good faith, and right action. I believe that's what the overwhelming majority of voters would say. Now, that doesn't address the second part that we've talked about. But I think for us to say that a public official who's pleaded guilty has not committed an act of official misconduct because it wasn't directly in performance of his duties, but it took place in a domestic setting. So that I clearly would vote to recommend that we find that there was a violation of the section of official misconduct.
Commissioner Studley?
I think your points are very well taken, and the potential abuse is real. I look, though, at the way the voters developed and amended this and think that they did not mean to create a very specialized and narrow tool. I look, for example, at the fact that it says any wrongful behavior when there were lots of other words that could have been used that would talk about degree of wrongfulness, and again, that falls below the standard of decency when there are ways to have said falls well below or egregious or some other way of making those tests tougher. And so I take those as saying something about the voters' expectation that that we were setting a high bar, and that they wanted to create an effective tool, and I think take care of the risks that you were describing by creating a series of protections, and that's where this can't be effectuated by the act of a single officer. It's not just the mayor acting alone. There is this three-step process that I think is important as a series of checks and balances and different roles and different kinds of expertise. There is no doubt, and the public has made this point many times, there is a significant investment in time, in attention, in disruption, in risk, in doing this instead of something else for a number of people. That is a high public cost of trying to maintain the standard that I think is set by the public. We may get more efficient at it if it comes up again. The experience may let us get more quickly to the resolution. I think there is also a lesson in this that a mayor would act very carefully in using this tool because there are extra legal considerations, public reaction, press consideration that would also militate against overuse or at least suggest caution in overuse. I'll cut to the chase. I do see that there is, for me, I would find official misconduct under option 2 because I think that there is sufficient relationship between the standard and the duties of the office. I may be reading Mazzola a little bit differently, but it's partly the same way Commissioner Liu does, that Part 2, when I said that the law is different than it was, it's that the addition of Part 2 must mean something or the voters would not have revised to add it later. There you are.
Commissioner Hand?
Only one left. Yeah, I'm willing to support option 2. and add the somewhat more narrow definition for the reasons that you have advocated. And I appreciate all of the thought and effort that you put into the thinking behind all of these options, Commissioner Herr. I mean, really, it's a formidable challenge, and you have been more than up to the task, and I thank you for that. Especially being, as a layperson, I mean, some of this can get a little murky for me. But with this definition, I certainly do see that there is a relationship to the duties of this office of sheriff, and also that it is behavior that falls below, I think, the common standard of decency. Domestic violence is something that we take very, very seriously, and just because it wasn't, the most extreme form doesn't mean that it isn't domestic violence. And sheriff is the head of a law enforcement agency. And I don't think the sheriff should be an example of reformative justice. I think the sheriff should be an example of someone who follows the letter of the law and is someone that we can all emulate. So therefore, yes, I would certainly feel that this has been violated.
Okay. I think probably I appreciate the views of my fellow commissioners. I appreciate also that I'm clearly in the minority here. But I mean, I think they're very informed and wise views. I will say one thing in response to Commissioner Studley. You're right. The language of this thing is all over the place. It could be interpreted as the people wanting to be broad. One of the reasons, though, that I think the people didn't want to be so broad is because the power it gives the mayor to suspend an elected official without pay while this entire process goes on, I think is pretty extraordinary. And we may become more efficient going forward, but it's still going to be disruptive. And I want to protect this mayor, future mayors, and elected officials from a provision that I am concerned is going to be too vague to be applied. But I think, I think we've pretty much settled whether or not official misconduct occurred. I think the next thing we should discuss is what our recommendation should be and whether the recommendation should include a request that the sheriff be removed from office or not. Mr. Embledge, I'm going to put you on the spot here. Is that within our purview to make a recommendation of official misconduct and also make a recommendation as to whether removal is appropriate or not?
The charter says that the Ethics Commission should make a recommendation as to whether the charges should be sustained. I think that's probably open to interpretation as to whether as Commissioner Rennie has put it, that there's two elements to that, whether there's a finding of official misconduct and whether that could result in removal from office, although a finding of official misconduct, the charter seems to presume would result in a removal from office. So I guess I'm being a lawyer and going to tell you it can go either way, that you certainly would be within the charter to make simply a recommendation that the charges be sustained and leave it up to the Board of Supervisors to decide whether to agree with you, and if so, what the penalty is, or if you want to make a recommendation as to the penalty as well, I think you're within your right to do so.
Commissioner Studley?
The page that we were having trouble seeing goes on to say that when any city law provides that a violation of the law constitutes or is deemed official misconduct, the conduct is covered by this definition and may subject the person to discipline and or removal from office. That addresses a very particular circumstance, that when a violation of law includes within it a determination that if this ever happens, this would be official misconduct. As to those, it says discipline and/or removal from office. And I wonder whether there's any, is that the only reference to a range of different results? Or, and even if it is, might we import it to say that removal from office or suspension without, up till now, suspension without pay, if I recall, is not mandated. The mayor could have suspended with pay. So we have, does this give us any either authority or just reminder that if in those circumstances there's a range, should we consider that we could recommend as to a range if we find official misconduct apart from this mechanism where it is inherent within the law expressing the violation?
I guess I would read that section, that sentence as applying to a specific violation of a law that provides that a violation of that law equals official misconduct. The section that gives the mayor the power to do what he did in this case gives him the power to suspend and remove, not necessarily to suspend for a limited period of time or to do some lesser, impose some lesser consequences than removal. There is another section in 15105 that provides for automatic disqualification from office, but I'm not sure that really informs you here.
Well, I throw this out just for consideration here. In the amended charges, the charges are that he be suspended based on engaging in official misconduct, and then in the prayer of relief, the charges ask that the Board of Supervisors, upon the vote of the Board of Supervisors sustaining the charges, that the sheriff be removed from office. So I'm not sure that even the charges contemplate that we determine what the appropriate penalty might be, that's for the board to decide.
I mean, it's all for the board to decide. It's
Well,
all for
correct.
the board to decide.
Correct.
I almost read that as suggesting that you should make a recommendation as to removal. I mean, if anything they have to sustain seems like it should be something we recommend on. Although I think it could be read either way.
Okay, if I just may, it does say that if the board sustains the charges, the officer shall be removed from office. So and perhaps we're just parsing words here. It may be theoretical that you think there is a realm of official misconduct that you might find that doesn't justify removal from office. That probably means you should also say you're not sustaining the charges, because recommending sustaining the charges seems to mean you're recommending removal from office.
So you could, okay, let me see. So you could, are you saying that we could find official misconduct and recommend that the charges not be sustained?
Before tonight, I hadn't thought of it as a two-step inquiry. Before tonight, I assumed if you found official misconduct, that would be the recommendation. You'd pass that on to the board, and the board would then decide whether to sustain the charges. The charter says that if the board sustains the charges, the suspended officer shall be removed from office. So I'm trying to square that language with the two-step inquiry you're talking about, because I'm not sure how that fits together. I feel like we're trying to pound a bit of a square peg into a round hole.
Mr. St. Croix?
Commissioners, with all due respect, I think you're overcomplicating your requirement here. It says that you make a recommendation to the board of whether the charges should be sustained. That's all you need to do. We recommend that they be sustained, or we recommend that they be overturned. I think it's that simple.
Well,
you don't have to.
But the charges were a package. I appreciate that. there were a package of charges. There was a charging document with a number of provisions that the mayor thought supported suspension without pay. We have found one out of a half dozen or so of those. So we've already made it more complicated in the sense of saying instead of finding all 6, and if that's sustaining the charges, then we didn't. We found that 5 or so, some of them quite serious, did not rise, we did not even find facts for, let alone official misconduct. So we've done something different than what the mayor sent us already. And after having done all this, I at least would prefer, or see what the other commissioners would like to do, would prefer to say something to the supervisors about the actions they might consider than simply say, we found one, you, the supervisors, only have one choice. Because I think, at the very least, there was a big difference between what came to us and what is going forward from us.
So are you saying then maybe we should just specify what the recommendation that charges be sustained as to certain counts only, or a certain count?
Right. And then what meaning we think that might have, and I have some thoughts on that I'll save if people think that we should do more than just pass it forward.
I mean, I'm in favor of that. I'm just trying in my mind to square it with the automatic removal if there's a finding of official misconduct. So maybe you can explain what you had in mind, and we can.
Well, give me a minute to think about it. Well, one is that I guess I'm. One strand is the automatic removal if the supervisors agreed with us. They first have to reach that or fail to act within 30 days. And then things happen. But there were members of the public who said, and I found this, it got me thinking in a variety of additional ways, when they said, it's unfortunate that this has come this far. Commissioner Hand said something similar. Why don't you see more situations like that here or elsewhere? Because people take action. They either resolve things with their supervisor, or they resign, or somebody works out something to protect the interest that's at stake. And we did not, I think correctly, didn't think that we had the ability to try to negotiate a solution, but the supervisors might feel that they could. If they could, I'm torn here. I'm balancing several different things, and I do think that there was, under these terms, official misconduct. But I think that the domestic violence issues raised here were serious, and the responsibilities of the sheriff for domestic violence are important. At the same time, so is the voters' decision to choose somebody for an office. The struggle is, they then said, once we vote, we have only this very extreme measure, the recall provision, to allow us to go back and say, we have new information since the election, and we want to do something different. They created another pathway for a particular kind of reason to recall that they wanted to have in place. And I'm just wondering whether it's worth reminding the supervisors, and maybe by just talking about it, we remind them that they may have alternatives if we think that they did, or if we think that one charge is different from the whole set of charging provisions here. So I am trying to work this through. I'm not positive.
I mean,
I don't have a fixed picture of what I would suggest.
Commissioner Hand?
Well, I would just say we need to send a written recommendation to the board. And then when they have their proceedings, my understanding is that the the Ethics Commission will have an opportunity to make a presentation, however short, and perhaps that's the time to refer to some of these other issues. Because otherwise, I agree with Mr. St. Croix. I mean, why? I don't think that we should complicate it further. I think we should make a simple recommendation. And from what you've said, the charter said if they all vote in agreement with a recommendation that the individual is guilty, then automatically that person is removed from office. Is that correct?
Yes.
That's how you read the charter.
It says, if after reviewing the complete record, the charges are sustained by not less than a 3/4 vote of all members of the Board of Supervisors, the suspended officer shall be removed from office. If not so sustained, then the suspended officer shall be reinstated.
I mean, that seems pretty straightforward, unlike some other parts of the charter.
When Commissioner Rennie raised this two-step inquiry idea, I liked it in part because I think one of the difficulties here is, in some ways, that the sheriff was the guinea pig. And if the charter provision was so difficult for us to parse, then in some ways it does seem, it gives me some pause for him to be removed based on a provision that we took quite a while and had a hard time deciding exactly what it meant. But Commissioner Han, I think you're right. I mean, based on what Mr. Embledge just read, I'm not sure we have any leeway to do anything other than sustain or not sustain the charges. I don't know, Commissioner Rennie, did you have any further thoughts on the matter?
Well, we could address the question of whether or not we think that the mayor exercised his discretion in filing the charges and in proceeding in an unreasonable manner. Now, whether that would assist the board at all, I don't know, because as Mr. Embledge has pointed out, it's either the charge of official misconduct is sustained by us on our recommendation, or it's not.
But if 4 of us are inclined to believe that there was official misconduct, doesn't that validate the mayor's action on at least that one provision, that there was a basis, that he had found the same result that 4 of us would also see that there was an official misconduct element? I've always thought, as you've been talking about the two-part, I've always thought that this was a going forward issue, that once the mayor put it in our jurisdiction, put this in our lap, that it didn't matter what or why he did it. For this process, that becomes the voters' issue, that we should be looking at the merits ab initio and looking forward at the consequences and not questioning how it got here. I thought Commissioner Herr was very, put it in a very crisp way the last time we talked about this part of it. But there is one piece that people aren't reading, by the way, just for the completeness and those who are not burdened with the 15 inches of documents. There are 2 elements. The Commission transmits the record to the Board of Supervisors with a recommendation as to whether the charges should be sustained. Mr. Embledge read this. After reviewing the complete record, the charges are sustained by not less than a 3/4 vote of all members of the Board of Supervisors. The suspended officer shall be removed from office. If not so sustained, or if not acted on by the Board of Supervisors within 30 days after the receipt of the record from the Ethics Commission, the suspended officer shall thereby be reinstated. So the board has somewhat more complicated options before them. They have to either vote by 3/4 or better to sustain the charges, in which case the officer is removed. But if they do not act at all for 30 days, the officer is reinstated. Did I say that right?
Yes, that's correct.
So there is a real crossroads for the supervisors.
Yeah, I'm not sure there's much we can say. I mean, I do think we should have a written opinion for the board, but I am inclined to vote to have a vote as to whether to sustain the charges and then send that recommendation to the board. Let's talk about this written summary. I think one proposal could be that Mr. Embledge draft a summary opinion, essentially, of the bases for the vote to sustain the charges. One option is for a member of the majority on the commission to draft that. I think, and then subsequently, we could either simply adopt it as a summary. There have been we have summarized the proceedings previously without having to vote on them and ratify them. Or if this document is more in the form of an opinion, then I think we would probably want to come back, have a look at it together in another special meeting, and then vote to adopt it. Do my fellow commissioners have views as to which of these potential options for a written summary or opinion would best suit the situation?
Would it be sufficient to just transmit the transcript of our discussion and our determination without anything else?
That could certainly be done. I think it makes the board's job harder because there's a lot more to read. But anybody else have, what do people think about Commissioner Rennie's proposal?
I suppose that's what I was envisioning, Commissioner Rennie's proposal, but as you said it, were you envisioning in terms of a written summary simply how we came out on the findings of fact and then the vote itself? Is that what you're envisioning as a summary, or?
Well, I think we'd want to explain to the board exactly how we interpreted the statute. I think if they receive this transcript, it's going to be difficult for them to determine really what the basis was. Obviously, we're deliberating in public, which is a highly unusual thing if you're adjudicating a matter, at least in my experience. But so I guess I worry that the nuance of the arguments that have been provided will be lost if we simply send them a 5,000-page transcript and 300 pages today.
So are you then envisioning perhaps the salient points we found from the findings of fact, the specific findings of fact, how we came out on that, and then what we decided on the two options?
I guess I'm envisioning either something very summary that says this is the fact that we found, these are the facts that we found support the charges. This is the law, how we interpreted the law. This is the application of the law to the facts. I think that's a possibility. Another possibility is more an order that we would see from a court that probably has more detail and would provide perhaps even I guess just more detail as to the bases for the decision. Do the parties have views on this?
While they think about it for just a second, I many people have talked about the passage of time and getting to the point where the supervisors can initiate their consideration, I think would be just for all concerned. Might want to also think about how that relates to the presentation by the commission to the board, which we will make. Is that the opportunity to make some of this clear? It may not substitute for a writing, but it could complement it. And do we have any way of knowing whether the supervisors would want to inquire of either the representative commissioner who takes that part or all of us at that point?
The risk of a representative, or even the entire commission, frankly, appearing in front of the board and having a substantive discussion with the board about our findings.
Oh,
pardon me?
I thought that was expected. Was that not agreed on yet? Or
Mr. Embledge, maybe you can explain the board's expectation.
At the Board of Supervisors had a meeting where they discussed the procedure that they intended to follow when the matter gets to them. It's my belief that they do expect to have a presentation of up to 10 minutes from the Ethics Commission, and I certainly had the sense from them that they were expected to ask questions of the representative from the Ethics Commission. The difficulty that I explained to them is if there is one commissioner there, for example, trying to explain the process and the reasoning that went into whatever recommendations you make, that person is put in a difficult position trying to put into words what was in the minds of his or her fellow commissioners. So I think it will be a bit of a delicate task, but I do think the board is expecting some presentation from the commission and some explanation of how the commission got from point A to point B.
And the reason a written document may be helpful is that the risk of the representative straying outside of what was actually decided is lessened if there's a written document that formalizes
it really
that.
narrows it.
Right, and then the representative could be talking more about the procedure that was followed, and could answer more procedural rather than substantive questions. Mr. Keith, Mr. Wagner, any thoughts on this?
Commissioners, I think that in light of the problems that Mr. Embledge has discussed in terms of the commission speaking as a body, I think the scope of the questions at the Board of Supervisors is likely to be restricted to things like basic procedural matters. Who showed up for cross-examination? What procedures did you follow? And I doubt that there would be much of substance. On the other hand, and this really supports just making a simple recommendation here, the board is mandated to review the complete record, which means they will be reviewing the transcript of this proceeding, and I think the commissioners have discussed the evidence in a way and discussed the charges in a way that they're going to be viewing anyway, and I think trying to reproduce that in another document and to have a special meeting for that would require a lot of effort that may not be needed. And so I think in the interest of just moving this along, we'd say, let's not have a separate sort of opinion. Let's treat this transcript of this hearing as the commission's discussion of the evidence. That would be the mayor's position.
Thank you, commissioners, and I appreciate the consideration you're giving these issues. I just want to make a couple of brief points on this issue. The charter already says, and that's been reviewed today, that there can be official misconduct that does not warrant removal. A felony crime of moral turpitude, which requires removal by the mayor, but then also for it to be permanent, has to go before the Ethics Commission, and then the Commission can determine whether or not that felony crime of moral turpitude rises to the level that warrants permanent removal or not. So we already know that the Charter contemplates the possibility of official misconduct that does not warrant permanent removal. So I would also like to return to...
How do you reconcile that with the provision that Mr. Embledge read?
This is how I reconcile it, because the Charter says, with all due respect, the Charter says that if you sustain the charges plural, then removal has to happen. Well, here, you've already determined, to go to Commissioner Studley's point earlier, it appears from my hearing of what your discussion that you're going to reject at least some, if not most, of the counts. So if you're rejecting some of the counts, then by the clear language of the charter, you're not going to sustain all of the charges. And therefore, if you're not going to sustain all of the charges, then you can't, there can't be a removal. By the clear language of the charter, the charges, it doesn't give you the option to pick one charge and not another one. So then, if you're not prepared to accept that very narrow reading of what the language is, then it seems to me that Commissioner Rennie's point that you can make, your recommendation can be as nuanced as you would like for it to be. You can recommend that 3 charges be sustained and 3 be rejected, that yes, those 3 charges are official misconduct, but it does not warrant removal. Or 1 warrants removal, but not the others. Or none of them warrant removal, but yes, one of them may be official misconduct or wrongful conduct. In other words, I would respectfully submit that your recommendation can be as nuanced as your discussion has been. And you spent several hours discussing what this provision means. And as I argued earlier, that very ambiguity should be read in the light most favorable to the sheriff. And so in that regard, I believe giving the Board of Supervisors more options, not less, is consistent with due process, consistent with respecting the intent of the charter provisions, and also with your discussion. Reading the charter in the most narrow way, that you either have to say yes, up or down, and if it's yes, then it's removal, period. That's not consistent with the rest of the charter provision that clearly says there can be official misconduct that doesn't warrant removal.
What is your position on the written document?
I think there again, I appeared before the Board of Supervisors. We were notified by the clerk of the board a couple of weeks ago that they were going to be discussing their procedure, that they already had a draft procedure in place, presumably that Mr. Imbledge drafted, that we got very short notice of and had all of 3 minutes to address before the board during their public comment period. So there was already a draft procedure, and we objected, actually, at the time. I objected.
Okay, my question is, what is your position on whether we should create a written document summarizing our findings, or whether we should just transmit the record as is with all our views on the transcript? I mean, obviously, we're going to do that, too, but what is your view on whether we need a written summary of our findings?
I think the more information that the board has to help them make a decision, the better. So that a written summary is certainly going to be more helpful to the board than have them pour through 15-plus pages or inches of documents. Knowing your rationale and having that very clearly stated in a written document, I think the board would very much appreciate, and we would respectfully request that as well.
Okay, thank you. Commissioners, views on the written document?
Well, you made what you said was sort of a draft or poll of the board, the commission, and 4 of us seemed to agree that there was a violation of the official misconduct statute. But going to the charging document, I am looking at it and wondering which one of the charges is, or which one of the charges are we saying we're sustaining? Because the way they drafted this, they sort of incorporated all the paragraphs, some of which included the impeding witnesses, things of that nature, which we have found, there wasn't sufficient evidence, so that it seems to me that we've got to have, in fairness to the sheriff and in fairness to the board, we have to have some clear statement of the charge that we say we are sustaining. And I going through the charges 1 through 6, and there are a number of them. Certainly counts 2 and 3. We have said we didn't think there was sufficient evidence. And the others are, as I say, they've sort of commingled a lot of their factual statements, many of which we've rejected. Whereas I was suggesting that I believe that the conviction and the circumstances that led up to it is what is the official misconduct.
So is that more count 4?
Well, count 1, which they call domestic violence, it looks like. Count 4, except for the fact they incorporate 1 through 46 paragraphs, which has a lot of statements about which we have said there was not sufficient foundation.
But when we sustain a count, we're not sustaining, I mean, we're just making a finding that each of the elements
What's a charge? We were recommending the charges be sustained. Well, the counts are their charges, aren't they?
Right. So, but I mean, just because a complaint incorporates by reference every paragraph, that doesn't mean sort of the decision on the charge has to incorporate every paragraph. I mean, you and I are used to jury instructions that tell us exactly what the elements are and can identify those clearly. But you raise a good point. I mean, even in count 1, I'm not sure that we found that, I'm not sure we're inclined to find that he engaged in domestic violence. I mean, obviously we agree he committed an act of violence. I don't actually have in front of me the elements of domestic violence, but I mean there certainly are portions of this where we may, even the 4 who agree that there's official misconduct may not agree with every allegation in these. In count 1, at least. So what are you suggesting, Mr. Rennie?
Well, I guess what I'm suggesting is that the written document, if we prepare one, should be a clear articulation of what the charges were that we found sustained the mayor's action in suspending. And
in your view, what is that? What having heard what your fellow commissioners have said, what should that document say? Which of these were sustained, or is there sufficient evidence to sustain? 1 and 4? Is that parts of 1 and 4?
Yes.
Anything else?
I'm pausing on 1. 4 is a clear factual statement, but committing domestic violence against his wife imports a very complicated area of expert analysis, and I wonder if it complicates things to add that, or whether it is what we really mean. We're just staring at it over here. I'm not saying that it might not be. I'm just not sure that that I'm in a position to say that that happened, whereas number 4,
Right.
I can.
And I don't think the commission has to find domestic violence per se for it to be official misconduct. I mean, in light of the rationale that's been provided. So it may not be essential to the recommendation in any event.
Right. Which is not to say that it doesn't exist or that it's not very real.
Right.
But it may be cleaner and more useful for us to opine on what we know. And to the extent that it is within, that those things happened within that context, that's beyond my ability to be certain about.
So perhaps it's also count 5 instead of count 1, because count 5 captures the discussion we had about prong 2, which is conduct that falls below the standard of decency required of a sheriff and the sheriff-elect.
I guess except for the reference to paragraphs 19 to 31.
Correct.
Yeah, that.
So are we saying in a sense that count 4 is the basis for count 5? The wrongful behavior consisting of that crime or that crime and the facts related just to that are what we determine falls below the standard. Is that what you're saying?
Yes, thank you.
What this discussion has suggested to me is that I think something in writing
down.
is going to be
Yeah.
helpful to the board. I mean, if we're, Commissioner Sedley, was there something else?
No.
So I think the question is what form that should take. I think something that is as simple as here are the facts that we found could constitute official misconduct. Here's the law we applied. Here's our application of that law to these facts. Here are the charges that we think should be sustained in light of our findings, and why, I think, is sufficient. I mean, I am kind of, again, thinking out loud that however this document comes out, I am wondering whether we will need a special meeting for the commission to adopt it. We have devoted a lot of time to this, and I know this means more time, but given its complexity, it seems hard to see us tying it up without an approved written document. Now, I don't think this is going to cause actually that much delay because the record has to be prepared. The board is in recess currently anyway. So perhaps we can schedule something in early September to adopt whatever findings and then send that with the rest of the package to the board. Commissioner Sedley.
I don't know if this is where you want it, but I'm out of the country from September 4th to 14th, or 2nd to 14th, 16th. We had a meeting date on the 27th. I don't know if it's too late to notice for that, if that was a window we could do this.
Mr. St. Croix, do you have thoughts on this?
We could still use that meeting date on the 27th if you wanted to.
August 27th?
Yeah.
Yeah, I'm going to be out of the country on business.
All
The
right, we'll
next
have to
2
look
weeks.
for another one. I would recommend that you make a finding tonight as a basis for the document to be prepared. But we're going to have to work out a follow-up time. The alternative is you can just empower the Mr. Embledge to do the drafting on behalf of the commission and trust that he will put together a correct document. It's up to the commissioners if you want to have a final approval or not.
Commissioner Studley, please.
I was just going to ask if we could delegate this to the chair and Mr. Embledge.
Certainly.
It's a lot to ask somebody to do without a commission reviewer. And I don't need to be here if we've taken a vote now. I'm happy. I don't mind missing the resolution of the document if that's not necessary.
And by the same token, I don't need to be here either. So, Commissioner or Mr. Embledge.
2 points. One is if you're going to delegate some drafting to me, I'm going to need the transcript. So there's going to be some time before that can be prepared. And then in my other life as running a law firm, I've got depositions Monday, Tuesday, Wednesday, and Friday of next week. So I don't think I'm going to have too much time for drafting next week.
Okay.
Well,
Commissioner Han.
Well, as has been said, I think tonight we need to vote on our findings so that the ball can get rolling, since the Board of Supervisors has to get the entire transcript and all of the records anyway. And then they can schedule their hearing whenever that's going to be. And then you already have, I would imagine, an idea of what this document should look like in outline form. Am I right?
Other than what I've spoken,
you've said some things
I don't have
tonight
anything.
that I think kind of outline what it might consist of. And you could give Mr. Embledge some guidelines on that. And when you have the opportunity to begin drafting it, then you can proceed, if that makes sense to you. And then we, as a commission, can approve that document without delaying any proceedings at whatever meeting is set up for us to do so.
I have no objection to that. Okay. Well, we can schedule it. We don't have to schedule it right now, but I do think we should prepare some sort of summary document. I will work with Mr. Embledge to put it together for approval by the commission at large. Is there any objection to that procedure from the parties?
No.
Okay. Okay, so I think unless there's anything else, are we prepared to make the motion for a recommendation to the board? Is there a motion to sustain the charges relating to the physical abuse for the reasons that we discussed here today? Secondly, to adopt all of the interim rulings that have been made throughout these proceedings. And finally, to authorize the preparation of a summary document of the findings made by the commission to be subsequently ratified by the commission as a whole.
So move.
Second.
All in favor?
Aye.
I oppose the first portion, but agree with the second and third portions. Okay, the motion is adopted. Anything else from the parties?
So, Commissioner, when is the next meeting going to be held?
We need to figure it out. We'll be in touch with you.
are you rejecting all of the counts, but then creating a new count of official misconduct? I'm a little unclear as to exactly what action the commission is taking.
Yeah. You know, that's good. I wonder if that question suggests that our motion should be in terms of count 4 or 4 and 5, so that what we adopt tracks something that was going forward.
I mean, the problem with that is that 4 and 5 contain, as Mr. Rennie suggested, allegations that we did not.
Allegations in the paragraphs?
In the paragraphs. And which
so
are
maybe if we
incorporated by
narrow
reference.
it to point 49 or sentence 49 and read that and see if that's what we mean, and revise 54 so that it tracks the formal basis that we had.
Mm-hmm. I think the motion was clear enough. I mean, the whole purpose of the written document is to summarize what the findings are. We clearly made a finding of official misconduct based on the physical violence that occurred. I think that suggests we also rejected a number of findings, and I suppose we could make it more specific if the commissioners would like to, but
I'm just wondering, before
Fair
Mr. Wagner has to say it, whether there could be some criticism that the crime of falsely imprisoning is different from physical violence. And while they might have something in common, that we would be vulnerable to not having acted on one of the charges that was brought before us.
Okay.
Not a criminal lawyer, but
we can remake the motion. Would you like to remake the motion, Commissioner Studley?
do you want to make it?
I'm not sure what the amendment that you were suggesting.
That we, well, tell me if this is, what I'm thinking is that when we said sustain the charge, Ray, physical abuse, by adopting point 49 and 54 subject to specific references within the paragraphs, that we adopt the substantive content of those two as the charges that we are defining as official misconduct.
I guess
maybe we're doing something different, but this may help us tell what we're doing.
And I obviously did not vote with the majority on this, but I mean, if I were in the majority, and I would be concerned that might be too narrow given the breadth of the discussion that ensued. And I mean, the charter only says that we have to make a recommendation as to whether official misconduct should be sustained or not. And I'm wondering whether you're going to be limiting the authority of the drafting if we limit it so specifically to two specific paragraphs in the charges.
I think it really depends on what part the allegations played in. I never quite understood why we had an amended charges and particulars in the first place. Why it wasn't just we figure out what troubled us and what we thought was official misconduct. So I really defer to the council and Mr. Embledge. If we have to stand on those counts, then I think we should stand firmly on the ones that we're adopting. Otherwise, does it look like these were the counts and we did something else, and if they don't converge sufficiently, our process will be unhelpful to the supervisors?
Mr. Embledge.
What I'm hearing from the commission is that you have voted 4-1 to sustain the charges of official misconduct based on the sheriff's conduct on December 31st and his subsequent conviction as reflected in counts 4 and counts 5 of the charging document. If I'm correct, you might want to amend your motion to incorporate that language so that it's clear that you are sustaining it both on the the actions that occurred, the conviction that resulted from those actions, and that you believe that those are related to counts 4 and counts 5.
Any objection to that? Okay. Someone like to make the motion?
I move that we adopt Mr. Embledge's recommendation for charges.
Second, unless you'd like us
Okay,
to restate
well,
it.
I think we also need to add the adoption of the interim rulings and the empowering of the written summary. So, maybe I'll take a shot to just tie it all together. Is there a motion to sustain the charges as to the conduct that occurred on December 31st, 2011, and the subsequent conviction as reflected in counts 4 and 5 of the amended charges of official misconduct? Second, to adopt the interim rulings of the commission made throughout the course of these proceedings. And third, to empower a written summary to be subsequently reviewed and ratified by the commission.
So moved.
Second.
All in favor?
Aye.
Opposed? I oppose as to the first part, but agree as to the second and third parts. Okay, any other objections or concerns from the parties?
I would only add that I don't think the charter authorizes the commission to create new language of official misconduct. What the language that you just adopted at a 4-to-1 vote says, we sustain official misconduct for the incident on December 31st as reflected in 4 and 5. It does not say we sustain 4 and 5. The charter says you either sustain the mayor's charges or not. It does not authorize the commission to draft new language or new charges that are reflected in other charges. So I would just state that for the record. Thank you.
I think it was clear enough. Any dissenting view?
No, the motion was, I think, clear enough to say that we were adopting the heart of counts 4 and 5.
Okay. Thank you very much. With that, the meeting is adjourned.